Courtroom buzz lights up the air. Faces tense as stories tear. Truth and lies like a tangled dance. Justice here takes no chance. Gavel strikes, hearts beat fast. Witness takes stand, shadows cast. Whispers loud like wildfire spread. In this game, none's ahead. International eyes on the scene. Lines of right, blurred and lean. Arrested dreams, shattered glass. In this court, who holds the past?
Hello, good morning. Just need to do a small test. Give me 1 second. Yeah, yep, everything is working because Nightbot was lovely. Hello. Sorry, we came on early because court started their feed earlier because absolutely took me out of the way. I was here just chilling, prepping myself to go live, and then all of a sudden I get a notification from court, from the feed saying we are live now. So good morning, Denise. I hope you are okay and everyone is okay. Um, today could be the final day. In this case, I am expecting. I was listening to loyally earlier today, right, to catch up on her live stream from yesterday, and today she doesn't believe today we're gonna have closings, but I do. It is gonna be an off day because defense is supposed to rest after the jury instructions that they're gonna go through for the first hour. They are gonna go. The defense is supposed to rest, and then I think state has a rebuttal case that might last about an hour. I think tops 2 hours, so that will take us to lunchtime. Either the court is going to come back in the afternoon and they're going to do closings, or the judge is going to call half a day, go home for the afternoon, and then tomorrow morning do the closings and then verdict watch afterwards. Which probably, considering the way that this court has gone and has been with never really actually going further out, um so I believe that you know, I it is unbelievable that they're not gonna. I want to be positive, and I want to be like, yes, today we're gonna finish this case. We're gonna move on. Let's crack on because she's gonna be found not guilty, hung jury. I'm still on the fence, but I'm sick of her. I'm sick of her smiles, and I want to move on. I had enough of Natalie, and our new trial might start today, and I want to move on. I just Natalie being in the past, just forget about her and moving on. But apparently, I think we are gonna go to tomorrow too. I don't believe that closings. I want closings to be. It's the same thing of I believe she's guilty, but I think she's gonna be found not guilty or hung. It is the same opinion about the closings. I hoping that the closings are today, but I don't believe it is gonna be tomorrow. Uh, but and that's my opinion. I mean, what do you guys think? Let me know in the comments. I know Denise already posted that she doesn't think as well that is not gonna be closings today. Good morning, Susan. Welcome in, welcome in. I was supposed to tag that one, and but I'm always wrong, as always. Again, I'm always wrong. So prove me wrong, court, and let the closings be today. Um, so I was doing some investigation, right, on the internet, on YouTube, and on YouTube. That's not where you do research. Neither is Twitter, but anyway, and I found some information because apparently I think I missed that yesterday. Actually, someone tweeted that. Oh, hello, Nightbots. Welcome in. Good morning to you. Long time no see. Nice to see you here today. So someone tweeted that apparently when Natalie went to the doctor, right, the day before she and alive or Michael passed away, that she went to the doctor and she got benzodiazepine medication with that, but Michael was allergic to that, and he was found in his system that he had that in the autopsy. Which one autopsies? I don't know. Don't quote me that. That was found that he had benzo. How does he call it? Benzodiazepine. Sorry, I have to read it from the paper because otherwise, um, the otherwise I cannot say it. He had that. So my thinking after reading this tweet, right, was it possible that Natalie gave Michael that medication that she has just gotten from the doctors to him, and he had an allergic reaction, and that's why he collapsed, and then on the way to the hospital she finished him off? Could have been, because allergic reaction you have almost straight away, and it's not like the insulin that they were saying that takes 5 to 10 minutes, or 5 to 15 minutes or to react. So she could have given the benzodiazepine mixed with his tablets that he took every single day, with the million and one that he took, had the allergic reaction, and then she finished him off in the car on the way to the hospital to make the blood sugars go crazy. What do you think? I think that's my opinion, and that's my theory, my new theory. Because every day that we come in, I have a new theory about a case. So it's always changing, and I'm always thinking. Just before we do, make sure that you like the button. It does help the channel a lot, to get out there on those YouTube streets and people finding us. Even though I do like the small little community, but we can always grow and get better and have more people in. But carry on. So that's my new theory of the day. I think we're going to call it Katya's new theory of the day. So th- today is actually also I have a hearing in about an hour and a half. I want to say it's going to be a half 10 Eastern. It's about, and then the case that my follow in this channel, I still have to check because the time difference is crazy. It's out of in Idaho. No, it is not Brian Kohlberger. I have already said that. So probably we're not going to follow that case here because of the length, because of the time difference. But this is another case that me and Denise, one of our lovely people here, as we've been going to all her hearings online. Well, me online, and she sometimes does go into court herself. But because I'm not in Idaho, I can't go in person. I wish. But we might follow that case here. We'll see how it goes. No, I think I can see your point, Denise, but she in the car there were the best friend in his testimony only said that it was him, her, and Michael in the car. There was no one else, and she was in a back seat of the car while he was driving the car. So that is a little bit, well, it's not a little bit suspicious. It's just a working theory. Do I think that that's what happened? Yes. Does the state think that? Probably yes too, but will the jury? Probably not. So I think, and I also think that this is going to be a rather quick deliberation. I think it's going to be about 10 minutes. No, not 10 minutes, and not 10 hours, please. Not 10 hours of verdict watch, please. I cannot handle that. I think it's gonna be about 5 hours, pushing on 6 hours. But and actually talking about that, I need to try to pre-set up our clock for the verdict watch, because everything happens so quick all the time that I never have time to set up things properly. So I need to just to preempt the that the fact that we're going to be on verdict watch. I don't think we are gonna be on. So but we'll see. Courts, fantastic things happened, and it always amazed me. Do we know what they're gonna eat today in terms um of sandwiches or biscuits or anything? No, I don't know. And that's what I was saying, Nightbot. I think I believe I heard throughout the trial was only the best friend driving, and then her in the back with Michael. So she had the opportunity to do whatever she wanted to, really, in a way. I mean, she had the possibilities. So there is actually a lot going on today in the world of true crime. I mean, there's this trial happening. There is two trials out of California. There is jury selection in our new trial. My days, there is so much going on that it's like my phone is bipping out of control, with all the information, especially from X, because when you start following people and get on notifications and everything, and it is crazy. So yesterday, in terms of a mini recap, there was a bombshell at the end of the day, if you haven't seen it, that Natalie, she was going to testify. She did say in the beginning, and even especially last week on Thursday when the court abruptly ended, she said she was gonna testify. But then I think Friday, Saturday, and Sunday came along, and she had time to reflect and think about her actions and then her decision. She decided not to. So she has completely changed her mind. Did the 360, 180, sorry, 360. Go back to the same place that you were, me and mouth, 180, and change her decision in terms of not to testify anymore. So she thinks that the case that her attorneys have put on was enough to create reasonable doubt. Do I agree with that? Sadly, I have to. Sadly, I have to agree with that, because there's a lot. Even though the state, they did say it was a circumstantial evidence, it created doubt, and there is, I don't think, a concrete proof of that. So I think we're not gonna see her walk free, because she's still gonna have to go to federal prison for the next few years. But I think it is either that, or the judge was talking as well, because there is also a possibility she is charged on the lesser included in the indictment. On the jury's instructions today, and then tomorrow, hopefully, when the judge reads the jury instructions to the jury, we will know what charges she's facing. Because so far we know that, I think that it's the unaliving charge that she's facing. I don't know if it is first, second degree of the unaliving. I think it's first, because the first one in West Virginia, you do have a life sentence, and that's what she's facing if she's get charged on that. So, but we'll see as well what lesser included is, if there is even a lesser. But the judge yesterday sounded like it there is a lesser charge included, negligent homicide. And after some research and throughout the West Virginia legislation and everything and information this morning, she's facing, if she does get found guilty on that lesser, it is going to be 1 to 5 years in prison, and that would have to be served after her federal prison. So she spends the 11 and a half or 10 and a half years in federal prison, and then goes to the normal state prison to serve the unaliving charge. So it's not concurrent, it's consecutive, if I have my English correct. So, oh, bear with me 1 second. Sorry, I have a bit of a runny nose. So that is going to be interesting. I want to know what is the lesser, and then obviously I'll do some research in terms to see what is the actually that she's facing in terms of prison. There's still no movement out of court. Still have, yeah, just checking that I was actually playing and not just doing there. Good morning, Lewis. Good morning, all. Sorry, and my apologies. I did go live a little bit early, but because court decided to go early too, so it's not actually my fault. It was the court's fault. So we all blame court. They are not on time. They still not on the record. So no. I am early. When am I not early? I'm always early. No, the thing is, I'm early because I'm always like seated here, ready to stream. But I was early because of court. Court is the one to blame, not me, and I don't speak English. So yes, they are not starting until 10 a.m. with the jury. They are doing at 9 a.m. The jury instructions. So they are starting the doing the jury instructions conversation between the lawyers. We don't know if that is going to be able to live stream. That's why we are waiting. If not, we're going to be talking about other things, and we might be able to even watch something else while court hasn't started. So that's why we are live and a normal time, because we'll see if we are privy to watch jury instructions conversation and see what happens. If not, don't worry, I've got plans. I can show you the timeline that I've made for our new case that we are following. Well, I'm hoping to following, because not 100% sure if still has a live stream on YouTube. I know that Law and Crime has demonstrated an interest, Court TV as well, and then other like small news stations in the local area have demonstrated an interest, but there's nothing in the docket that shows that. But they're still in jury instructions anyway, so there's not that big of a deal in terms of we're not losing anything. But if not, well, I'm sure we'll find another trial. There is plenty out there, unless we be permanently catching up on one of the trials that is going on in California. We'll see what happens. And I mean, we still have to finish this one, and but I'm sure hopefully the one in Florida it will be okay, and we're gonna be following that shortly. So it's just gonna, sorry, notifications keep me distracted. I get distracted so easily, and especially having everything on the computer, I was just like click, there's a notification. So and that's the thing that I wanted as well. So Natalie, right, she says she had cancer because there was messages that she told the neighbor, right, and I just remember this, that she told the neighbor that she couldn't do a certain thing, or because she was tired from the radiation, or from the, was it the chemotherapy and everything. So she was telling people she actually had cancer when she didn't, and that it was still in the investigation phase. So that it's literally a lot. Well, it's literally a lie, because it's been what, 5 years, 6 years almost since this whole situation occurred, and she's still very wealthy and very thing. And the thing is, being in prison doesn't treat you well. Even though it's federal prison, it doesn't treat you well. So that is one of the things that was a big win yesterday, I believe, in my humble opinion, for the prosecution. The fact that they literally got in that Natalie was lying about the fact that she had cancer, she had leukemia, and it's official. Court is late, so no 24-hour live stream yet. So we'll keep live coming and see if I am gonna have to do a live streaming or not, if the court is on time anytime. But so far, there's no luck. So that was interesting that I was thinking about yesterday. Another thing that I was thinking, I think too much, and I think it should be always a note that I'm still trying to read Nightbot's handwriting, and I can't. I think I need to invite him on stream to read that today, because I can't read it. I give up. I tried when he was working. He actually went to work today. No, I'm joking. He's a very hard working guy, and it did had to go to work this morning, and I tried to read that and I couldn't. So that I think we're gonna have to tell him to come back to stream and tell us his side of the events. Also, by the way, you might see a bit of a different background tomorrow, because yet again I'm moving. Because the thing is, we, like I've said before, me and Nightbot, we're trying to simplify our life and like get rid of things and everything. So we have decided to get rid of a big sofa that we have, which will enable me to move to where the background is just the simple green that you see behind me. I don't know which side, that side, that side, that side, that side, there, the right behind me. So that is going to be our new background. I'm actually going to be by that window over there. Hopefully we're going to be able to do that in the morning, and I'm going to be able to set up everything in the computer tomorrow, because it's gonna be easier. We probably can do like a fake background or something from the picture that I took yesterday in the UK court. I think I'm gonna make that my background, so it's a bit different, and it's not just yeah. And I can blend in today with that will remind me I cannot wear the hoodie anymore from tomorrow if I do that, because otherwise I'm gonna blend in with the court, and you're only gonna see my head float around, and that would be hilarious, and we don't want that. So that is the plan. A new back, well, not new background, but a different kind of setup. And then, like, the thing is, where I am right now, it's like literally at the end of the stairs. So what you see, this is the stairs to go upstairs. So every time Nightbot needs to go upstairs, that's why I have to turn off my camera so I can move, so he can pass by, and then turn on. And I don't really like that. I don't like be always turning on and off the camera. I don't like to affect the stream or anything that can affect. So I'm always like saying him to wait or taking a little break. That's like to be able for him to be able to go down and up and everything, and I'm always in a way, and he has to be in a very awkward place to get out of his chair. So by me being there, I'll be kind of out of the way, but I'll still be in a good probably lighting with the thing. The only thing I'm worried is the noise from the street, which hope it is not going to be too bad. Otherwise, I'm just gonna move the microphone to the other side. But we'll sort it out. We'll figure it out. That's my own problem to resolve, and figure it out. But yeah, so that's the update in terms of our stream, and they are 5 minutes late. Well, there's nothing new. I don't know if they are gonna be on the well, they're gonna be on the record, but I don't know if that is going to be streamed. I don't know. I'm not 100% sure that it is going to happen. We just wait. I I wanted to show you the thing, the timeline, but the thing is I don't want to miss anything from court. So what I'm going to do is I'm going to stop sharing the screen from court, and I'm going to share the timeline while we wait, because I don't know how long we're going to be or not. So I need to share the screen again, the window, and go to this one. So you can find actually a link to this timeline in my link tree. I will put link on here on chat. 1 second. If I knew how to spell tree. Uh, so this is the timeline. I'll zoom in a little bit more. Just try to. There you go. So we can see that. Oh, my days. Using Manx. So we can see that everything started in February 2023 when Colin unalived his dad in self-defense. I put self-defense because I still don't believe that it was self-defense. So I'm just doing that. And then when the charges get dropped, and then when he moves to mom, and then later on in the year, it was in the beginning of September that he had the Baker Act was raised against him, and then a few months later, in November of 23, he had the first DV incident with a mom, and then there was another fact that so he was supposed to be with the mom in February, but he was fighting and ran away to the grandma's house, and then he was reunited later in that month with the mother, and then he actually calmed down a bit apparently throughout a few months between that incident and the next incident that we have in September, the actually unaliving. Then he actually graduated from the alternate high school, so that, and then everything that has happened to the with the and death of the mom. So on the 6th of September 2024, he had a big fight with the mom because of the chores and everything, and then he refused to go back with her mom and face the responsibilities because his mom wanted help. uh Yeah, I can pass you the notes. Nightbots, 1 second. Uh, I'll give you the whole thing. There you go. Yes, Nightbot is just behind me. And then so he refused to go back home with the mom, and then that was when he was seen on that day, on the 8th, right, dragging in the mother inside of the house by a neighbor. So a neighbor actually reported that, and then after 2 hours after the incident, Colin called 911 to report about whatever happened with Amanda. So that is the timeline I did. Oh, court is in section.
Number is 23-F-343K. All parties are present, including the defendant, although we are missing Ms. Acord. Is she going to join us?
She will be joining us. She is at the office, but she's working on some stuff and she'll be here.
All right, thank you.
But I have her permission to go over the court's instructions on behalf of the prosecutor's office.
All right, thank you. I do have the individual submissions from the state and from the defense. I've prepared a continuous charge to the jury that incorporates all of the submissions, both from the state and the defense, and sets it forth in the court's traditional charge. I suggest that maybe we could go through that page by page. Again, I've mixed up your offerings a little bit, but all of them should be included in the mix. So you have a copy there of the proposed court charge.
Yes, sir.
All right, let's go through it page by page and raise any concerns that you have. Is there any problem with page 1?
Nothing to say, Your Honor. Thank you.
No, Your Honor.
All right, page 2,
Nothing from the state.
No, Your Honor.
page 3,
Nothing from the state.
No, Your Honor.
page 4,
Also nothing from the state.
No, Your Honor.
page 5,
Nothing from the state.
No, Your Honor.
page 6,
Nothing from the state.
page 7, and you'll note that I put in the squib about expert testimony.
Yeah, and in the paragraph after that, Your Honor, there's some gender change that needs to be made, I believe.
Okay,
Well,
Your Honor,
yes.
I believe Mr. Victor has a comment or objection.
all right, let me handle this. There is no paragraph on the defendant's testimony or lack thereof, Your Honor. It has to be.
Well, I do. I think
It's
I have
in
that, but it's towards the last. I can move it.
Okay,
And I'll find it.
well, I'm probably looking.
I believe I did see that, Your Honor, but I can't locate it right offhand.
Well, everything gets lost. You know where it is, Colleen? Oh, it's page 12. And it's the second paragraph that starts with, as a defendant is presumed innocent of the charges brought against her.
And we'll get to that.
Okay.
Okay.
All right, let's go back to page 7 and see if there are any issues or objections to any of the material on page 7.
Your Honor, the last paragraph. May I remain seated so I can?
Certainly, yes.
I believe that the offense charged in the indictment is murder in the first degree. The jury may return, I believe, 3 verdicts here rather than 2, because they can return the verdict of murder in the first degree, guilty of involuntary manslaughter, or not guilty.
Okay, we need to think about how to word this because the jury will be confused. We've never raise the issue of involuntary manslaughter with them, and to just pop this on them may cause some confusion. Any suggestions, Mr. Truman?
The state does concur that the language of the first paragraph of number 7 should likely be changed. And it may be just as.
Could we put one of the offenses charged in the indictment as murder of the first degree?
Yeah, that would work.
How's that, Mr. Victor?
But what is charged in the indictment is really murder.
Well, that's true.
Your Honor, may I suggest?
Yeah.
As number 3, or the lesser included offense of involuntary manslaughter.
See, the way that we have it is actually correct, because it says the offense charged in the indictment in this case is murder of the first degree. That's right. You may return one of 2 verdicts under the indictment.
Okay, all right, I stand corrected.
So we're okay with it.
Right, but there has to be nevertheless recognition of.
Yeah, and it's right after that on page 8.
All right.
No, I'm sorry, not 8. Page 10.
And Your Honor, I'm sure Mr. Victor will volunteer some information. At the bottom of page 10, you say, you're talking about a distinguishing feature between voluntary and involuntary manslaughter. Voluntary manslaughter is not a consideration.
Right. I think we need to remove that. That somebody submitted that, and I guess it was either you or Mr. Victor.
No, I don't think we're there yet, Judge. I'm looking at page 8, and page 8 starts with murder of the first degree. And by the way, I don't know, this is a very, very minor thing, but I think we should be consistent with capitalizing certain things.
Okay. I think that's a big deal.
That's just,
Okay.
suggestion. But before, murder in the first degree is any felonious, willful, malicious, deliberate, unlawful. It has to be unpremeditated. The premeditation is the most important factor of the murder in the first degree. So it has to be there.
Okay.
And I don't know if we need to put the West Virginia Code section there for the jury.
All right, I'll remove that.
And then, of course, in that instruction, in the paragraph starting with before the defendant can be convicted of murder in the first degree, paragraph 4, feloniously, willfully, maliciously, deliberately, unlawfully, and premeditatedly.
Okay.
And then I believe, Your Honor, that at the end of page 8, we probably need to go and describe what is now on page 10, and that is murder of the first degree consists of an intentional, deliberate, and premeditated killing. And that definition is the definition of premeditation. Because otherwise we're going straight to malice, and we're discussing malice, and then we're going back to murder in the first degree.
Okay. So we just need to move that before we discuss malice.
I would so ask. Then, and I think that in that paragraph on page 10, describing premeditation, in the third line, well, it starts with the duration of that period. I would say that this is the this should read the duration of premeditation or of the period of premeditation cannot be arbitrarily fixed, and that's under Guthrie.
Okay. Any problems, Mr. Truman?
No.
Now, this is what I have. The duration of that period of premeditation cannot be arbitrarily fixed.
Yes, Your Honor.
Then I'm going to move this entire paragraph to the top of page 9 before malice.
Yes, Your Honor. Now, and then, since we're describing the offenses which the jury can consider, I would also move involuntary manslaughter definition prior to the definition of malice, because we've already talked about the definition of the first-degree murder. So now I think the next logical thing is to discuss involuntary manslaughter and then discuss the definitions of malice and just about it.
Okay, where do you want to move that to now, Mr. Victor?
Before the top of page 9, before malice.
Okay,
Involuntary manslaughter is committed when a person caused the unintentional death of another person. Now, in that paragraph, I think we have to modify this paragraph because, as Mr. Selden astutely noticed, this paragraph deals also with voluntary manslaughter, and we don't have any voluntary manslaughter anywhere. So I would propose the court instructs the jury that the absence of an intention to kill or to commit any unlawful act which might reasonably produce death or great bodily harm is either the main characteristic or the main feature of involuntary manslaughter.
okay, if you can write that down, you talk a lot faster than I can.
Oh, I'm
write.
sorry, Your Honor.
That's okay.
I'm sorry.
I mean, I'll work it out the way you want it, but you'll need to write it down.
I think that the, okay, I have it.
Matthew.
The main component, okay.
Involuntary manslaughter. Take out distinguishing feature between.
Okay, main components. And then, Your Honor, we're arriving at the definition of malice. I've been doing some research on malice, and in the first paragraph on malice that is right now on page 9, the last full sentence, malice and intent can also be inferred from the defendant's intentional use of a deadly weapon under circumstances which doesn't give rise to legal excuse. I believe this may have been this may be one of those instructions that shifts the burden of proof to the defendant. Although I believe that there's the State versus Jenkins case, and it's probably all right, but I
think this is a pattern instruction.
yeah.
I've seen it many times. I don't know where Mr. Truman dug it up, but maybe right out of a form book.
I think
It's just one of those stock instructions that the state keeps, and it's been offered as long as I can remember.
and that's
If
why
it needs to be changed, then let's hear what
We
the
can
basis
we
of
can
the
change it.
I think inference is all right, but then in the next sentence, implied, and once the jury starts
Okay.
making something
In the next
that's an
sentence where it
implication.
says it may be inferred or implied, what if we get rid of or implied?
Yes.
That's in there twice. So in the next
Okay.
sentence, get rid of it.
I see it up in the first paragraph too. Can we change implied to inferred?
Yes, Your
Okay.
Now, when we talk about involuntary manslaughter, I think that a full definition of involuntary manslaughter should be probably given, and that is, I will read it, and maybe I'll read it quickly, and then we'll try to parse it. A person is guilty of involuntary manslaughter when a result of the doing of an unlawful act in a reckless or grossly negligent manner, or the doing of a lawful act in a reckless or grossly negligent manner, he causes the death of another person.
Okay.
Was that in an instruction the defense
That wasn't
submitted?
an
No,
instruction.
that's
Oh, you're adding this.
right. I think that would be the appropriate definition of involuntary manslaughter.
Well, do we have that in writing? Can you submit
I
that?
can write it in here and present it to you.
Okay. Does that sound all right with you, Mr. Truman?
Yeah, I'd like to see what it
Okay,
what it
let's
says
write.
before I comment. on
Normally,
it.
there are written submissions that the court considers. Okay, we're okay with the elements of involuntary manslaughter.
Yes, Your Honor. I'll write it down and submit it
Okay.
to Mr. Truman. Now, let's see.
Sorry, I have to pause a little bit. I thank you. Oh my days, I am literally crying. Thank you so much for the support. You guys. I'm sorry. Thank you. Thank you. Muchas gracias. Thank you. I appreciate so much everything that everyone has been done for the channel, and thank you.
It's really not an element of first degree murder.
That's
I mean, it doesn't necessarily hurt anything, but
You're talking about paragraph 2 on
yeah,
page
a
10.
person acts knowingly.
You want to remove it in its entirety.
I'm just raising the issue because it's not an element. I think it's been offered in every case since why it was decided. But it's there. I thought I'd raise the issue.
That's fine.
Can we just omit it?
We can remove it, sure.
Okay.
Now, on page 12, the first paragraph, that instruction is always questionable to me because this one, I believe, shifts the burden of proof to the defense. That you may.
Okay, I don't know that we need it. If we take this out, Mr. Truman, will it be a strong objection?
Vociferous, okay, go ahead and take it out.
Okay, I'm going to remove it.
Although we do not accept the argument that it's just the burden. I don't think it does.
Well, I've put it in virtually every
I know.
charge that I've given, but I don't know that we absolutely
That's
need it.
fine.
Okay.
And since I stand corrected about the defendant testifying or not testifying instruction, which is on page 12, I always insisted on the word must, and that is 1, 2, 3, 4, 5, 6. Seventh line in the first, well, in the paragraph that starts with, as a defendant is presumed innocent. It says that you should disregard it, no, not is, it,
Yeah.
and not discuss it.
Okay.
I think it should read you must entirely disregard.
Okay.
It because it's-
Any problems, Mr. Truman?
None.
You must entirely disregard it and not discuss it.
That's right.
How's that?
That's fine, Your Honor.
All right.
Anything else on page 12?
I think there might be in the next paragraph, second line. I think that wither is supposed to be weather.
Well, it was weather. It just okay. I'll change wither to weather. How's that?
That sounds like a plane.
And I don't have any other objections to the end of the document.
Okay. Page 13.
No, Your Honor.
Any problems, Mr. Truman?
This is getting kind of repetitive. But other than margin issues.
Well,
with
we
page
can't do
13.
anything about that because that results from the way it was submitted.
Oh,
We tried,
okay.
but it's just, we're just gonna have to live with it.
Okay.
Anything on 14?
Second full paragraph is a gender issue, second line.
Are we on 14?
Yes.
Second paragraph?
Second full paragraph. You have to believe that the defendant.
Oh, I see it. Okay. Change him to her.
Right. And then the last line, committed the crime. I don't think it's an of that you need there. That just needs to be deleted.
Run that by me again.
Yes, sir. The last line on page 14.
Yeah.
To establish the defendant committed the crime, I don't think of needs to be in there.
Oh. Got it. Okay. Page 15.
Nothing from the defendant.
Nothing from the state, Your Honor.
Okay. Page 16.
I think it's the bottom, the last paragraph in that, the law presumes, that's all covered on page 2 of the charge.
I agree, Your Honor, and
Okay.
I think that if we need to have it, it can be moved to the beginning of the instructions, but I don't.
Yeah, which it's on page 2.
Right.
Okay. I propose to take out the entire paragraph at the bottom of page 16 and it runs through the top of page 17. Is that okay?
Yes.
That's fine. No, yeah.
And likewise, on page 17, since we're there, the last paragraph is also covered on page 1 of the charge about the indictment.
I agree.
Now, where is it?
The last paragraph on page 17 is also the
I'm
first.
going to remove
Yeah.
the last paragraph on page 17, which runs one line on the top of page 18. Okay, now page 18.
I don't know that this is an objection, but I don't think the courts admonished the jury as to any statements that were limited for the purpose of impeachment. I don't recall it if it happened that way.
Well, it didn't. This is just stock language, which I can remove if you want it.
Well, I mean, I just don't think that this
It
happened.
doesn't pertain to our case.
No, it really
I
doesn't.
propose to take out the second long and full paragraph on page 18. Is that okay with you, Mr. Victor?
Yes. That's fine.
I don't know that we've ever done that, but it's always in the charge. A lot of this came from Judge Ashworth.
Yes, it did.
Okay, page 19. I hear a sigh.
Aren't we slightly repeating ourselves with this?
We are.
We are.
All possible doubt.
Mr. Truman has always complained
I
about
do a lot
that.
of whining about that. Yes, that's true.
It inures to your client's benefit, but I'll take it out. What is it that you want removed?
I have no words. I don't know if I should cry anymore. I thank you. I literally have no words, and that that's I you're so kind. Thank you. I don't know what to say apart from thank you. Um, thank you. I absolutely don't know what to say. I think I need to go and cry some more because I haven't cried enough apparently. Um, I've almost thank you. Gonna cry again, and let's go back to court. Oh my days. Thank you.
Those two things. It's a proper statement of the law.
Well, I can
But-
just remove that squib altogether. I don't know that we have to have it.
Well, judging by the prior instructions and because it's murder in the first degree, I think that the jury will, by virtue of the nature of the charge, have to discuss the punishment.
I propose to just take out the line, you must not discuss or consider punishment or permit any speculation concerning punishment to influence your verdict in this case.
Of course, there is this involuntary manslaughter, which, by the way, I don't think that the jury should ever be advised whether it's a felony or a misdemeanor, but
I don't think we should tell them that.
right. And
I'm going to remove this line.
but that line is superfluous in murder case.
Okay, anything else on page 20?
Nothing from the state, Your Honor.
No, Your Honor.
21.
No.
No,
Nothing
Your
from the
Honor.
state.
Will the court advise the jury on the selection of the foreperson?
Oh,
or
yes.
it's done later?
Sure.
Okay.
Now I'm going to have my trustee law clerk Colleen redo this, and I need some help, especially from you, Mr. Victor, because some of the instructions you read into the record from a book or from rote, and she will ask me what I want in there, and I wasn't able to write down everything that was pertinent.
I'm at the court system.
Okay. All right, I'm going to revamp this, and we'll get ready for the jury. Hopefully they'll arrive at 10 o'clock as instructed, and we can go forward.
Okay.
In terms of the schedule, and again, I don't want anybody to necessarily tip their hand, but I anticipate that the state or that the defense will rest. Is that right, Mr. Victor?
It is correct, Your Honor, yes.
And then the state may have one rebuttal witness.
Yes, sir.
Okay. All right. Let's get to work, and I'll need at least Mr. Victor, if not all of you, to help us straighten out some of the elements and some of the charges for the jury to consider. We'll take a brief recess.
All right, so that was fairly quick in terms of jury instructions. To be fair, I was distracted half of the time for the generous donations and memberships from Ivamos. I can't even speak yet. I'm just stand, and thank you so much. It's so much appreciated. I better get on some content created for members now. Thank you very much. I mean, any support, even just spending your time here, it is very much appreciated. I appreciate every single one of you. And I don't want to start crying again, because otherwise I'm gonna have to title this True Crime Addict Cries on Stream instead of the trial. So um yeah. Oh. Huh? Oh yeah, he's in the background, lol. So I was just yeah, I am just stumpfucked. Sorry, I'm still in my lost place. I'm still trying. Oh no, distract me all the time now. It's absolutely fine. Thank you. I appreciate it. I'm just still speechless about it, because when I started doing YouTube and doing this a few months ago, I never thought that actually people would come and spend their time with me, might as well wanting to be members of this community and just give. And it's just so nice to see, and I'm gonna make myself cry. And I'm gonna have to change the stream, and I don't want to ruin the makeup. I actually did an effort today of looking nice for the stream, and not looking like, yeah. So again, I was like, thank you. Sorry if I'm carry on crying. It's just thank you. It's thank you, Denise. Stop making me cry. Oh no, it's just amazing. Thank you so much for the support. It is very cozy here. We try to make it a little cozy, and it's just I I really appreciate every single one of you. I've heard, I don't know if you guys heard, but I heard about what the first 5 pages of the jury instructions. Apparently there was 20 of them, or 22. Lost count. I got too distracted with everything. I know the charges that she's facing. That way now, at least it's something. She's facing first degree and unaliving, and then she's has a lesser included of involuntary manslaughter. And so that's all I knew from the jury instructions. The rest, don't ask me. That I got too distracted by something. I wonder what it was that happened on the stream. So they were done very quickly. I thought they were gonna take the whole morning, that they were going to be late for the jury to come and to do the instructions. Even the slowpoke attorney, the sloth, was fair. Well, he did not had a part a say in it. It was Victor that Clink, I think it's Clink, that said more stuff than he actually did. So but yesterday, actually, and I forgot to share this with you guys, and now that we have a little bit of time to talk, we can. These attorneys, now I'm not taking sides, right? Both, either the defense attorneys or the prosecution, right? Both of the teams, when they are on a trial, they have to become experts on the most wildest things ever. So this case, obviously, we've been dealing with insulin, and they like about diabetes and all of this kind of medications and not medications and everything. But at the trials, we've seen, for example, the Melody Fairies, they had to become experts on burns and fire, and how the heaviness things a person um was doing. Oh no, Nightbot. If the slowpoke would be reading those 22 pages, would be here next year, and would not yeah, absolutely no sloth for that. Like I was saying, so it's interesting how they have to become themselves kind of an expert on what the trial is on about. I mean, this case, insulin, and that's just it's amazing how probably a short time, because especially this prosecution team, they only had us a few months to prepare themselves for this big case, because of they changed teams. So it's just interesting how in such a short time they become experts on insulin, and know a lot about this information and everything. And it's just, yeah, um it's just amazing that how they work like that, and how attorneys are so versatile and adaptable to different circumstances, and learn so much about a subject in such a short space. And that is a really good like quality in a way for an attorney, that it's very adaptable and they know how to like investigate about something, get experts, and even that, getting the experts that that they they have to find this expert somewhere. You can't go on Google, or can you, just like an insulin expert, and then like something shows up. Probably you have to have contacts of people in almost every aspect of things to be able to have information on this. So it's just very interesting. Like, sorry, sometimes I do wonder about the most random things ever, and then talk to you guys about it on stream, and you guys accept. No, I'm joking. It's just hilarious that of the things that I think sometimes, and the way that, yeah, my mind works. You don't want ever to know that. Um, so it was just now waiting on 10 o'clock. Yes, 10 o'clock. Sorry, I was looking at the clock and figured it out. 10 o'clock for the jury. Hopefully, will be on time. I think even if they are early, the judge might start court early, which does not goes into having a 24-hour live stream. I mean, one second. So what we're gonna do is, if they come back exactly at 10 o'clock, we will do a 24-hour live stream. If they come back earlier, they come back earlier. No, I'm joking. They might still have their biscuits in the morning, but I'm sure they're not gonna be on time for sure. But if they come exactly at 10 o'clock in the morning, or until the end of closings, because obviously the verdict is impossible to know when they are going to come back, because we can be here for 6 hours, 8 hours, like we were in the next time. But if they do start at 10 o'clock in the morning, I'll do a 24-hour live stream. So you can clip it, post it, and then if I don't do it, like very rightly so, tell me off about it. Use as proof. You can use this as an evidence in the court of law, just to hold me to my word, and now and to do it. Don't trust Nightbot to remind me of things, because he has a memory of a goldfish. Actually, no, that is wrong. Did you know, actually, very randomly, goldfishes have a good memory, so that's saying it's not really true. So yeah, goldfishes don't have the greatest have really good memories, so he has a very bad memory. I did ask him yesterday to remind me at the end of our stream yesterday to share the timeline for our new case, and he forgot about it. So um yeah, no, don't count on Nightbot for that, because he's not a good person. He literally has memory problems. I'm honestly getting him to go to the doctors to check that out, for because for his age, he shouldn't be that. I did not call you worse than a goldfish. I just said that your memory is not like a goldfish, because goldfishes have good memories and you don't have a good memory. Gold. I was gonna call it goldfish. My apologies. Um, yeah. Oh, yeah. He does other stuff very well. Lois. He's very handy. I mean, he built a shed outside of our house, which is amazing. The shed has been standing for 2 years, no problems. Is very very handy, and he also does leather work. Like he hasn't done as much, but he does like bags and everything. If you like want a phone case or anything, you can get. You can do it with no problem whatsoever. That so it's just that is very very handy. Ooh, sorry, I just received the document from the Discord people about the indictment of the of Natalie Cochran. But I think this is more about Yeah, I think this is about the federal case actually, because he's sorry. I was just like, yeah, he built a shed. A shed. I mean, he's absolutely fantastic. He's very 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 good with like building stuff with doing things physically. He's very very good. He can like. You give him an idea in terms of something to do in the letter work, he will do it. With his models, he's absolutely fantastic. And sorry, I got my cup of coffee in my favorite mugs that says I can't adult today. So I have resigned my adultness and I unsubscribe to that channel of adult. Um, so yeah, so he's very very handy. I really like him for that. Well, not just for that. Let's just say I don't like him just for that. I like him because of many 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 of his qualities, not his memory though. But he's very good. So, and I need to stop talking good about him because otherwise his hat will not fit in the room. I'm joking, but so yeah. So I was just waiting now on court to start. Um, I want to thank one more time to I Vamos for the generosity to the channel. It's still gobsmacking me that and just yeah, absolutely amazing. Thank you. And also, by the way, let me plug a little bit more. There is a new video out, maybe after the stream or during lunch break or even on Verdict Watch. You can go and watch a new video on the channel about my experience of yesterday going to court in the UK. I know we talked about a bit in stream, but I talked a little bit more in depth, and I did show a few bits outside of the court and a few pictures that I took inside of the court and everything, so you guys can have a look. Well, you can go now and have a look. We're not really particularly waiting, but the video will be going. It's I think 18 minutes, and it will go into the time that the jury is supposed to be back. So you don't want to lose anything because we are on the home stretch for this trial. I'm very very excited. I want to start investigating if our new trial um yeah, thank you. Make a banner of Nightbot, and then we might use it. I need to check if there is any news coming out of Florida about the jury selection of the new trial. You know that I'm always following that. I am slightly become obsessive with this trial. Um, I have a problem, and I think I'm gonna have to say my name is True Crime Addict, and I am obsessed with the Colin Griffith case because I am stalking Reddit groups, I'm stalking X feeds of Court TV, Law and Crime, and what's or not, and go forth. I've been turning on my VPN to find out more about this case, more about the jury selection. Yeah, it's becoming a problem. So I'm really, really hoping they do live stream it online because Law and Crime did tweet something about it last week, and I know from well, Reddit is not the best place to get your factual news, but there was this group that there is about true crime community, and they do say that it's going to be live streamed on YouTube on Core TV. So, but again, it's Reddit. Never really believe what is out there. It's crazy. Sorry, 1 second. So yeah, so that's I'm trying to because the thing is there's some news right that says, and I'm gonna read. Trial begins for teenager accused of unaliving mother. Okay, that means that to me kind of meant it's like, oh, trial's about to start. We're gonna have openings. Now, when I go into the article, right, it just says jury selections began on Monday. I was like, you say trial began, so it hasn't actually begun in a way. You begins when opening statements begin. That's when the court begins. So so oh hi, sorry, case one, welcome in, welcome in. Sorry, Nightbot has been chatting way too much and I did not see your message. My apologies. If you are catching up, awesome. If you're not, I'm gonna give you just a bit of a rundown. We only had the jury's instructions that they did. Took us took them, not us, about 40 minutes to do. There was not much spicy or spiciness at all. The only thing that happened was that the charges was given. Like, we now know exactly what charges she's on. So it's a first degree unaliving and voluntary manslaughter, which will be probably the more probably charge that she's going to go on. And then we had Ivan was very grateful giving memberships to the channel to try hit people left, right, and center, which was amazing. We still need to, we'll hit you as well. And yeah, that was it. And now it's just me talking a lot. I have my cup of coffee here waiting for me, and it's cooling down a little bit because it's a little bit hot for my taste. It's only my third cup of coffee, so it's okay. So I'm not allowed more coffee after this one because I'm limiting myself to 3 cups of coffee. So it's not a lot for a Portuguese person that loves coffee. 3 cups, it's nothing. It's nothing compared to what I used to drink back in the day when I used to live in Portugal. Oh, okay. What are your notes? Do you want to come on and talk about your notes, or? No, but let me know if you want to come on. I can, we can figure it out a way that we can both be. Oh, okay, yeah, you can talk while I drink my coffee. Do you want to come to the side, sorry, just trying to figure out what Nightbot wants to do. Bear me a moment. I think he's getting himself ready to come on camera. He's putting his makeup and is touching his blush and everything. I'm joking. It's gonna kill me. But nah, is just getting read through his notes just to prepare himself to come on. You get a special. You get both of us on stream. Probably we need to figure out a way that we both can be on the screen. I don't think we can figure that one out just yet. Maybe when we are in the new place tomorrow, it will be easier. And we're still going to be doing the do a stream. Me and Nightbot do a stream together, so you can see how we interact with each other, which is very lovely. No, I'm joking. Oh, you guys are like, I have a 3 cup of coffee. I am still shaking from what happened earlier. Well, that is my hope so too, Case One. It's just the thing is, if they're gonna find she's gonna go for I think they are gonna go for the involuntary manslaughter, and I don't think I can say it. I think that is going to be the charge they are going to go for, not the first degree unaliving. I don't think there is proof enough for that one. But yes, the second charge, and the reason being is she probably what she's going to be, it's the negligent side of it, that she failed to provide aid and or care to a person that was in need of, and that could be classified as that, I believe, in West Virginia. And that is going to be, if she does get convicted on that, it's a range of penalty of 1 to 5 years in prison. So, and that would happen after her sentence in federal prison. So she would go from one prison to the other one to serve that, which would be a big shock, because I mean, I don't know in terms of reality if it is actually, but federal prison is a lot more cushier than actually normal prison. So she would go from the very cushy prison to the reality of prison and suffer that way. So I believe, 1 second, give me 1 second again. Sorry, guys. So what's gonna happen is, you guys kind of probably hear Nightbot talking. I just need to try to move the mic without without crashing everything and ruin everything. And while I'm gonna be seated here, you're gonna watch me. You can't see Nightbot because the way the setup is, you can see his arm is here. but then he's gonna talk while I have my coffee. You can try talking.
Yeah, I don't want your coffee to go to waste. That's why I probably thought it would be a better idea to talk about some of the notes I had on the first witness, which was I say witness. He was the first pathologist to come on. So this pathologist was 40 years in his trade, and he'd done thousands of autopsies. It said in one weekend he did 6 autopsies, which tells you how many autopsies.
Yeah,
done.
that is a lot of autopsies. Sorry, just one question, Nightbot. Which coffee is this coffee?
It's a normal coffee. I put syrup in.
You will about to witness an unaliving on stream because he did my unfavorite coffee ever. Yay!
I tried something fancy, it backfired. So right, go to note number 2 because I didn't have a notebook.
Well, there was many around the
doing it
house.
on these little post-it notes.
Well, I'm looking at one right now.
So they were looking for. I'm trying to read the word encephalopathy.
He can't even read his own writing.
Yeah, no, it's very hard when they pronounce something and you're writing it down phonetically. It doesn't quite translate well.
Are you okay?
Yeah, they were looking for brain damage function.
Yeah, because they did say that he was almost brain dead when he went to the hospice, so that could kind of correlate to that.
What he did say was time probably would have been a factor in this, in the death. So getting him to the hospital was, the quicker he got to hospital, the quicker he wouldn't have lost brain function.
That is true. I mean, she did wait like forever to take him to hospital, which I don't understand that thing out of him. So her, sorry.
So they originally tried to question him about an abnormal amount of meds, or whether that would have been anything to do with the cause of death.
One second, Nightbot. Sorry, it is 10 o'clock in the morning right now. As soon as it turns to 10:01, the 24-hour live stream, it's not happening yet. So we'll just keep an eye on the clock for that.
I should have been reading while you were talking. I feel like the first pathologist was actually suspicious of the other pathologist, because there was 2 pathologists that did the autopsies.
There was 3 autopsies apparently altogether. So.
Yeah, but I'm not counting the private one because
true.
I mean, it depends what she was looking for, really.
Yeah. And it's 10:01, so live stream is off for the moment. Well, the 24-hour live stream. We're gonna carry on today. Don't worry.
Which is interesting. I don't understand why he was actually there, because he said it could have been in a crazy amount of stuff that he could have died of. He had many different ideas, but he said that pretty much the body was decomposed and the brain was decomposed. So basically, they were trying to figure out whether his head had swollen, and obviously he couldn't tell them that, because for him he had to measure the white matter and the grey matter in the brain.
Yeah.
So timing was of critical importance to
of course
deconstruct the body.
Yeah, and then especially because it was that one was which one, the 7 months one, or the one that did in 2024, the autopsy.
I think this autopsy was 7 months.
Okay.
He said there was many things he could have found out that would have been problems.
Yeah.
Like he couldn't find anything basically. So by that point, it was pointless him doing the autopsy.
Well,
so
yeah.
I feel like somebody should have actually let him know that there was a body to work on.
Yeah.
it almost sounds as if somebody failed to let them know. So that was my notes from yesterday.
Well, the fact that they did took 3 attempts of autopsy and 2 exhumations of this gentleman out of the ground, all where he was being kept, it just shows that it is crazy. And that was Nightbot's review of day 7, the part that he covered for us on stream while he was thing, and now he's choking. No, I'm joking, he's all right. He's just not used to probably talk as much as I do, because I talk a lot. So he's just choking far away now. He's all right, don't worry. Need to set up again my mic like it was, so it doesn't. Yeah, there we go, it stays like I want. So in terms of updates, there's no updates on the other case on the jury selection, so I think it's still ongoing. I think they might be having a trouble. I am trying still to keep an eye out on any news or anything that is happening, but no really information on it. I don't know. Let me have a look. Oh, also, by the way, do you guys know, that case with Blake Lively and Justin Baldoni, I think it's another defamation case. They have a date. So, oh, there's a new case going on, and I was just catching, but it's not being live streamed again. It is just the Court TV style of live stream. So the Blake one. So it said that a New York judge set a March 2026 trial date on Monday. Well, basically yesterday, and moved the initial conference from mid-February next week, as the public feud between Blake Lively and her it ends with her co-star and director Justin Baldwin continue to grow and accelerate. So apparently, if they don't settle before that, they are going to go to trial next year in 2026. But again, it's New York, so probably that is not going to be live stream. And you did it very well, Nightbot. Thank you very much for that. You did very much. Yeah, it's first week. That is a quite quick. That's literally next week, the first week of February. So that is just, I think, what it is. And gone. The initial conference. So that is absolutely crazy and fast. But the sad thing is this trial probably is not going to get live streamed. It's just because it's New York. I don't know how defamation cases do work in New York, or even if, because it's a defamation case, they can live stream. But yeah, no, you did you did very well. I'm very proud of you now, but you're getting more comfortable, which is absolutely great, and great to see you grow on stream. But so that is the case. I mean, if he gets to it, and if it's live stream, and if we're not in the middle of a live, if a court case next year or whatever, well, I might consider streaming that one. We'll see where things take us and where things go, because we don't even know if it is going to be live stream. But I'm sure there's going to be a lot to talk about, and it's going to be a lot. It's going to be like Amber Heard and Johnny Depp 2.0, but it's going to be the New York version, and sadly probably not going to be live streamed. But then again, where was the Amber Heard and Johnny Depp case? Was it California? I'm interested now to know. Does anyone know in chat where Johnny Depp, if I knew how to spell Johnny, that would be good. Johnny Depp and Amber Heard. Where was the case? Where was Heard? Oh, Virginia. Okay, so that tracks that. That's why it was live streamed. So yeah, it's Virginia. Thank you, I very much appreciate it. So yeah, so because probably that was because he was in Virginia, that was why it was live streamed, and was live streamed. And this one, it's probably not gonna. Knowing New York as it is not gonna be live streamed. So we'll see. I mean, until from here until then, a lot of ink and a lot of publicity and then a lot of information is gonna come out about this case. Oh wow, they are late 10 minutes. What a surprise! The jury probably still munching on their biscuits or on their chicken sandwiches or whatever the court got them this morning. So we'll see where things take us. We'll take one trial at a time, and yeah, we'll see where it goes. But it's just interesting that new information came out on that. Well, it is going to be a new trial unless they settle before, but I don't know. I'm not saying them settled in that case. So, oh, hang on. Oh, please, 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 there is a live stream of that. There's a new article came out in Core TV website about our new case. Um oh. Oh no way. That is so interesting, Lois. I would be like, maybe you are, maybe it's this doppelganger and you don't know, because I mean there is a lot of people that I see online and everything that looks like a celebrity but it isn't, so it's just crazy. um okay, hang on, so let me just double check about this case. I'm trying to read very quickly the article that Court TV just published on their website about a new case, see if they mentioned if they have started or not. um oh, well, maybe could be. I mean, I'm not saying anything, but that could be a possibility. And it could be like not this temporary, like not this full time house, but maybe just a house when he goes to that area. I don't know. That is interesting. It's crazy. Or you could be definitely the doppelganger, because most of these celebrities, they do have people that look a lot like they look, just to be out there for them to be safe. It's a little bit weird. How do they do this? Oh, sorry, my throat. It's oh wow. Tha- I mean, that is now crazy coincidences already, Glowes. That is absolutely crazy. No way. Oh my days. That is mm, well, like that is so cool. But maybe one day ask him. I don't know what is gonna happen. It's gonna say, no, 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 it's not me. I'm just looking look alike or anything. So, or like, I mean, if you want to do that, I'm not saying to do that. I'm just joking. So, don't take advice from me. By the way, you never should take advice from me. No, yes, I said don't do it. I was just joking. Um, yeah, sorry. No, there's nothing new in our case. I'm getting very obsessed with that case. If they don't stream that case, I'm gonna be very very sad, and I'm gonna be very very upset that we can't stream our case. And we spend so much time. Well, I spent so much time digging and researching about it, and then yeah. Um, Oh, no way. Ben Stiller is amazing. I like him. I always, you know what? Him and Adam, what's his name? The other, Adam Sandler, thank you, Nightbot. They, in my opinion, okay, in my opinion, this is just my wild opinion, they look alike so much. Ben Stiller, and correct me if I'm wrong. Um, Oh wow, really? Oh, it doesn't look like. Maybe he wears not heels, but heels inside of the shoes where when he acts. But I always thought that Ben Stiller and Adam Sandler was the same person until I actually realized that they are not. They are just kind of look alike. I don't know if they are, if it's just me that thinks that they look alike, or if not. So bear with me. So it's just ooh. Yeah, exactly. So that's what I thought. That's maybe that's what it does. Oh, it is very funny, but I think I'm gonna be a bit controversial. Um, I prefer Adam Sandler. I really like Adam Sandler's movies. Oh my days, he's just hilarious. Was it the yes? No, the one that he has the remote, the click. I think it's click. That one was one of the best movies. And then there's the other one with the little kid. Oh, I keep forgetting the name of the movie. Let me see if I can find it. One second. Adam Sandler and kid movie, because I keep Big Daddy. That's what's the name of the movie. Big Daddy. It's quite an old movie. It's from 1999, so it is 26 old. So it's very good. I really like that movie. And it was actually on the other day on the telly, and I wanted to watch, but I think, oh, oh yeah, is that the one with Jennifer Aniston? Okay, Swan, because that one is also very good. um oh 51st Date. That one is a very good one. Meet the Parents. I was like, it's great movies. He's a great actor. I really like the way he does, and he's now a director, I think, as well. So he did as the Mall Cop as well, which was hilarious. So I really like that movie. Uh, it's to just go with. I think it just go with it with Jennifer Aniston. It just has done such good movies that is just we could be. Oh, was it Kevin James? Oh, oh, okay. I like Kevin James too. Then no, it's he's a good
It was wasn't it Adam Sandler?
Oh well, but Mall Cop is always it's a staple. Okay, it is still very good movies. Um, no way, she was. Well, to be fair, it's Jennifer Aniston. She can get any role she wants. After she did Friends, which I am rewatching again on my spare time. I'm rewatching Friends, because I haven't seen it yet this year. So, oh. She does art? I did not know that. Oh, see, I know a lot about true crime, not about movies, because all my time that I spend is watching videos on true crime and doing research and stalking people on their internet. In terms of true crime, don't take that out of context, please. Sorry, I need to just sip my coffee before it goes cold. Hopefully I'm not gonna have a coffee thing on my lips. But yeah, Adam Sandler is very good. Which other actor do I like? I can't remember any actors right now. I'm on a spot. Oh, I know it's because I just spoke about it, but Matt LeBlanc, it's he's very good too. Oh, Matt Damon. Oh, that is true. Matt Damon. I had a crush on Matt Damon, right, a few years back. I absolutely obsessed. Favorite movies from Matt Damon? The Born Identity. All the Born Identity movies. I I can watch it all the time. And it's a one that is actually quite old. It's from 97. But I really remember because I used to watch it at least once a year, that movie. And I can probably say, oh, say that movie by memory, because it's with Matt Damon and Ben Affleck. Good Will Hunting. It's from 1997. It is good as everything, and he has how was his name? Oh, what's his name? Robin Williams. That's it. Has Robin Williams on it. I mean, any movie with Robin Williams on it, it's a good movie. You know that. That was a great loss. So, yeah. Uh Oh, you do? I am so jealous. I mean, I'm sure I can find out on the streaming platform all the Bourne movies, but it is. But the thing is, they did one without Matt Damon, and I did not like it. Not because Matt Damon was, yeah, probably that was why I did not like it, because Matt Damon wasn't on it. But another great movie that he did was The Martian. That was a very, very good movie. Um, I think it was in one of the oceans. I think it was the Ocean 11 that it was on. I think it was. It was very good. I think it was on Oppenheimer. Sorry, getting a little bit talking crazy about Matt Damon. I'm gonna keep talking about it. Wait, was he? I don't know. Was he? No, I don't think he was. I know it's like we bought us, so that one is a little bit, yeah, wild. um I'm thinking, no, it wasn't, or was, the Inception movie. I really like that movie too, and I really like the aspect that makes you think and everything, but I don't think Matt Damon was on it, was it? Hmm. Oh yeah, we need to start now, but the thing is, Nightbot, doing that will take a lot of licenses and copyrights and everything, because movies are all copyrighted. You stream that, that'll be you gone. It's not as like a trial. There's the fair use and the right to know and everything. So it's not, sadly, it's not the same. So streaming movies and streaming that sort of stuff, it would not be good for anyone. Would not make anything. Yeah, that's just, yeah, YouTube doesn't even allow that. They will strike you and give you copyright strikes so hard that it will be crazy. I mean, sadly, there's channels that are going down. Oh, I met him. Okay, sorry. Sorry, I mean, he did not specify, so it was not my fault. No, I'm joking now, but the thing is, with you, I can be a little bit more real. No, I'm joking. I can always be real because I mean, what's up with court? Oh my days, hang on. Okay. I just had a thought that I had stopped the stream, the feed, and I was here talking for nothing, and court was going, and we were losing. No, they're just late, very late, 20 minutes late. I mean, even for them, that is not normal in terms of how late. I said sorry. Yes, I did say sorry. I was just thinking, it's like they are late, but they're never this late. It's like almost half an hour late. Maybe one of the jurors got stuck in traffic because they came in later. They had more traffic, probably because they're normally there early ish. So maybe one of the jurors got stuck in traffic. I don't think there is actually quite any news about that. Ooh. Oh, Tom Hanks. Oh, it's so sad what's happening. Which is the name of that actor? Oh, it's missing. He's been diagnosed with dementia. Bruce Willis. Oh, that is another good actor that sadly has been diagnosed with dementia and everything. And it's just so sad how things are going for him. He is still a very good actor, but I don't think it's gonna be um yeah, it's gonna be a bit hard for that. It's a bit sad when starts to, yeah, go downhill that much. Sorry, another sip of coffee because I'm getting a little bit dry throat. Not gonna lie, this coffee, it is okay, but it's not the best. It's, I think, it is what, a vanilla flavor that you did, Nightbot? No. Because he put something in my coffee, like a flavor or anything, and it's different. It tastes different. It's not poison, but because I haven't done enough, I haven't yet. Oh my days, this channel is wild. Honestly, so yeah, we are waiting on court to start. It's still not going. I wonder what happened now. Something is. Do you think that she took a plea at the last minute? Is that possible? Now that, like, we are literally at the verge of the conclusion of the case, but, well, technically the defense hasn't rested yet, because it hasn't been entered on record, I don't think. So I don't think defense has proper rested, because they haven't said the defense rests to the jury. So um you need to explain that better. Gardeners make the best analyzers. Why do you think that, Nightbot? I want to know why you think that. But like I was saying, I don't think she can take a plea deal at the moment, can she? Oh, please don't. I don't want, like, having gone through 8 days of testimony of this, putting up with the slowpoke, with the sloth, um, and then having to, she takes a plea deal at the last minute, then lowers you and Nightbot will be best friends because he's a gardener. That's what he does for a living. Obviously, now during the winter, he hasn't been doing much because it's winter. So, uh, any tips or tricks that you would like, contact Nightbot, or you can contact me and then I contact Nightbot. We both, but yeah, he literally knows everything. He went to college in here, over here in the UK. He has a lot of qualifications to do gardening, and he's been doing his own business for what, 4 years, 5 years now, almost 5 years. How long have you had your business, Nightbot? It's been a long time. Yeah, it's been about 5 years that he has his own gardening business. So, and well, I think gardening is pretty much universal. So, yeah, fair enough. But hey, any tips on gardening, you can reach out. And I mean, it's not going to come from me because I can kill the cactus, and I would kill the cactus. Don't ask me for opinions on gardening, please. If you do, direct them to Nightbot, because Nightbot needs gardening. It's, yeah. Yeah, it is trial and error, but I literally can kill a cactus, and I don't want to subject the cactus, another cactus, to that. Because during the pandemic, right, during the lockdown period in 2020, I tried to grow tomatoes, and it did not work. I had the tiniest little tomatoes of like this size or even smaller, and yeah, they did not grow, and I don't know why. Well, I must have forgotten to water once or twice. What should you grow in Florida? In the summer. Nightbot? Opinions about what to grow in Florida in the summer? I would like to know. Help, please. I need help. I think you will post something in the chat because zone 9. It's zone 9. Cactus chat. It's just because, okay. This is nice. I am learning new things today. I did not know that um I know more English. Oh, Court is here. Court is here. Da, da, da. Court is here. Court is here. Finally. Well, only 25 minutes late.
Good morning, everyone.
Morning, Your Honor.
And we are continuing in the trial of State versus Cochran. We have been working busily on instructions, and I have a draft that I have handed out. Hopefully, Mr. Truman, you've got a copy there. Okay,
Yes.
I'm not rushing you. We'll have some time to discuss it. I just want to make sure you got your copy.
I did. Yes, sir.
All right. Any matters to take up at this time before we bring out the jury and continue?
Still,
Yes, Your
we need
Honor.
the equipment for the next witness.
Okay. We'll fire that up.
I will carry it. You go with, yeah, and I will carry it.
All right.
My days, we've been on the record for 2 seconds and they already want to approach again. Like, but anyway, what about cucumbers and carrots? Maybe I'm just saying. we definitely need the fireball, the 8 ball now to predict how long are they gonna take. 500 years. I think that's what they are gonna take. Um, yeah. Ooh, sorry. They're oh yeah, it's just yeah, yeah. But I think they are discussion matters of the witness. What they could possibly be discussing at this point in time. The fence is gonna rest. Oh, oof, okay. Heat and no shade. Cucumber. What about maybe carrots? I know. Case one. That's just that could be a record breaking right here. That the sidebar 2 seconds after they come back. I mean, we've waited half an hour to stop work today. First thing that they do, sidebar. It's just crazy. Absolutely so infuriating. Sorry, there was just a news article that came out about our trial, but it's the same thing as always that we've already known. It talks about the trial is more clickbaity than actually proper news. So well, yeah, he has to because I don't think this judge wants to get a move on. I think I think his wallet is already kind of hurting of having to buy uh, the food for the jury. The ones that they showed, yes, I believe it is case one. I think it is the parents of the deceased. I think this is the grandma that's gonna go on the thing now. Um the grandma, and I don't know who that is, but she's been there almost all week. So it doesn't look like a daughter. I don't think they had two daughters, maybe a relative, or they keep zooming in on her. And it's just crazy. I don't know who she is. Probably she's a relative. But I think the other two that they showed, I think they are the parents of Michael, of the deceased, that someone had an outburst yesterday in court, and I believe it was the mom when she was looking at that autopsy photo, which by the way we haven't spoke about. This is the grandma. Is that was a little bit too bad from the defense, like posting that picture straight away the without notice, without telling people, or if you want to get out and everything. um Probably, you never know, she could have stashed it somewhere and just yeah. Sorry, I'm just looking for something, and it is please don't tell me I lost it. Yeah, I think this lady that is showing now, it is the mother of Michael. Find the photos that I've saw of Michael and everything. It does look like it does, they are very similar. There it is, here, found it, awesome. It does looks like Michael, but and then the gentleman next to it, to her, the father. But I don't know, it's just all speculation, of course. So it's just me simply talking. And my days, why a long sidebar? The jury's not present. Why can we not be privy of this? Because it could be. Um, oh, I don't know what you're talking now, but probably some gardening stuff that you're talking. I don't know. I'm not gonna put myself in that conversation because I don't know anything. Um, mm. Yeah, I was like, it is horrible. I having to have to watch that photo yesterday. I don't know. It must have been so horrible. I think this is just court watchers that are in court. I don't think they are related to the case. I think it's more like community people. Um, but then again, don't know. Don't quote me on that. Don't use my information for proper information. I'm joking. So it's just, and then all the media people, then more family members, I want to say. But it's interesting that the kids are not there today. Oh, the other person, the media person, was talking to that relative, I want to say. Tony. It's Victor's talking, so Victor is going to get done hopefully fast. I don't think he's happy about something. He's never happy with anything, really. Just doesn't seem amused. Prosecution doesn't seem very happy. I said, I don't know, Your Honor. I just started of this. I want to go home. No, I'm joking. You feel that I'm starting to go crazy because it's already 10:30 in the morning. Oh my days, the hearing. I have a hearing I have to go to. I completely forgot. Oh my days, sorry guys. I'll be right back.
All right, now, Mr. Truman, if you'd take some time to select the documents that you wish to present.
Handing them to defense counsel as we speak. I'll take these back. Oh, yeah.
Sure. All right.
My apologies. I can't talk right now. I'm in the middle of a hearing and I will be right back. My apologies.
Time.
Okay, looking at the ceiling now. Right, I'm done with the hearing. I'm back. Sorry about that, guys. I mean, what happened? Sorry, I was a little bit distracted because I was trying to pay attention to the hearing, add to the chat just to keep both. But what happened? What did they say anything? Sorry, I'm back on as well. Did they say anything? It's just very weird. Oh, don't you tell me. Do you guys think that they are? She's getting a deal. That they are sorting it out, the deal stuff. Please don't tell me this. Please, 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 please. I don't want to have us put through the. That is interesting. That is very interesting. I was just like, because, oh, I please don't tell me that they are. They are getting a plea deal in a works. That is just, oh my days. Sorry, it's just a friend sending me some notes from the hearing. Thank you so much. But I was just like, I don't know. Nothing has been said. They've been in two sidebars talking to the judge and to each other, which is not normal. It is just so weird. Oh my gosh, what is happening? Last time that this happened, you guys remember? It was in a defamation case. What happened that? They came to an agreement in terms of the settlement for Zachary Young. Do you guys think that she's getting a plea? And if so, what kind of plea do you think that she's getting? Because now I'm interested. What is happening? Oh my days. I think so. Yes, they wanted to bring the detective again for the rebuttal case to talk about the kid's testimony, to talk about that and to compare to what the investigation was on about and everything to kind of probably impeach the kids. But they've been talking about that, and I honestly don't know. Um, No, the thing is, Nightbot, they can at some point get to a plea deal. The state could have offered something else to the defense before they actually finish, and they might be considering that. Um, they could be having a fit over that, but I think the judge would get that fit because I mean it's already 11:15. We've lost almost the whole morning. For sure, we're not gonna get to closings today. We're gonna have to spend yet another day on this trial tomorrow. For the closings and then verdict watch. Which is gonna be very, very, very interesting to see because I'm not saying that this judge definitely having closings today, not when he's spending so much time on nothing. I just hope she's not getting a deal like yeah, probably they are settling. I mean, they can be settling, which would be very, very interesting. Sorry, just scouring the internet to see if there is anything information on this or something else. But it's just crazy that they can like spend this much time on a trial and then all of a sudden just gets settled and a plea deal happen, and then all the time that they made the jury, the court, the staff and everything spend, because come on, she had plenty of time to accept the deal, to accept the plea deal and everything, so she should just accept her fate and just let it on the hands of the jury. Because come on, I mean, you've already changed your mind once, um in terms of testifying and not testifying, and now she's probably changing her mind again and accept a plea deal. That would not be too far-fetched, I think, in my opinion. I think that could be a very good possibility. Exactly, and all that food served and all the food that the judge bought for her, for her, no, for the jury. So I wouldn't be surprised that she's taking a plea deal, and then we're gonna come back very soon and the judge announcing that she is accepting the guilt because she's probably scared that she's gonna get found guilty. It is a possibility. I mean, it's not impossible. It's not too far-fetched, I don't think. Probably they are doing a potluck. That is funny. I'm trying to research like anything that's happening to see. Sorry, I pressed the wrong button now. Um, to see anything about this because it's absolutely crazy that there's a possibility that she is gonna accept a deal. I mean, yeah. I mean, it's not unfighterable. So I'm just like scouting the YouTubes and the internet for more information. Going on Twitter now, trying to see if there's anything new in either case because this is interesting now. This is getting very now that we're getting to the final stretch of the case. They all got very secretly. And remember, again, the last time that this happened, we were in the defamation case of Zachary Young against CNN, and this exactly happened. They came back and they had a settlement. So, which is interesting. So it is gonna be very, very, very weird. Let me have a look. I don't want to know about that. That's another case, and this is personal. This is politics. We don't want to talk about that. Um, nothing. There is no really information about it or anything going on. Just scrolling and nothing. I don't know. Yeah, let me see if there is any other information about the other case because I am obsessed and I've got a problem. Because when I get my head obsessed around something, I will investigate it without finishing. So that was 21 hours ago. I want something more recent. There is nothing. There's nothing really new. I mean, what's going on? Where's all the information? Give me the information, people. I just don't know what's going on. And I'm looking at my phone instead of screen. I'm still keeping an eye on my screen so I can still see chat, but I don't know why. It is morning. Hello, good morning, Paula. You look so good in green. Oh, it's so good. It's so great. I Vamos was very, very, very generous again for it gave us membership for the channel was I Vamos. She's absolutely amazing. Um uh she's been very generous to the channel this morning, and I'm not gonna cry again. And yeah, and if she amazing. If you want to see me cry on stream, just rewind a little bit. And it's yeah, it was great, amazing, great support, really, really appreciate it. And yeah, so f- for bad for who? For the defense or for the prosecution, Kay? Because that I think that was bad. Oh, such a hard worker. Hopefully we can keep you a little bit company, but I think it was bad for the defense, Kay. Yes, I think we are in the same wavelength because of hi, what did I say? I think it was the Priya, the second forensic pathologist that was on the thing. She was, I think she talked about the fact that he was allergic to benzos and he had benzos on his system, and that Natalie was prescribed benzos when she went to the doctor the day before he was unalived. So that for me was very suspicious. And then the fact that she was in the back of the car while the friend was driving to the hospital, which was 30 minutes away, which she had plenty of time to inject him with insulin and then cause him to have the blood sugar drop again or go up like crazy. So that's my theory, at least. Yeah, so it's just absolutely, that's my theory now. My theory, because with an allergic reaction you get symptoms straight away. I know that because I'm allergic to kiwis, and as soon as I eat the touch or eat kiwis, that's it. I need to have my EpiPen to alleviate the symptoms because they are immediate. So if it was allergic to benzos, which I don't know, but I can go allergy to benzo, and I cannot, yeah, can be serious and may require immediate medical attention. So he might have been poisoned with that. Yes, I am allergic to life. I think everyone is allergic to life at some point. um and Paula, I really hope you can cope with everything. It just seems a lot. Oh, are we back, or is this another false alarm that we are having yet again? We'll
All
see.
right. Are we ready for the jury now?
Are we? You
State
sure?
No, Your
prepared.
Honor, we are only halfway through these documents. A lot
Oh,
of them appear to be unsubstantiated, irrelevant, but we still have to go through about half the documents.
Well, we've got to go forward. And
yes,
so
thank
I
you.
don't want to leave the jury in there much longer. Perhaps you can review them and do it on the fly.
Well, Your Honor,
Leave it to the appeal
unfortunately,
sloth.
we would have to go through each and every document as they're being testified to. We need to view them.
Let me ask you this. Have you been provided with these documents?
We honestly don't know, Your Honor. We were provided with 100,000 files. I can't tell if we did or not, and we
And you
have
had
not
4 years,
reviewed
5
these
years to
prior
prepare.
to the presentation.
Let me ask Mr. Truman, did the state provide the defense with these documents?
We did. This is the download of the defendant's phone. We separated them, and we've already agreed not to submit all of the phone messages that are not already in evidence. So it's down to this stack of a few right there. The state does have a suggestion. In order to expedite this, we can probably eliminate some of these, and that could save us some time.
Okay.
You got, what number are you on? 11. Good. We'll eliminate 11. I said we'll eliminate 11. 12. No, this isn't on record.
They're engaging in another powwow.
Yes. 15. 17. 18. So 11, 12, 15, 17, and 18. We'll withdraw.
Do you want to withdraw any of these?
No, I told you the ones I was willing to withdraw.
Your Honor, respectfully, could we have an additional 5 minutes to, the state has eliminated a few, but.
All right. I'm going to hold you to that, Mr. Selden. I'm going to time 5 minutes.
Okay.
No more time. This is just absolutely crazy. I mean, how much more time does he need? It's like, I know he's slow, but come on, no. It's enough. Enough is enough. He just needs to start putting his foot down with this guy. They taking advantage, taking forever, delaying things, making me talk. And it's just like, no, I want to be able to do some research and some investigations on other things apart from Natalie. She is just Yeah, okay. I think by the time I think you're gonna finish the dishes quicker than they're gonna come back. Believe me. How much do you want to bet that you're gonna come back quicker than they're gonna come back themselves? Um. So 5 minutes. The judge is counting, and you know what? So am I gonna be counting 5 minutes to see actually how long they're gonna take. Hang on, where's my stopwatch? My timer. There we go. Start. I've started my timer to time to see exactly how long they are gonna take. If it is actually the 5 minutes, um, oh, so it's just I am definitely gonna be. So I'm just gonna do a bit of a recap for a friend there can actually she's listening to our trial, but she was in a hearing. Denise, you did not miss much more. They were just doing sidebars. I think apparently the defense needs to go through this massive document that the prosecution gave them, and they did not have the time to go. And now, at the last minute, they want to go through pages and pages of the document just before they bring the investigator on. So now they want time to read. The judge gave them time to do that. So, and now they want more time. So the judge gave them 5 more minutes, the last 5 more minutes to go through that document and to be prepared for the rebuttal. So that was what we both kind of lost because I had one earbud in of the trial that we are covering, and another on my phone of the hearing we both just bit into in on Zoom in Idaho. So that basically was it. We did not miss much more, and it's again to waiting and to wait. I mean, it's been already like this is the sloth, right? We're talking about. It's gonna be very, very slow reading these documents. How much do you want to bet that he's going to come back and he has not read not even 2 pages more than he was already read? So I think that is my bet that they are not going to be ready. They're going to complain. But I mean, leave that for an appeal issue. I mean, go like I'm sure she's not going to get convicted, and if she is, you can appeal it on that basis. That could be an appellate issue. So I don't understand this sign why these just move on with it and be quiet. So it's reads on the fly, and that's what he's paid for, to kind of adjust to these circumstances and like do things on the spot. So just yeah, do it. I don't know. It's just crazy the way this trial is being, because there's a lot more that is going on that I want to do, and I want to do research on things, and I want to see if the jury has been selected in our new trial, because I cannot find any information. I can look at the court records to see if there is any information on that, and it's already been 3 minutes. I'll show you guys on the camera. 1 second, bear with me. Been 3 minutes. Oh, a little bit. Oh, back early. That doesn't mean that we're gonna do the live stream. It's only when they are on time, like right on time. So they were
All
early.
right,
That doesn't
are
count.
we ready for the jury now?
Your Honor, we only have one exhibit to review. If we could have 1 minute.
All right, 1 minute.
I think the judge is as much as tired and sick of this as we are. I think he already had enough, and he's just about to throw everything at the fence and just like, I definitely you have more done than these guys have done. It's absolutely incredible. It's like the judge just lost his patience. I mean, this has been a very understandable and very perky judge, and very, very understandable with the scheduling, with the impasse and finishing court earlier, and adjust and adapt to their needs. But they've been absolutely slow about things.
All right,
and-
bring in the jury bailiff.
Yep, he had enough. Here we go. Finally. I can't stop talking. Yay!
I'll ask the defense to call their next witness, and presumably you'll rest.
Your Honor, while we're waiting for the jury to come in, we would like, especially, we would like copies of these to go through as they're being testified to.
Okay.
Always something while the jury is coming in. Always something.
Good morning, ladies and gentlemen of the jury. Good morning. I'm glad to see that you're still smiling. I apologize for the extreme delays. We have not been sitting around talking about West Virginia basketball or Marshall football or even politics. The attorneys and I have been working diligently since 8:30 this morning to try to streamline this trial and get it in a posture for your consideration. I appreciate your patience so much. We are now in a position to go forward. If you will recall, we are still on the defense case in chief. So I will ask Mr. Selden to please call the defendant's next witness.
Your Honor, we have no other witnesses. We are resting the defense case.
All right, thank you. Let me inquire of the state if there will be a case in rebuttal.
Your Honor, the state does have one witness to call in rebuttal.
All right, please call your witness.
State recalls Robert Heinzman.
Mr. Heinzman, I remind you, you are still under oath. You may have a seat. You may proceed, Mr. Truman.
Thank you, Your Honor. Mr. Heinzman, handy what's been at this point. It's part of State's Exhibit 3. Ask you to review that as well as the second page, which is also an abstract from.
You might request that we get copies so we can look at them while they're being testified to. If we could simply copy them very quickly.
Does the state have copies available?
We do not. I mean, we can make them, but.
Okay. I'll ask Ms. Brown Bailey or the deputy to make the copies real quick. How many do we need?
He's the only one that wants one, I guess.
One.
Yes, Your Honor, one copy.
Okay.
Your Honor, and for the court's information, Mr. Victor will be cross-examining this witness.
Oh, all right.
It's not gonna be the slowpoke cross examination. That is a good thing, and that is a celebration. Yes, I even rhymed. Oh wow! Please do not clip that. Uh, but that is just so good news because that means it's gonna flow a little bit better and it's not gonna be slowpoke to cross. Yay! Now we're just waiting for the copies to be done. Yet another tactic, so you can have more time to read the document. So, oof, honestly, the Nightbot, please no, thank you. Okay, I'm gonna go back to my research time while I am listening and taking notes at the same time of this witness. That would be absolutely hilarious if the bailiff or whoever went to do the copy and would come back as like, yeah, the printer doesn't have any ink. We need to wait for the maintenance guy to come and do. But so my possibility of exactly of having closings tomorrow is getting very
With our
high.
luck, the copier may have run out of paper. That's right.
See, I think the jury is listening to our stream because we were just talking about paper ink, and he just said that. Oh my days, this trial is gonna be the death of me. My unaliving. How did she was unalived? Well, she listened to the Natalie Cochran trial and she went to a better place. Oh my days, this trial. It's gonna be one for the books for sure for the year. I just don't know. It's what in 10 past 11. We have done nothing apart from jury instructions that took 40 minutes. Oh my days. They must win the award of the most delayed tactics that ever did on a trial. That is for sure. I think they are gonna win that award for sure. 100% sure. How many times I said sure? Probably a lot. Just because I'm running out of things to talk. I mean, I was saving some of these things to talk about during Verdict Watch, but now I need to think about new stuff and new material. And it's not that easy to come up with things to talk about. And well, it is because I can talk a lot and I can talk about the most random subjects, or we can just talk about food. Now, I've got plans for throughout the Verdict Watch, as always. We can do like a recap of the case again and get your guys' opinions and theories, and I can talk about my own theory. And then if the new trials started, we're going to catch up on that. If not, we can just listen to some parole hearings while waiting and hang out. And I mean, if it is today, we'll it goes into Verdict Watch. We'll be here as long as needed. If it is
Okay,
tomorrow,
go ahead.
we'll do the same.
You previously testified that you and Tim Bledsoe, both retired troopers, were the lead investigators in the two cases, correct?
That's correct.
As part of your investigation, did you interview the defendant's children?
No, we did not.
Why not?
At the time of the investigation, and more specifically between March and June, March is when we began the investigation. June is when we executed a search warrant on the defendant's residence. During that period, we were collecting information from third-party records. We were collecting information from witnesses, from financial institutions. And there was nothing in that 3-month period to indicate that there would be a need to speak to the children. The second and most important thing was their age. They were very young at the time. One was 10 or 11 and one was 13. And we were looking at the business of the Cochrans. We were looking at the Cochrans individually. So there was no indication or any reason to speak to the children. And then the final reason we wouldn't speak to the children is we've been long taught in law enforcement and investigations that you don't speak to children under the age of 18. And there's some tolerance there with 16, 17, 18-year-olds, but you don't speak to anyone that young without a parent's permission or without an attorney present. So we would not, by normal operating procedures, have spoken to the children.
You were in the courtroom when the two children testified on behalf of the defendant, correct?
I was.
And in their testimony, they indicated to you who actually ran the company businesses.
I did hear that testimony, yes.
And what were the children saying as to who was controlling the Cochran's businesses?
The children put a lot of responsibility or.
I'm going to object to this. The jury heard the evidence. The jury can draw whatever conclusions from the children's testimony. This witness does not need to editorialize on that.
Sustained.
You're being recalled as a witness for the purpose of rebutting the testimony provided by the children. Is that
Yes.
correct? Okay. Thank you. Hand you an abstract from what's been admitted as State's Exhibit 3. Ask you to look at that as well as a second page, also an abstract of what's been admitted as State's Exhibit 3. Recognize those documents?
I do.
What are they?
These are text message communications between the defendant, Ms. Cochran, and Stephanie Hamilton.
Have those back, please. At 10:15, the defendant sends a text to Stephanie Hamilton. Can you put that in some kind of context as what's going on there?
Natalie Cochran is offering Stephanie Hamilton an opportunity to invest in a government contract dealing with medical equipment.
The document speaks for itself. Again, we don't need any editorialization as to what these documents are, what they speak of.
Could the state respond to that?
Sure.
That's not accurate. Those are statements taken and they don't say anything about a contract. It says there are two today. Two what? I think it's fair to put that in context with the witness's investigation and what he found that meant.
And for that matter, these documents do not indicate any interlocutor of Natalie Cochran. We have no idea who this is.
Well, I think we do need some explanation from the witness, and so I'll allow it. I'll overrule the objection. You may proceed, Mr. Truman.
Thank you.
Ms. Cochran is offering an opportunity to invest in two contracts or to consult on these contracts. They deal with surgical masks and betadine swabs, medical equipment. Ms. Hamilton was in the medical field.
Okay. Here's another text, and this is also a download from the defendant's phone, correct?
Yes,
And
from Ms. Hamilton's phone.
correct. And this is April 26th of 2019.
Yes.
And the defendant responds, that means next Friday is payday.
I'm going to object to this, Your Honor. This is way past Michael Cochran's death. This document is irrelevant.
What is the date on this?
The date,
Yes.
April 26th. And the purpose of this testimony is to show that the defendant continued to run the business as she had before.
I'll allow it. Overruled.
Thank you. Trying to next hand you an abstract from State's Exhibit 2. Could you identify that?
Yes.
What is it?
This is a text message between Natalie Cochran and Chris Davis on February the 6th, 2019.
Judge, I think we really need to approach the bench at this point.
All right.
Been on trial for 5 minutes and he wants already approached the bench already. This so sorry, like we're talking in chat, me and Lois, about our previous case. Oh hell, welcome back, Toxic. Oh, Toxic, you hello, you've missed the boring of nothingness. Literally, you did not miss much. You probably missed about what 5 minutes of testimony before they went back. I will DM you in a second, Toxic. But like I was saying, me and Lois were talking in chat about our previously trial, the defamation, the Zachary Young one. I think there might be some shuffle in the CNN world coming up. Yeah, so I think it is things are moving sadly not very well for the investigator of that piece that CNN did about Zachary Young, the Afghan situation, everything that we covered previously in this trial. So yeah, I think there's some moving parts. I've like even with the way the VPN to contact to the American side, sometimes I miss things. So apparently the Zach's attorney did an interview on YouTube, and I needed to put my hands out. Ooh, maybe he got overruled, sustained. I need to learn that still.
Continue, Mr. Truman.
Thank you, Honor. February 6, 2019 at 9:27. That's a text from the defendant to whom?
Chris Davis.
We'll have these marked collectively, but if you could take a review of those documents. And if I could have this marked as States 34, please.
All right.
No, this will be State's
Well, we didn't-
Exhibit number 37.
We're not going to, those weren't allowed.
These aren't allowed?
No.
These are here.
Right.
Number 35.
What's
30
the number?
34 and 35, I think. Or 35 and 30, 35 and 36.
So those are not going to be admitted?
These, well, the ones that you marked previously are not. It's this one in its stead.
Okay, well, it's going to be 36, 7, because I can't.
That's
see it.
fine, sure.
Okay. This is defendant's exhibit number 37, Your Honor.
State.
Thank
I
you.
mean, states, I'm sorry.
States 37.
Yes, sir.
Okay.
Thank you. Stage 37, marked for identification. Can you tell us what that is?
These are text messages between Natalie Cochran and Wendy Poteet.
Who's Wendy Poteet?
Wendy Poteet would be the sister of Natalie Cochran.
And how did you acquire those documents?
These documents, they're cell phone text message documents. These were recovered from Natalie Cochran's cell phone subsequent to the search warrant executed at her residence. The cell phone is given to a forensic examiner and they do an electronic download of all the data on the cell phone. And these are pages from that extract.
And that was from a search warrant?
Yes, sir.
Now, we don't necessarily have to go through all of these. Let's just put a few up here to show where this is going.
Which one is this?
4.
4.
Oops, can't get anything out of that. Once again, these are text messages between the defendant and her sister,
Yes.
and she's offering a contract.
Wendy Poteet was already a investor victim of the contracts, and she is.
We object to the characterization investment victim. We don't know anything about Ms. Poteet.
All right, that's a fair objection if you'll refrain from speaking of her as a victim, please.
Yes, Your Honor.
Continue.
Wendy Poteet was an investor, and this is reference to a contract that she is owed money on. And Ms. Cochran is advising her that she's going to be paid by certified check.
Once again,
This is a text message.
Your Honor, can we please have this identified? Which document?
number 5.
Text message, again, between Natalie Cochran and Wendy Poteet, where Natalie is offering additional contracts for Wendy to invest in on February 18th of 2019.
Now, collectively, is there a pattern emerging here in terms of the defendant's conduct of the business?
To object to this question, that's argumentative.
Or we could just go through slide by slide.
Overruled. Continue.
Is there?
These contracts were dated after the date that Michael Cochran collapsed on February 6th. So this is a continuation of these illegal business operations, the investment, the Ponzi scheme we'd spoken about. This is a continuation of those after Michael's not available.
This time for sure. Please.
This will be State's Exhibit number 38, Your Honor.
Very well.
Before I go south with these. This is one. Let me give that back. take this. Hand you what's been marked for identification as States 38, please. You recognize that?
I do. I do.
What is it?
Which number is it?
Oh, I'm sorry.
For the,
Yes. Yeah.
25.
22, 23, 10,
10.
13, 14,
Okay.
16, 19, 20, 21.
Okay, so
22,
now we're looking at 10.
collectively at the moment. But
Okay, all right.
they're not all available, but exhibits 10 through 23 or tabs 10 through 23. What is that?
These are all text messages specifically between Natalie Cochran and Michael Cochran, ranging from August of 2018 to February 5th of 2019.
5th or 6th?
These end on the 5th, February 5th of 2019.
This is page 2 of number 11. Who's that to and from?
This text message block is Natalie Cochran's text message that she has sent to Michael Cochran.
Do those numbers mean anything to you?
These are dollar amounts that she has told Michael are owed to them and their business for contract, government contracts that they have sold or obtained, been awarded would be the correct term. She's.
Are you done with that one?
You want me to finish, Mr. Truman?
Please, yes.
The date of this text was on August 27th. And with these dollar amounts, she's provided other dates in which these dollar amounts will be posting. The very first entry, 3.45 million, should post tonight at midnight. That would be on August 27th. And then there's timestamps applied to the other amounts in those texts.
13. And this one from October 25th of 18.
This is a text from Natalie Cochran to Michael Cochran where she's talking about getting off the phone with government entities, and that the audit, which was presented as a reason why none of the contracts could be paid out, she is telling him at this time that the audit is complete. There's some additional administrative stuff that needs to take place, and that all monies from all those contracts that he believed were being awarded and due will be available by Monday, October 29th.
You heard young Mr. Cochran testify about a 50 caliber contract, did you not?
I did.
This is number 14. And this is, again, a text. You recognize the phone number as to where that text is coming from?
Yes, that's Natalie Cochran's phone number.
And that the only 50 caliber order in your investigation that you saw, or were there others?
That is the only one. And this is a reference to a text again to Michael about that 50 caliber government contract order, where she is telling Michael that they, being whatever entity the contract was fulfilled with, want to double that 50 caliber order, and it would cost them $244 million and yield a return of $378 million.
This one from January 30th, 2019. Who is that one from at 334?
Again, this text is from Natalie Cochran to Michael Cochran. In this text, this is following the government shutdown, to put it in context. And she is telling Michael that they have all the money being resent tomorrow, and they should be available to them by Monday at the latest. And then the feds will begin sending money on Monday. This was dated January 30th of 2019. February 1st was the date that the investors had been told that the monies would be released post government shutdown.
There's one from the 31st.
This is, again, a text from Natalie Cochran to Michael Cochran, where she is telling him that she is on the phone with the Bank of America. And this is in reference to the monies that were supposedly inbound. And that's why she's talking with Bank of America.
I'm going to object on lack of personal knowledge.
All right, that's fair. Sustained.
As part of your investigation, did you download records indicating when the defendant was using her cell phone to make phone calls?
Yes.
Did you compare the text messagings with the downloads to see if in fact she was on the bank phone with the bank?
There were instances where she claimed to be on the phone and she wasn't. And there were instances where
Judge, I'm going to object. This is a broad. I'll withdraw that.
Okay.
Thank you. 21. What's DFAS?
DFAS is the Defense Finance Accounting Service. It's a federal government entity that deals with defense finance.
And 2 days before Michael collapsed, there's a reference to the organization you just mentioned. Who's Betsy?
Betsy was earlier referenced in testimony to Betsy Britland. Betsy was a character created by Natalie Cochran to be a government employee that she communicated with regarding government contracts on the regular. She would ask, or when asked about contracts, she had told Michael that her point of contact was Betsy Britland with DFAS or the U.S. Treasury.
That's not in the exhibit. The witness is testifying from some other unidentified documents. I object.
Overruled.
Go ahead.
So Betsy Britland, who did not exist, this is a reference to Natalie claiming to have spoken with Betsy regarding the contracts and the whereabouts of the award money that should be coming to the contracts. And this text is, again, to Michael Cochran.
22. And on 2-4 at 301. 2-4-19 at 301.
Again, this again is a text message from Natalie Cochran to Michael Cochran, assuring him that all 4 wire transfers and money deposits were en route and that they potentially could show up that day on February the 4th. And she references 4.8 regarding millions of dollars that should arrive in the morning and 23.8 million tomorrow, the next day at some time.
From your review of the text messages between the defendant and Michael Cochran, the defendant and Wendy Poteet, the defendant and the Davises, the defendant and Stephanie Hamilton, was there a pattern emerging there?
Yes, there was.
And was always deception to all of those parties, was it not?
Now the prosecutor is testifying. I object.
Fair point.
Sustained.
The text messages that we've reviewed in summary fashion, did they indicate a pattern to you?
They did.
What is that pattern?
That Michael Cochran was being told the exact same information that the investors were being told. Those who were relying on money to be paid back to them, the information that was given to them is the exact information that was being given to Michael Cochran.
And that all derived from the defendant, correct?
Yes.
Could I have just a moment, please?
Sure.
There was also reference in the defense case to Michael utilizing the defendant's phone and sending messages as a guise that it was her sending them. Do you remember that?
Yes.
Oops, I need another marker.
This is State's Exhibit number 39, Your Honor.
All right.
Thank you. And what's been marked for identification is State's 39. Ask you if you could identify that.
You want me to identify it?
What?
Yes. This is a photograph of a text message from the cell phone of Matt McCormick. It's a text message stream between Matt McCormick and Michael Cochran.
What time is the text message from Michael Cochran?
There are 2 dates here. Do you want?
The second one.
On February 6th at 1:39 p.m., there is a text message that was sent from.
I'm going to object to this. This has nothing to do with my client's statement. This is hearsay.
We don't think so.
This is a statement between 2 third parties. One is dead, the other one is a third party.
Care to respond, Mr. Truman?
Yes, sir. This is a text from Michael Cochran's phone when all the evidence says Michael Cochran was totally unconscious and lying on a couch.
I'll allow it. Overruled. Go ahead.
This is a text message at 1:39 p.m. from Michael Cochran's phone to Matt McCormick's phone, in which he is telling Mr. McCormick that he would be available to see him in a few days, reference a firearms transaction.
From your investigation and from all the evidence to date, is there any possible way that Michael Cochran could have sent that text?
No, not at 1:39 p.m.
Why not?
We have a timestamped photograph taken by Natalie Cochran at approximately 12:30 of Michael Cochran laying on the floor at their residence. And then soon after, we have witness testimony of individuals at their house with him in his unresponsive state during that time frame.
Your Honor, at this point, the state moves into evidence. I can't remember the numbers. Is it 37, 8, and 9?
37, 38, and 39.
Please.
And I'll preserve the defense objections previously made. Are there further objections that you wish to place on the record?
No, Your Honor, to all of which I do object.
All right, I'm going to admit states exhibits 37, 38, and 39 over the defense objections.
Your Honor, the state has no further questions.
All right, cross-examination, Mr. Victor.
Mr. Heinzman, the purpose of your testimony here today is to demonstrate that Michael Cochran, and this is an old story, was duped by my client, Natalie Cochran, and didn't know anything about these contracts, right?
Yes.
Now, and for that matter, the other message there that you are telling the jury about is that Natalie Cochran was involved in the illicit business of contracts. Is that right?
Yes, that's correct.
Would you agree with me, sir, that throughout this trial, as you were sitting here, we have conceded that Natalie Cochran was a bad girl and she was dealing in those federal contracts? Did we concede it or not?
Did you concede to it? I don't know who we is.
Listen carefully. Is it true that Natalie Cochran has conceded that she was involved in the fraudulent scheme?
Yes, she did.
So that shouldn't be any surprise for you when you look at all these documents. That she is involved in these transactions.
The purpose of my testimony was to illustrate that Michael Cochran was not involved in the illicit transaction.
Michael Cochran wasn't involved in it. All right. I'm going to ask you if I can do this. Looking at one of the examples. I do not recall which number it was. I think it's somewhere around 5 or 6. But you testified about this document, didn't you?
Yes, I did.
That document was telling you that on August the 30th, and I presume 2018, $1.2 million was going to be posted, right? See it there?
On August 30th, yes.
Yeah. Posted in the account of Mr. and Mrs. Cochran, right?
Yes.
Then on September the 3rd, $724,000 was going to be posted. May not be the 3rd because it's going to be a holiday, but it was going to be posted in the Cochran's account, right?
Yes.
And then $2.56 million next Friday was going to be posted in their account, right?
Yes.
Well, comes August 28th, no money in the account, right?
Correct.
Comes August 29th, no money in the account.
Correct.
Comes the end of September, no money in the account, right? Right?
Yes.
Yes. Well, that $2.6 million next Friday, so that's probably sometime, I don't know, sometime at the beginning of September, right? No $2.6 million coming.
Correct.
And Mr. Cochran doesn't know that? He is waiting for about $4 million, right? Right?
The last date put out on these is December. So between August 27th and December, it was over $300 million that he was
I
told
asked
was
you
due.
about these numbers. 300,000, $1.2 million, $724,000, $2.6 million. There's nothing about December there, is there?
December 21st on the next one down. 12/21, $131 million on 12/21.
I didn't ask you about that, sir. I asked you about the top,
Okay,
the exhibit. There's about $4 million coming to Michael Cochran, to his account, right?
to the business. Yes,
To the business where Michael Cochran is a minority owner, right?
no,
To the business where he has a joint account, right? Yes, sir. Yes or no?
yes.
Yes. $4 million coming to my account, and I don't know anything about it.
That is correct. Well,
And
he knows what's been told to him here
Okay.
about the
Well,
full million.
fine. Then let me ask you this. We are now at the beginning of October. That $4 million didn't materialize itself. He is not asking questions, is he?
He absolutely is. The defendant had
is?
produced an audit
Show me in
ruse,
any of these documents, sir.
an audit
When-
ruse.
Show me any of these documents, these exhibits. When he is asking any questions about where is that $4 million?
We have.
Where is that $4 million? Show me any of these documents here that were admitted into the evidence, not some stuff about we did our investigation. Show me in any of these documents.
If you'll hand the documents back, I'll review them to see if I can find that.
You can review them all you want.
But I know that throughout the text messages that were reviewed, 1,224 pages of text messages or
I don't care about this.
numerous times that Mr.
Show me-
Cochran
show the
asked
jury.
where the
Mr.
money
Heinzman,
was.
Mr. Heinzman, there's no question pending. I'm asking you to show this jury from these documents that Michael doesn't know, that Michael somehow is not surprised that the $4 million that was supposed to come to him at the beginning of September is not there. Show me.
He had been
Show
told
the
it
jury.
wasn't coming because of an
No,
audit.
No, sir. You look at these documents, show me if there is anything in these documents that indicate that Michael Cochran is or is not surprised by not getting $4 million.
Your Honor, do me take the time to review all these documents?
Well, if you can, go ahead, Mr. Heinzman.
I'll move quickly.
All right.
And I'm looking specifically for where is that $4 million that was supposed to come in September?
Would you restate your question?
Well, show me in any of these documents when Michael Cochran is asking Natalie or anybody for that matter, where is that $4 million or, well, 300,000, 3.4, well, there's more than that. 300,000, $1.2 million, $724,000, and $2.56 million. Where is it? It was supposed to be deposited. Now it's September, it's October, it's November. Where on earth is that money? Show me any of these documents indicating his inquiry about that.
Okay, on page 19, he's referencing the 1.6 million, having to wait for that. On
Okay.
page 20, when she says she's on the phone with Bank of America, he's asking, are we 1,000%? Because she's told him at that point that the money is at Bank of America.
Okay.
On page 21, he says, this is February 4th, the day that 3 days after he expected the money, he tells her that the money isn't there. She provides additional excuses for that. And then on page 22, dated February 4th again, she's telling him that the 88 million and 297 million will possibly show up today.
No, she's telling him.
4.8 million in the morning and 23.8 tomorrow. Again, another delay, and his response is shit.
All right. Okay. Show me.
You want me to go through the rest of the documents?
Hold on. Show me when there is going to be $108 million to be deposited in the account on October the 12th.
It's right there on August 27th on the text that's being provided.
And $131 million to be deposited in November and in December.
Yes, it's right there on the text.
And he doesn't know that this money ain't there?
No, he does. He believes this money is coming. What's significant about August 27th?
No, I didn't ask you. You seriously?
I can explain.
Hold on, sir.
Okay.
Are you seriously contending before this jury that he doesn't know that that $239 million is not there?
I'm telling
Yes or
this
no,
jury
sir?
that
Yes
Michael
or no?
Cochran does not know.
Yes or
because
no,
he
Your
believes
Honor?
that money is coming.
Your Honor, I'm sorry. It's a yes or no.
Well, he's trying to explain, and I think we should let the witness explain his answer. Go ahead, Mr. Heinzman.
Michael Cochran has been led to believe that all this money is coming to their accounts for government contracts, and it never comes.
And I presume that in September, October, November, December, and January, he lives in the same household as Natalie Cochran, right?
He does, yes.
He certainly doesn't live on another planet. He can talk to Natalie Cochran about these contracts on a daily basis. He can talk to her, can he not?
Yeah, he does.
And he does. And he, on August 20, whenever, September, honey, where's that $8 million or $4 million? And she's lying to him, right? Is that your testimony?
And she says, we're getting hit with an audit. Can you believe it?
On September 5th, she's telling him, oh, no, that money is coming, right? On September 6th, 7th, 8th, 30th, October, he is somehow duped by it, and he's so blind to it that he will not ask his wife, where is $238 million? And he naively and blindly believes that this money is going to be there and it ain't there? Is that what you're testifying to, Detective?
Absolutely.
All right. Show me. There is nothing in these documents that talks about Michael's computer. Is there? Michael
not in these documents.
Arranging for these contracts on his computer as he's sitting in the bedroom while Natalie is watching TV and the kid is between them. Those documents don't deal with any computer operations of Michael Cochran, right?
No, they do not.
Okay. Those documents did not deal with any personal contacts that Michael Cochran had with the investors, including his own mother, correct?
These documents do not.
These documents do not deal with any checks that he wrote, as we saw in some of the exhibits here, on behalf of the companies, correct?
Correct.
For either services rendered or for consulting services, etc., right? These
Correct.
documents don't show that. These documents don't, oh, well, these documents do not address any issues that, well, the detectives are coming and, maybe they should talk to the kids. Is there anything about that anywhere?
No, that wouldn't be anything like that.
All right. These documents, of course, do not deal, again, in the same old story, with the lifestyle of the Cochrans, right?
These documents do not.
Honey, I'm taking you to Paris and I'm going to get you a Louis Vuitton bag for God only knows how many thousands of dollars because we have somebody else's money to live high on a hog, right? These documents don't deal with this, do they?
Not that depiction, no.
No, not that depiction. Well, they don't talk about any of the wealth that the Cochrans, plural, have acquired through the illegal schemes and enjoyed for a long time, right?
These documents do not.
These documents don't deal with anything about Michael Cochran's health. Honey, I feel bad today, I'm declining, or anything of that nature.
There are references to him being stressed because of the lack of money.
He is stressed because he doesn't know.
In these documents I'm referring to.
He's like in a National Enquirer. We want to know, right? He wants to know, right?
He wants to know where the money is that they've earned.
wants to know.
Through what he believed was legitimately awarded government
Right.
contracts.
And yet he goes to a boat sale and buys himself 2 boats at the same time, right?
I don't know if he went to a boat sale. I know that he did purchase ATVs, boats, vehicles,
Right.
things of that nature that both he and his wife picked out based on text messages we read, or by her encouragement to make purchases because she had led him to believe that they had all
Sure,
this
she let him
wealth.
believe. And you truly believe it.
Absolutely.
All right. These documents do not show, these documents that deal with Natalie only, not Michael, whether he was copied on them. Do they?
So would you ask that again?
No, you look at any of these documents where Natalie is talking to Miss Petite or Chris Davis, where Mr. Cochran is not involved. Is there any indication that he is copied on those conversations?
Some of them, yes.
Yeah. So some of this he knows, right?
Some of it, but
Yeah.
not in this context that you're framing it.
Not in this context, of course. Okay. Now, when he talks on some of those messages, the jury will probably see that those conversations take place after Michael's death, right?
Yes.
So he cannot contract anything, Mr. Heinzman, because unfortunately he's passed away, right? Right?
Yes.
And Natalie Cochran is continuing the scheme that she was involved in, but it has nothing to do with what Michael knew and what he didn't know because he's dead. Right?
No, it supports the fact that it was her scheme because she continued it on.
Well, one of those exhibits, Michael asked, no, 16. Michael asked directly to pull out $9,500. From where?
From their personal account
To do what with it?
to have some cash on hand.
And that $9,500 came from where? They didn't have any income, independent income. That must have come from the investors, right?
That or rescue loans.
Well, is it possible that since they have no income, independent income, you testified that Natalie wasn't working as a pharmacist anymore, and Michael's job was an IT man, not really defined, that he's pulling $9,500 in cash that must have come from the investors, right?
Yes,
So he pulls $9,500 that he considers money earned, right?
from previous contracts.
If
Yes,
he believes that, if he's so scrupulously honest, well, he must believe that this is the money that they've already earned on those contracts, right?
right. He's not aware that there are illicit proceeds. He thinks they're legitimate proceeds.
Right.
Right.
What does $9,500 tell you as an investigator of money laundering?
Well, that
Cash. I'm going to ask 9,500 cash. What does that tell you? You're the expert here on money laundering.
Sure. In this context, it means nothing. In the context that you're framing it, it references currency transaction reports. Those are a federal requirement under the Bank Secrecy Act.
Well, let me ask you
Where-
this. Let me ask you this.
Yeah.
Well, I'll ask a very specific question.
Well, the witness should be permitted to answer. Go
Explain
ahead,
the
Mr.
$10,000
Hines.
cash.
The Bank Secrecy Act requires financial institutions to file what's called a currency transaction report for any transaction involving $10,000 of U.S. currency, that'd be cash or coin, in or out of a financial institution. It is a derivative of the Patriot Act and the war on terrorism, so they want to track large amounts of cash. So if a withdrawal from a financial institution were to occur above $10,000, the bank would be required to complete a currency transaction report and document that transaction. In this case, however.
Well, I'm
the
sorry.
Cochrans
Now
had
let me,
cash
I'm
inside
sorry.
a
I'm sorry,
safe.
Your Honor.
Okay,
Now the question is this.
fair enough. He's answered the question. Go ahead, Mr. Victor.
$9,500 in cash is obviously under 10 grand, right?
It is.
And he withdraws that amount of money in cash, right?
Yes.
Would you agree with me that he does that for the purpose to avoid the $10,000 money reporting necessity?
No, I would not.
No?
That's not illegal. It's not an illegal act. It's when that is anything 10,000 or more is
Right.
taken out in multiple increments over a short period of time. That would then trigger what's called a suspicious activity report
Right.
with the bank that ties back into the currency transaction report.
And
So
that's why-
that amount alone is not illegal.
And that's why he's taking $9,500 rather than 10,000, because he would have to report it to the IRS.
Your Honor, that's speculation. There's no way the
Wow.
witness could read the
Sustain.
defendant.
All right. What about those income tax returns that the parties filed jointly?
Those were prepared by Natalie Cochran. They were false documents.
They were false documents.
Yes.
And he signed off on them.
There was no signature by Michael on the documents.
For 2017,
No, there was not.
2018,
No, there was not.
2019.
No, there was not.
And you're telling this court that she filed taxes and he didn't know anything about the income tax returns.
That's correct.
So he himself broke the law by not filing income tax.
If he had known what was being filed,
If he had known, he would have filed taxes.
no, if he had known what was being filed.
Okay. So he didn't have to sign the income tax return because his income was zero? Why didn't he have to file income tax return with Natalie?
I'm not saying he didn't have to,
Why didn't he sign those?
because they're done electronically now. You don't even have to sign them. One person could fill them out and file them electronically. He doesn't have to sign it. Now, the law requires that all tax preparers review their documents that they're filing, but
And he reviewed them and he had absolutely no idea what Natalie was doing with the taxes and with the bank losses and with, well, the business losses, the business gains, et cetera, et cetera.
I have no idea if he reviewed them. If he had, he would further believe that he had made an extraordinary amount of money on
Show me-
government contracts.
Show me here any income tax return that lists about $4 million by the Cochrans. Can you do that? Can you show this jury? Any-
No, I
any-
cannot. I don't have the discovery files and records with me to break
From
out to break out the tax returns that we did recover.
From your thorough investigation of this case, because you said that several times, was there ever an income tax return filed by the Cochrans that would list $239 million? Can you tell the jury that?
I know that there are tax documents that were given as ruses to get bank loans.
From your memory, Mr. Heinz.
But I cannot say if that figure that Mr. Victor has given me matches those documents.
$239 million. Would that raise some red flags if you ever saw an income tax return from a small West Virginia company filed with the Internal Revenue Service? Would that cause you to pause and consider that?
In what context?
Well, somebody's making $239 million from a business and files that income tax return. I would like to know the details of it.
Are you talking about the IRS would want to know the details, or?
Well, you were investigating their.
I've already answered that question. If I saw that, it's another prop. It's a ruse. It's not unsubstantiated by financial records, income records, state databases, federal databases. It would just, to me, that if I saw that.
So you have
it would
no
be another
idea.
prop.
So you have no idea as you sit here today to tell this jury how much money Mr. and Mrs. Cochran were making and how much money they were reporting. True? As you sit here right now. Can you or can you not?
It's a very broad question.
Well, how much money did they make in 2018? Can you tell this jury whether they made millions or whether they made a couple of $1,000s here and there?
2018.
Yeah.
Are we talking about legal income or illegal income?
Income tax return. Remember?
The income tax returns that we reviewed were submitted not to the IRS because that would have got red flags, but to people that they wanted to borrow money for to demonstrate the value of the company.
So now you're telling us that Natalie didn't file income tax in 2018?
My recollection was that there had not been income taxes. No, let me correct that. The income tax documents that we recovered had been doctored to show greater income because they were used for other purposes. The actual income tax that was filed, which presumably would have been legitimate, we did not review.
I see. Now, okay, if I may have a second. I don't think I have any more questions of this witness.
All right, redirect Mr. Truman.
Nothing to state, Your Honor. Thank you.
Very well. Mr. Heinzman, you may step down, sir.
Thank you, Your Honor. Copies or exhibits?
I think we've got the exhibits spread all around. Let's make sure that we collect them. Give everything to the clerk and she can sort them.
Okay. We've got them, Your Honor.
Okay.
It's part of, it fell off.
Part of it.
It fell off.
If it's a copy, no, I don't need it.
This fell off of here. That's part of 38.
Let me inquire, Mr. Truman, will there be further witnesses in rebuttal?
Your Honor, the state reps.
All right, will the defense have any rebuttal evidence? Certainly.
The defense rests likewise.
All right, members of the jury, you've heard it from the lawyers themselves. This is the completion of all the evidence to be presented before you. The next phase of the case will be the instructions of the law by the court. I will read the instructions to you. That's one thing that we have been working on to try to get a leg up and get ahead of the game, so to speak. We've pretty much settled on the instructions, and so we should be ready to go this afternoon. We've worked into the traditional lunch hour, and so be back in your jury room at 1:30. That'll give you a little extra time for lunch. We will commence hopefully with instructions at that time and argument of counsel thereafter. So although we are winding down and although we have completed the presentation of the evidence before you, the case is not over. It would be improper for you to discuss the case among yourselves or with anyone else at this time. Please enjoy your lunch. Do not do any research. Do not read anything online in the newspaper or on TV, and be back, please, in your jury room a little bit before 1:30. You may go with the bailiff now to your jury room. All right, Mr. Truman, I'm hopeful that you can have a working lunch and maybe go through the charge while you eat your sandwich.
I'll take care of, yes, I'm on page 8.
I
Okay.
have them done.
All right. Thank you.
So far, there's only been a couple little things to check on.
All right. Maybe we can come back at 1:15, so we'll have 15 minutes to make
Yeah.
any corrections.
I think that should do it.
All right, and then
From a
we
safe
can
perspective.
start out on time. I don't want to delay the jury anymore if we can help it. Is there anything further on behalf of the defense that we need to discuss?
No, Your Honor. Thank you.
All right, we'll break for lunch, and if you can, be back at 1:15 so we can take up the instructions further.
All right, so there you go. We might be on verdict watch this afternoon. So what's gonna happen that we are resolving this? They're gonna be back in an hour. We'll talk a little bit about this case, and then we're gonna have a break as well to have some food and regain energy, because we might have a long day ahead of us, guys. So I will be live until the court goes home. If we are on verdict watch this afternoon, we will be on verdict watch this afternoon. I've got some plans that we can do during verdict watch. Everything is set up on my side. I can be online and on stream as long as necessary for verdict watch. We'll be here for every step of the way today, tomorrow, for this trial until the last gavel that the judge will do. Very interesting. I was not expecting that closings would be today. I was prepared of the judge saying, that's it, we're going to break up here for today. Tomorrow we'll pick up with closings and then deliberations. But no, he surprised us with the fact that we are going into closings. Attorneys are going to have a working lunch to make sure that their closings are done, and the very high possibility of the closings happening this afternoon and then a verdict watch. It is very, very, very excited. I am excited to see the conclusion of this trial, to move on to big, better trials. No, I'm joking. But to finally find out what happens. It's been a long one, been a long trial. For certain, it's been a very interesting trial. I'm very interested that the judge did not say what they were gonna have for lunch. Now we're gonna wonder. I think we can place bets and then also I don't know. But it just was a very interesting morning. Very boring in the beginning. They took a while to actually get it started and get going. But when they did, they did. The only witness we had today was the lead investigator from the state's rebuttal case. That he testified that about some stuff that probably doesn't matter to anyone anyway. No, I'm joking. But that was the rebuttal case that the state had, because he was talking about the kids and their testimony and why they did not ask the kids any questions at the time, because you would not imagine that a 13-year-old or a 10-year-old would know anything about federal cases or anything. So figures why this ones know. But anyway, this is an interesting family. So again, like I said, what we're gonna do is we're gonna take a lunch break, me and I, but we're gonna have some food and enjoy maybe just a little bit of chillax stacks, and then we are gonna we'll come back a little bit earlier than the court comes back, so we might come back at 1 on the dot, then have a 15-minute chat and see what's going on. I'm going to do some investigation about our next trial to see if there's any news, any new information, if they're still on jury selection. It's been taking a while. I did call the courthouse, sorry, and the lady that I got to talk, she did say they was still in jury selection, which is rather interesting. So that gives me something. I also heard that it is going to be live streamed on YouTube, but again, I got our information from Reddit, so I am not 100% sure how I believe that information coming out from Reddit. No one ever knows. So we'll figure it out what happens then. If not, we might have another solution. We might have another trial to jump straight back on. Otherwise, we'll see. But we're gonna do that. We leave this one. This stream will stay up. I normally tend to always leave the stream up. You can hang out in chat. We can chat a little bit while on break and everything. But I do need to have my dinner and have some food as well. And you guys need to have your food. Take advantage. Stretch a little bit. Walk if you can. Go outside. Just catch a bit of fresh air. Just walk like I do around the house. And yeah. Anyway, I'll see you guys in 40 minutes and I'll see you all soon. Thank you very much. But don't worry, the stream is gonna stay up. Don't go anywhere. Hello, everyone, and welcome back. I am back, and we are back from lunch. Hope all your lunch was nice. What did you guys had? I am a bit noisy. I had, which I know it is going to be sound, but it's one of my favorite kind of Portuguese dish. It was it seems very like simple, and it's I actually really like this. I beg Nightbot to have this almost every single time. And it was very simple. It's just rice and a scrambled egg, which a little bit too much salt maybe, but that's one of my favorite dinners, and that's what I had today. While Nightbot had some leftover of lasagna that finally finished, so that was my dinner. What was yours? Let me know down if you want. If you want to know, if you want to tell me, not to want to know. So in terms of this afternoon, we are expecting closings to start. I am setting up the stopwatch that we are going to be available to have. In terms of this, I do need to learn how to maybe make it a bit different, but it is ready. I just have to press OK and add the camera to the stage in terms of the OBS that connects to the StreamYard. That's the way that I found that it works, and then we can go from there and actually have a clock for the verdict watch. During verdict watch, there's still no news about our new case, the Colin Griffith. We are gonna follow if there is a link, if there is a feed for sure. I'm hoping. I'm starting to get a little bit nervous. No, I'm not gonna lie on that, because why is jury selections taking so long on this case? I don't understand. I know it is like a bit hard to find juries that maybe not have heard about this case, because I think apparently this case has been a very high profile case in the area and very talked about. So probably they are struggling to get an impartial jury, but I'm sure they're gonna get something. They expect the openings now to be tomorrow morning, the latest. So which would be good, because if this trial finishes today with the verdict and everything, we can just pick the new one right back up tomorrow, because everything is ready. Thumbnail is ready. Everything is ready. It's just not knowing if there's actually going to be a feed for it. I keep searching high and low on the YouTubes and everywhere that I know where to find information about cases. And I even asked a friend that is over in the US to try to find some information for me if I could not get over here. But she still says that there's nothing much going on at the moment. There is no news, no press releases, no nothing. So it is, well, not on my side. I did call, I don't know if you heard, but I did call the courthouse earlier, and the lady said that they're still in jury selections. So yeah, all the big channels that cover trials, that we all know, the usual ones, they are talking a lot and creating a lot of buzz about this trial. So I'm imagining that they have said that they are gonna live stream. I think one said there's gonna be definitely live stream. I've seen that, but where, it is my question, because we know that they sometimes live stream in two places. They either live stream on their website and not on YouTube, or they do on YouTube and not on their website, which I am a bit scared that they're gonna do on the website and not on YouTube. Because if it is on a website, it's only going to be snippets of the case, which I am not 100% happy with that. So I keep checking to see if they're gonna do. There is another trial that started in Massachusetts, the same courtroom, I think, that oh, Karen Reed was, and I think they are live streaming all of it. Because you can see the witnesses and everything. I'm actually like watching it right now, and I think it is in the same courtroom and everything. I haven't seen who is the judge. I'm hoping they pan out to the judge soon to see. But because earlier, we were on the on court, while we were on court, I was doing some research, and I stumbled upon again their website, and I did see some. Uh, yes, it is Judge Bev. She is in that new trial, the Penelope McGee um trial. So yeah, that is a Judge Bev trial. I don't know if there's gonna be available for after though, because if not, in the case of Colin Griffith doesn't come to fruition, we could try pick this case up, because that could be a new one, because here just Judge Beth again. Yeah, I know. It's it is her courtroom. I'm trying to see if I can do something to see if there is if I know even know how to spell Penelope. Penelope, yeah. McGee. Let me see if there's anyone live streaming. Oh, well, they no, not there. Interesting. Not really no one. But they have the opening statements there, but I don't know, because court TV, it's very weird how they do the live stream sometimes on their websites, so it's just a bit hard to understand and navigate that. Hopefully Colin Griffith, it's not going to be like that. I am still stalking the thing. Still no news. No. I don't like that they started doing ads. Oh, hang on. There's another collaboration between those two. The Scripps News Fort Myers. Okay, I need to that website, because they might be live streaming the case as well on YouTube. I found another possible yeah, possible feed for. So let me see, is it four? Yeah. From where? Southwest Florida. There we go. Sorry, I'm trying to do a bit of research while we are waiting on court, and while people get back to the stream. The last time their live stream was 5 months ago, so there's not really a big hope. I mean, I'll keep an eye on it. Well, it's my. Yeah, I'll subscribe to that channel, just if it does get some information, we can just jump on that if there is. Actually, while I'm here, let me see if they have any update on the jury selection. If they're any information on Florida Panthers TV listings, know what to do. Ooh, watch now what they are doing. Can I yeah, no, I cannot watch because I'm not in the US and I don't have my VPN on, so I can't watch that. So that is okay. So if we go back to the Core TV website, we can do some more investigation there. But I don't think there is nothing in terms of jury being selected. Otherwise, there would have been more information on it. Let me see if there's, because this was updated this morning. So more. Yeah, it is jury selection and well, let's see if there says any more information on anything, because yeah, no, it's still underway. There's still no news, so just trying to find some more information on our upcoming trial, trying to see if it's actually gonna be available to watch. So anyway, we're just waiting on court to start. They have 1 minute to start, to be on time for us to be doing the live stream, because the judge did say to try to get back to 1:15, which is in a minute. Sorry, I'm trying to find something. So if they don't come back in a minute, well, in 2 minutes, really, it's the live stream is not gonna happen, and we'll see whenever it will. 1 second. So this afternoon, we are expecting to carry on with the trial. Closings. We are very likely have closings in this trial, and hopefully the judge is gonna allow an hour each side, because so if he would allow an hour each side, I mean, half one, half two, half three, half an hour for instructions. That means about 4 o'clock they would start deliberating. I don't know how this judge is going to do, if he's going to allow them to deliberate a lot today, or they're going to do closings, jury instructions, and then in the morning they as soon as they come in, they go into jury deliberations, and then go from there, because that is going to be the interesting. If it is, if we're going into jury deliberations, and then how long it is he going to allow the jury to deliberate for? Is he going to allow to at least make a head start on it? Or is he allowed just an hour and then interrupt the deliberations, interrupt for the night, and then go? Or is he gonna let them deliberate along? What do you guys think? Because I want to know. I was like, I am ready for whatever. We can be in deliberations all night today, or all day tomorrow. For me, I'll be here for whatever it might be. But it's just about a bit interesting to see what the judge, because I'm not seeing him allowing more than an hour for each side to do their closing, and then half an hour for the jury instructions. That's what I'm thinking, because then the prosecution is going to have two closings if they decide to do, but that will come out of their grand total of a slotted time that the judge is going to give them. So we'll see what happens, I guess. I mean, we can speculate, and that's what we do. We speculate a lot in this trial. And then we'll see what happens and see who's wrong and who's right. So it's just an idea. And in terms of how long do you think that the jury is going to deliberate, I might do when we are throughout closings, I might do some polls and ask about how long the jury will deliberate, what do you think the outcome of the trial is going to be, and so forth and so on, to try to keep a little bit engaged with you all, and kind of see where you are as well, because it's actually quite interesting to me to know what you guys are thinking about this case and how you think it's gonna end up. And then, like, we all have different opinions and we all think differently, so we'll see what happens. And as soon as there is any news as well about the other case, I will let you know and see what happens. Because oh yeah, I'm me talking and they are officially late. So but the judge did say they're gonna try to come in for 1:15, but because I want them to be late, they are late. So but it's just very, very interesting that we are following this case, in this another case that is coming to an end. It's good. I like when cases come to an end, because after a little bit I get a bit sick of the same defendants, and sometimes they just get to you when they're not the greatest. And then it's like this case, and I'm ready for our next case, because I've been doing so much investigation, I've been stalking so much about the other case, that I just want the other case. Sorry, but yeah, we'll see. But we definitely have a lot. Oh, actually, talking about that, I need to update our spreadsheet, because the defense rested today in this case, and I need to make sure that I put how long that the defense did the case for, so I can still keep an eye on that information. So let me try to do this without ruin the OBS thing, because I have. Oh no, it opened everything. What all my days? What did I do? What did I do? Uh-oh. Me trying to do something. I've opened everything, a bunch of files on my computer. Good thing I was not screen sharing, I guess. Um, let's see if this is how very good I am at this thing. There we go. Where is our spreadsheet? Oh, why can I not see? You know what? I thought that getting a Mac was gonna be like really good, and it is a good computer. I really like it, but sometimes it just annoys me a little bit. It's just so different than not like a Windows computer, and it just drives me up the wall sometimes. Let me see if I do it this way. It will let me open the file. Yes, it does. See, I don't understand how the other way doesn't work. Oh, honestly, sometimes. Okay, so defense started their case was Thursday, correct? I think it was Thursday. So Thursday into yesterday, and yesterday was 2 days. So they had a 2 day. Okay, so if you don't know, what I'm doing is, because we are following several cases, well, following all the cases that we follow in terms of the trial from gavel to gavel, I'm putting them on a spreadsheet with all the information about the victim, about the defendant, the relation that he had to the defendant, the type of case, because we cover both criminal and civil, and then we have the verdict, we have the sentence when it comes to it, and then we have notes about like little abbreviation what happened about the case, and then I've got the gender of the defendant and the victim, and then the state, because then I want to see which state we cover the most, and then something but more specific, like the length of the verdict, that is going to give us an average of hours of how long the juries across the certain period of time were deliberating, and then it's going to be how long the case of the state, now how long of the case of the defense, and then another thing just for fun and hilarious is if they are on time or not, which this trial already had a big fat name next to their name because they are never on time. So that's just something that we're doing and try to keep on track. I am going to try to share this spreadsheet in the link tree link, but I still figuring it out a way to do it, because every trial that we cover, it's going to have new information in, especially at the end. So either I upload every time that a case finishes and you have the most update and I take the older version, or then we're just gonna have a lot of documents there. So right now I'll drop the link of the link tree in chat, because link tree right now on there we have the timeline I've created for a new case. So that's why I'm so excited about that case that I even created the timeline and everything for it. So I'm just I feel like I am a stalker on that case, because it's absolutely like hilarious how I look like a stalker. Because I'm stalking all the news channels. I'm stalking X. Oh my days! I'm literally going everywhere to try find information about this case, and I just cannot wait. But the thing is, it's not going to be like that long of a case. I think it's like this week. It's not a long case either. So I oh I don't even know why is they taking so long to select a jury. So I just, there was a new news article that came out in a website, so I'm just kind of literally read through very quickly. Yeah, no, it's just saying that the jury selection for this case began Monday. There is a lot of interest in this case. I'm not going to lie to you. So it might be a bigger case than we were thinking it is. Just bear with me, guys. Like, court is late again. This court has never been on time ever throughout this whole ordeal, and it was nice when like we could catch up and we could skip all of these parts like we did in the beginning of the trial, but sadly right now we have to endure the live uh feed situation on this one. um so yeah, so Nightbot will be here in a minute. He's just I think he's finishing printing something, a new model or something. I don't know. Don't ask me. He did told me, but probably I forgot. Oh my days. I'm still hunting down Twitter or X or you whatever you want to call it for any information about the case. I yeah. Oop, there's two replies there. Hang on. No, it's just hey, oh, you finished. Okay, all right. So I'm here. I'm still gonna talk, but I just have to turn off the camera for a minute because he's coming down the stairs, and I can't wait for me to move places, so I don't have to do this every time he wants to come down. And I'm back again. Sorry about that. So Nightbot is passed. Well, it's not passed away. It's just passed throughout behind me. So I was gonna say tomorrow morning we're actually gonna change some stuff in our living room where I am at the moment, and I'm gonna be in a corner, in that corner over there of the room, which I will be out of the way of everybody and out of the way of Nightbot, so you can just move a little bit more freely. So hopefully we are gonna do that tomorrow morning, and then I will still be streaming in the afternoon. I'm able to set up everything rather quickly. In the stream when we move areas, and then we can be in a way that I don't have to turn off the camera all the time anymore. So yay. We're still waiting on court. Now they're supposed to be back at half past, so we'll see what happens if they actually have back at half past. The last few times they haven't. It's just crazy how some courts and some judges are like strictly on time and you cannot be a minute late or anything, and that's how the court runs. And then another ones are just so laid back, and they can basically do whatever they want to do. um and they can just be as late as they want. I understand it is not easy to prepare maybe closing arguments during lunch, but that's probably something you already have to kind of be prepared for and prepare throughout either the trial or even have it prepare like a script or a guidance like how you want it to go, because they can happen at any time and the court cannot keep postponing and saying I will come back tomorrow for it, and not because I'm sure there is at the trials the trials ongoing in West Virginia. I'm sure that Natalie is not the only one that has done an horrendous crime that needs to be brought to trial. So I'm sure there is other court cases to go before a judge. I'm not saying this judge because apparently case one was actually saying in chat that um the this judge, sorry, got out of retirement to come and do this trial, which is actually rather interesting that that happened. And I'm just interesting that they may have a lack of, is it criminal judges, is it what's going on in West Virginia that they don't have enough judges, that one has to come out of retirement and pay for lunch for everyone, and just that. So well, we have a minute to go until when they are supposed to arrive. Give me one moment and just to have a bit of a drink because I've been talking for a hot minute. So yeah, so they are supposed to be back in a minute. See if they actually come back on time. If they come back on time, you know the deal. We'll do a 24-hour live stream. Hopefully they won't come back on time. No, I'm joking. I keep saying this, but I'm gonna have to end up doing. They are gonna come back on time one time, just to get me to do a 24-hour live stream, which is absolutely amazing. So it's just, yeah, I don't want to, but if I have to, I will, because I keep promising that if we do go on, if they come back on time, we do a 24-hour live stream. Just notifications after notifications, but not the notification I want saying that the jury is being selected and the closings are happening and there is a feed for a new trial. When you become obsessed with something, it's just so hard when there is nothing on it about it, you know. It's just you keep seeing the same. Hello. Oh, okay. Oh, okay. Is it that the first one since there's been a new president and court is late, so no 24 live stream so far. Okay, yeah, no, it's fine. Only no lowest court. This court is always late, so probably by the time the press briefing is finished, court will be back. Probably they want to see as well. They want to watch it as well, and they are all in the back, curled in the huddle, watching the press briefing. For all we know, so we just sit here and wait, and yeah, keep waiting and waiting, and I've run out of things to talk about unless someone help me, because not. Yeah, drones, because there is apparently a whole situation in, I want to say, New York, New Jersey area, that has been some drones flying over that area identified, and people have been wondering what it is, and it's a whole thing. It's been quite a whole thing, a massive thing that caught up a lot of media attention and people's attention, and well, Lois is wondering if there's any updates on that, because apparently all of a sudden all the drones disappeared, everything stopped, and it's not happening so anymore. So it's just that, I think that is, correct me if I'm wrong, but probably I am. Again, there is high possibility that it is. I'm just stalking again the. Oh, I thought I heard something in the background. Probably was Nightbot. I'm just talking at the same websites again to see if there's any updates on this trial. I'm starting to get a little bit impatient. Oh, there's a notification. No, yeah, no. Um, yeah, I don't know. I've seen videos, blowers, about that actually. About a lot of drones in a specific area, in a small area, and then they disappeared, and no one has really talked about that since. But I don't know. It's like it is a bit mysterious and a bit odd. Like, I'm not gonna lie, that it is very odd that was happening and everything. So yeah, we'll see what happens. Court is officially late, 3 minutes again, at least for now, at the moment that they are. It's just crazy. Again, I was talking earlier, and I don't understand how some courts can just get away and being always late, and it's so unreliable, especially when you're dealing with matters of this importance. And it's just like, I know we joke around that Natalie is Natalie and she is what it is and everything, but also she has the right of the speedy trial and a concurrent trial, and I don't with this thing. Um, ooh. Well, I think they all know that, Lois. I think they all know how to say a lot of words, nice words, and then end up saying nothing. I think that's almost any politician or anyone in politics for that matter that knows how to say a lot of words without saying any information, or even saying less than no information. Somehow they can do that. But then again, don't quote me on that. Politics is not my forte. And yeah, so I'm just gonna try to do something else, because to see uh if the trial has started or not. So I don't know, they have that specific thing. They can say a lot of things but actually not saying anything. um is a rather very good talent that they do have it. Anyway, we are currently waiting still on the trial to start. It's still a mystery of where everyone is. I think they must have been stuck with the sandwiches today, because I don't think they had any treats today. I think they are just having sandwiches. No, they must have not had any treats, because the judge, I think, must have run out of pocket money for it for them. Um, yes, the stream is still working. I still haven't paused it, or thought that I was pausing the stream and not put it on, and we were waiting for nothing. So that this time is not my fault. I did that once, I think, and I don't think I'm gonna do that again. Yeah, it's just like, just don't understand this trial. This court is just incredibly late at all times, and it just gives me patience, and I just want patience for it. And yeah, I mean, I don't know what you guys think. If the Colin case doesn't come up, we probably will not be live to the other trial. I was thinking of maybe covering the ASAP trial, Rocky one. But again, we will not be live for it, because again, it is in California, time difference is supposed to last 3 weeks, and I don't really, yeah, I don't really want that f- to be live with with this case, because of the time difference and everything. And I don't want to impose that on Nightbot at the moment, because he is starting to get back to work and everything as well himself, and it's not fair. Like 1 or 2 hours after I go back to sleep, probably that is okay to ask him to do. But a whole like afternoon and everything, it's not really fair. He's been great in helping us out and helping the channel, but it's my thing, and I'm sure he doesn't mind. But I could not never ask that much out of him, because it would be a lot to him, and it would be very late for us in terms, because of the time difference. So um that's why I'm saying that we probably, if I don't know, we'll see what happens with Colin. If that happens, we'll see what happens, and we go from there. um Again, we are late 10 minutes now. I think they should be back in about 5 minutes. I think they definitely are all watching the watching the press briefing. Sorry, I was just stumped by something that I'm looking at the screen. So definitely they're still watching the White House press briefing. They definitely stuck on that, and they don't want to come in. They want to carry on watching. I understand, but we need to get a move on. Uh, I want to get a move on there, Judge, because we've got things to do. There's things to do. There's people to convict, people to deliberate on, and then we can watch other stuff. We have plans to watch. There is a parole hearing from yesterday. They are not live today, but there is one from yesterday that we can watch while online on deliberation, and then we can see what happens, because I don't think they are going to be deliberating today more than what, 2-3 hours. I don't think the judge is going to stay until that late. I'm not seeing that. But and then But then again, this judge has surprised us, so they might just do closings today, or even not do closings. By the time they're taking of coming back from break, they might not even come back at this point, because they might come back just saying because of the time and everything. They might just end for today, dismiss the jury, come back tomorrow, do the closings, do the jury instruction, and then deliberations. That is a possibility as well. So yeah, that could be a very high possibility. And I would not like that, because they could have already dismissed this an hour ago and we could have gone our merry way. But no, we're gonna say, oh, we're gonna, gosh, judge. Sorry, just me going crazy. I've been talking for a while. I think Nightbot needs to come up and we need to talk about probably nothing, but two people would be better talking than one talking by herself. But yeah, so it's just crazy. I'm just, yeah, looking at the feeds to see if there's anything new again, because don't have anything else to do, guys. Please help me, Nightbot.
I don't know what to say. I think we both run out of things to say.
No, nothing yet. Okay, Swan, you know this court. You think they're gonna be online on time? Sorry, that is funny now. Nothing yet. It's been 10 minutes since past when they said that the jury was gonna come back, and it's been 35 minutes since we were supposed, almost half an hour since we were supposed to come to sort out whatever they needed to sort out before the jury came back. So I just been talking about a lot of nothingness because that's what we do. Yeah, so we just waiting and keep on waiting and talking about the possibility they're gonna come back and dismiss the jury for the day and then come back tomorrow and do the closings then. That's what I'm thinking. That's what I don't know. I hope that doesn't happen. But because they're losing so much time at all the time, that's probably what is gonna happen, because all this lateness and all this coming back from court very late and all these breaks and all these sidebars that they've been having has been delaying this thing. They could have been, and as well last week, going off earlier from court very early is just wasting time. Oh yeah, I saw you there. I popped in just to say hi and drop off my like to her stream, and I saw you there. I'm keeping my eye out. No, I'm joking. But yeah, so it's just yeah, it's just waiting and chilling, and I mean, it's like it gets to a point. It's laughable. It's funny. Ah ha ha. That court is late, but it gets to a point that it gets too much. I mean, it's like we here for this judge. So what is the hold up? Like, let's get him move on, and it's not really fair that we keep waiting and they just because they all went to lunch or they're sorting out or reading documents and we are slowpokes like the other lawyer, we have to wait indefinitely. Yeah, I think we need to. No, I'm joking. I'm not gonna send the judge a letter or anything, but it's just a bit rather uncomfortable. You know what I mean? They were supposed to come back half an hour ago to sort out some stuff before they start closings and jury instructions, and they haven't. And it's just now gonna delay even more, because now if each other has an hour closings, that is gonna be half one, like quarter to 3, quarter to 4. Jury instructions, not jury instructions, is going to be 4:15, 4:30. They're going to what? To deliberate for half an hour and break up for the day? No, what the judge is going to do is even possibly not having closings at all, have everything tomorrow, start deliberations tomorrow, and it could have just let us go for the day and we could have moved on to other stuff. And yeah, I am thinking that, case one. I'm completely thinking that, because I don't think he's gonna make the closings today. and then let the jury go deliberate for half an hour, because in half an hour you don't deliberate anything. You probably choose who is the foreperson, right? And then you start deliberating, and then you have quite a bit to go through, like the financial statements, the kids statements and everything, and all the information, and try to remember all of it, because remember, they are not taking notes in this trial. And then they have to talk about the insulin, if they have even experienced themselves with insulin. So that's going to take about deliberation 2 to 3 hours. And then filling the paperwork and not filling the paperwork, we're looking at 5 hours. People coming back to court 5.5, which is never going to be on time because it's this court. So we're looking at what, 6 hours, 7 hours? 6 hours, 7 hours. That's gonna be about what, 11 midnight. I don't think this judge is gonna stay there until midnight. So I am thinking that they're gonna do closings. They might do closings today in jury instructions, but then the judge might dismiss them for the day and start deliberations in the morning. That's my opinion. I know too much. No. That's just me rambling on and talking about the past experience from the trials we've watched. And when you start watching court cases and following stuff like this close, you get the experience in terms of how sometimes the judges are thinking and which directions they are leaning in throughout. And this judge doesn't look like making the jury stay past 5 p.m. or even 4 p.m. for that matter, to deliberate on the case, even though he just wants to get over and done with, because I think he already had enough and he wants to get back to his retirement and he wants to go back to golfing, because that's probably what he does in Florida. So I'm just talking kind of a little bit of experience. Not that I have a lot of experience, but kind of some of them. So I'm just talking about that. Ooh, and talking about that, the judges come back. We'll see if what he says, because he might just dismiss the jury for all I know.
All right. Have you received a copy of the court's charge? Here it is. And I've realized that one thing we failed to discuss was the jury verdict form. We have one, but I don't know that it's been approved by the other side.
They had it.
I think we did have some corrections on it, but I don't have any clue.
It's pretty simple and straightforward. Thank you for the list, Angie. Thank you so much.
You did not miss much, Denise. They were just talking about the verdict charge on the form, and just talking about that. It's not much going on. They're just talking a bit before the jury comes in, so it's basically a nothing burger.
Last version.
The one that's submitted this morning is that one. The original one I submitted a couple weeks ago was
Okay.
That one's been revised, but this one has been approved by it includes the lesser included.
Okay, I'm going to have this stapled. You may have to take it in the other office to staple it.
Your Honor,
Yes.
I have a minor point to discuss. May we approach? Well, since the jury isn't here.
The editor's not here.
I was looking over the identification of the state's exhibits and the defendant's exhibits. And I believe there's might be a little confusion or clerical error in item number 10 and item 16. It reads an empty vial of methylprednisolone acetate injection. It's not the injection itself. It should read empty vial of injectable methylprednisolone acetate.
Okay.
I took that right off the label.
She said she took it right off the label.
Fine, it's a minor point anyway.
Okay. All right. Can the defense approve the court's charge?
Final stages.
Okay.
Oh, yeah.
Check this. I think this is an older version. I don't think that's the most recent one. I think this is the most recent one. You don't want to get confused. Okay. All right, let me ask counsel, how much time do you require or request for argument?
Your Honor, we'll defer to the defense.
I don't know. The state has the burden of proof. Maybe the state can.
20 minutes?
Half an hour?
Half an hour?
What do you guys need?
No, I don't.
Hey, want to do that 45
Okay,
minutes?
45 minutes.
45 minutes?
Yes, Your Honor.
Okay. Will you be doing the closing, Ms. Akert?
Yes, I will, Your Honor.
Okay. How do you want to divide your time?
35 for closing and 10 for rebuttal, Your Honor.
Do you want a discrete 1-minute warning
I would appreciate that, Your Honor. Thank you.
on both ends?
Please.
That would give the defense the full 45 minutes if you wish to take it. Do you wish a 1-minute warning, 2 minutes, or what?
2-minute warning is fine.
Pardon?
2-minute warning is
2
fine. Your
minutes.
Honor.
All right, here's the final question I have for you. It's going to take me a little while to read these instructions because it's 18 pages. Do you want to take a brief recess between the court charge and the closing arguments, or do you wish to go on through? It's up to you.
Judge, the only thing about the instructions, I thought we were placing the involuntary manslaughter before the instructions dealing with malice.
I thought that's what we did.
Yeah, I thought so too, but it's not the case.
Judge, I think that is what we proposed.
Okay.
It'd just be a matter of cutting and pasting page 10, where it starts with the definition, and moving it before the discussion of malice on page 9.
Okay. I'm going to ask you two to go with Ms. Brown Bailey and assist her so that you can set it forth appropriately.
Oh, sorry. I should have been talking, shouldn't I? It's the jury's. I was so distracted about the Timu version of Danny DeVito conversation that is just.
Yes,
Oh, I'll put on my list
Even better than typewritten.
of cases to watch. So apparently, we're gonna have 45 minutes each. Party to closings. State is gonna do 35 and then 10 for the rebuttal, and defense is gonna do the time. I did not catch who's gonna do. Is it the Timu Danny DeVito or is the Slowpoke? Hopefully is the Danny DeVito Timu version. Doing, because at least it will be less of a excruciating pain, and at least he probably will get everything in, because if it is the other guy, even though he has 45 minutes, it's gonna be taking a bit of time. Oh, sorry, I'm just um and then I think 45 minutes. I'm trying to do math, because the judge did say it's going to take a while also to read the jury instructions, because it's 18 pages. She does seem not, she seems normal to me. I think she's just like chilling. She probably knows that the outcome is not going to be guilty. Anyway, I think she knows that no matter what, anyway, she's gonna still going to prison for the crime, the Ponzi scheme. So it's not like she's gonna go home anyway. I think it would be different if she thought that after this she could have go home if she was found not guilty, but she isn't. So there's that as well. So yeah, we'll see what happens. I mean, I guess we'll be here. I don't know what they're doing. Are they sorting out the remainder of the jury instructions? Are they waiting for the jury to come in? What we doing? Oh yes, I know. I love that one. It's Always Sunny in Philadelphia. That is a very great TV show. I really liked it. I like that sort of stuff. Oh, is that the granddad? We've never heard about him. Um, so Always Sunny in Philadelphia. It was a very good TV show. It ran for a hot minute, wasn't it? I don't know how many seasons, but it was very good. Anyway, it was a very good TV show. Um, so who here? I'm gonna actually doing closings. I was thinking of doing a poll, but I can just ask you guys. Let me know on the chat. How long do you think jury's gonna be deliberating, and then your verdict? Guilty, not guilty, hung jury. Just let me know. I'm interested in knowing. Instead of me doing a poll, it's probably easier. Or if you don't want to do it yet because you haven't heard the closing, that's fine. But when you do, just do your guess in the comments of what do you think is gonna happen in this case. Is she gonna get guilty, not guilty, hung jury? And then how long the jury is going to be deliberating. Ooh, okay. 5 hours of not guilty of deliberation for a not guilty verdict. So Lois has her option locked in. Ooh, she does? I haven't noticed that. Interesting. So Lois has locked in her choices. You can't change them now. No, I'm joking. You can change. So 5 hours and not guilty deliberation for Lois. So we'll see. Actually, Nightbot, would you get me this post-its again? I think I'm gonna make notes of what people say, because then I'll forget, and with us talking, everything will disappear, and I won't see. So yeah, there is. There's always. Definitely, there's always going to be one that thinks differently, and then needs a bit persuasion to go either way of the jury. So I am thinking 4 to 7 hours. No, 6 hours. I'm gonna give them 6 hours. 6 hours of deliberation with That's the thing. I'm still between hung jury and not guilty. So hang on. Let me write before lose. So 5 hours, and then not guilty, and then case one says 3 hours. Okay. Do you have a guess of the verdict? Is going to be not guilty or guilty? Because I still don't know what I'm gonna say. Um, I am thinking of the 6 hours. I am locked in on that. But on the verdict, yeah, true. Oh yeah, that is for sure. And someone that it's not easily influenced, because you have those types of people. Oh, that is good. A lot of questions. So you think there's going to be a lot of notes in this one, like there was in the defamation trial, that they were asking if all the say. So Nightbot say 3 hours as well. So Nightbot says 3 hours. And what is your verdict, Nightbot? Guilty, not guilty, or hung? Hung jury is when they cannot come to a decision on the verdict, and they just hung. They cannot, and then the court declares a mistrial, and then the state has to, you know, see if they're going to press charges again or not, take it to trial or not. So you say 3 hours and hung. That's interesting. And now I just need my verdict. And I don't know. I'm still between not guilty and hung as well. But I have to choose. So no, that's fine. It's like, I think I'm gonna go for hung too, but I'm gonna go for 6 hours, because 3 hours the judge is gonna send them back out again to deliberate. So that is probably not gonna happen at a hung jury in 3 hours. But ooh, Denise, so 4.5 hours, guilty of a lesser. Okay. Guilty of a lesser charge. That is actually something very true that can happen, you know. That's interesting. Possible the lesser. Do you want me to put you down for the lesser as well, case one? I can put you down for the lesser. Sorry. Yeah, it's like, the thing is, there's a very high with the lesser. I did not think about the lesser. So I'm gonna go anyway for the hunk. 6 hours hunk. That's my choice. It's locked in, it's written down in pen. So, and then we'll see who was right and who was kind of closer. And yeah. You Thorn. I can imagine. I can feel it. I am too. Bets are in. Put your bets in. No. Just something, because I like polls, but I like to get to the interaction a bit out of you guys. So while we still very manageable chat, we can do this. Maybe in 5 years, when we grow as a channel, we'll probably do another different. If anyone is listen, just let me know on chat. Don't be shy, just chat with us. We are a nice
With the
group of people.
court's charge, I see that we have switched the elements for involuntary manslaughter with the definitions of malice. Is that correct, counsel?
Correct.
Yes, Your
And we haven't changed the wording of anything. We've simply moved those segments around as indicated.
It was a cut and paste. Yes. Sir.
Yes, Your Honor.
All right. That's agreeable, certainly, with the court. That's what we discussed. One more thing. Do either of you wish to have the podium set up in front of the jury box?
Yes, Your Honor.
All right. I'll ask the bailiff to do that, please.
And Your Honor, while we're doing that, after some reflection, I'm thinking I might need a little more time for closing. If we could have an hour total, I won't need that long, but I think mine will probably run about 45 minutes on its own.
All right. So you'd like to have an hour altogether?
Yes, Your Honor.
And how do you want to divide that?
45 and 15.
Sure.
45 and 15, Your Honor.
You still would like to have the 1 minute warning?
Yes, please.
And that would afford to Mr. Victor a full 60 minutes. Is that agreeable?
Yes, sir.
with a 2-minute warning.
Yes, sir.
All right, are we ready for the jury?
Yes, sir.
Bring in the jury, please.
Your Honor,
Okay.
the state does think
Oh.
that it would be appropriate to take a break between the charge and the closings, given the length of the closings.
Okay, I think that's probably a good idea.
So while the jury comes in, Paula, if you want to let the chat know on the chat, what is your verdict? Even though if you haven't followed too much, the we are voting for the weakest link of the channel, which will be night one. No, I'm joking. We are voting for what you think, if it is guilty, not guilty, or how long the jury deliberation is going to be. I know you probably haven't followed the whole entire case, but just let us know what you think. I would love for you to be part of it as well, even though you haven't followed. Just say whatever you want. It's just us trying to be a bit. Yeah. So now we have two new things. Closings is going to be an hour each, which is going to be not according to plan, which they're not going to finish on time. And it's Victor, the Timu version of Danny DeVito, doing the closing. So yay. So that's not going to be slowpoke. It's going to be a little bit more interesting than bearing for an hour of the closings. So I need to get ready to do the clock thing. So well, and the jury is going to come in anyway, and the judge is going to start talking. And I don't know if it's closing straight away or if it is jury
Members of
instructions.
the jury, the next phase or stage of this case, as I touched on earlier, is the instruction of the law by the court. I can tell you that this is a very boring and tedious part of any trial. And perhaps some of you who have served as jurors before know that very fact. Sadly, you must pay strict attention to what I tell you. Your oath requires you to apply the law that I will state to you to the facts you determine from the evidence. So this is a very important stage or part of any trial. Members of the jury, you have now heard and seen all of the evidence in this case. You are the sole judges of that evidence and the facts that it establishes. It is your sworn duty to determine and base your verdict only upon that evidence. In doing so, do not be influenced by sympathy, anger, passion, prejudice, or public sentiment. It is now my duty to inform you about the law that applies to this case. You have no right or privilege to disregard these instructions or to form a different opinion about what the applicable law is or should be. All of these instructions are important. Do not pick out one part and ignore other parts. You are to draw no inference from the order or manner in which they are given, and they are to be considered by you in their entirety as a whole. The indictment in this case is merely an accusation, and it is not any evidence of guilt. The burden is on the state to prove the guilt of the defendant beyond a reasonable doubt. The defendant is not required to prove her innocence. Our law presumes a defendant to be innocent of crime. So the defendant, although accused, begins the trial with a clean slate with no evidence against her. And the law permits nothing but legal evidence to be considered in support of any accusation. So you see, the presumption of innocence alone is sufficient to acquit the defendant. You must determine the facts of this case from the evidence only, that is, from the testimony of witnesses and exhibits. Disregard completely testimony to which an objection was sustained or exhibits ordered stricken out of the record. Absolutely nothing that I have said or done during this trial is to be considered by you as evidence or as any indication of an opinion concerning the weight of the evidence, the credibility of the witnesses, or the guilt or innocence of this defendant. Nothing that I, as judge, said or did at any time during this trial is to be considered by you as evidence of any fact or as an indication of any opinion as to any fact or evidence, or as a measure of the credibility or truthfulness of any witness who testified, or as to the weight you should give to such testimony, or as to what your verdict should be in this case. For you are the sole judges of such matters, and I am only the judge as to the applicable law. The evidence from which you are to determine and base your verdict consists of the sworn testimony of all of the witnesses, regardless of which side called them as witnesses and whether their testimony occurred on direct or cross-examination. The exhibits that were received into evidence, regardless of who introduced them into evidence. Any facts which I have told you were agreed upon by stipulation or otherwise, and any fact which I took judicial notice of. However, if you do not agree with that fact, you are not bound to accept it. Members of the jury, there are two basic kinds of evidence, direct and circumstantial. Direct evidence is testimony as to what a witness saw, heard, or did. Circumstantial evidence is indirect evidence, that is, it is the evidence of a fact from which another fact, not directly testified about, can be inferred or found. Both of these kinds of evidence may be considered, and it is for you to determine and decide whether or not a fact has been proven by circumstantial evidence by considering all of the evidence in light of reason, common sense, and experience. There is no quantitative difference between direct and circumstantial evidence. The following elements are not evidence, ladies and gentlemen, and you are not to consider them as evidence for any purpose whatsoever. Anything that any of you have seen or heard outside of the courtroom or when court was not in session. Do not consider or be influenced by any testimony or evidence which has been excluded and not put into evidence, and do not consider or be influenced by any testimony, evidence, or any other fact or subject that I instructed you to disregard and not to consider as evidence. If during the trial I instructed you to consider certain testimony, evidence, or facts only for a particular or limited purpose, you are to continue to do so and must consider such matters only in that manner and for that limited purpose. Do not be influenced by or draw any inference from any objections that were made by the lawyers during this trial or my rulings upon such objections, for such matters are not evidence. As I have explained to you throughout this trial, statements or arguments made by the lawyers are not evidence and are not to be considered by you as evidence, for the lawyers were not and are not witnesses. What they said to you in their opening statements or what they will say to you in their final closing arguments or at other times were and are made to aid you in following, determining, and interpreting the evidence as it relates to the issues before you and their respective sides of this case. While you must carefully consider the testimony of each and every witness and not disregard or overlook any testimony, witness, or evidence, the jury is the final judge of the credibility of the witnesses and the weight of the evidence. The number of witnesses testifying on one side or the other of an issue is not the only test of weight and credibility. If you feel that the evidence justifies it, you may believe one witness over a number of witnesses testifying differently. The test is how truthful is the witness and how convincing is the testimony in light of all of the evidence and circumstances shown. As jurors, you are also entitled to draw reasonable inferences and make reasonable deductions from any of the testimony or other evidence as you come to believe are justified in the light of reason, common sense, and experience. If you come to believe that any witness did not tell the truth about any material fact after carefully weighing and considering such testimony, you may disregard it or any part of it, or give to it or to any part of it such weight and credit you determine it deserves. In weighing and crediting the testimony of any witness, you may consider the good or bad memory of the witness, the interest of the witness in the outcome of the trial, the relationship of the witness to the parties involved in the case or to other witnesses, the attitude and manner of testifying of the witness, the opportunity and means or the lack of opportunity and means of the witness to learn and to have knowledge of the matters about which he or she have testified, the reasonableness or unreasonableness of the testimony of the witness, the intelligence of the witness, the appearance of bias or hostility or friendliness or unfriendliness of the witness to the parties involved in the case or to any other witness, and any contradictory acts or statements of any witness that you determine were done or made that served to contradict the testimony of such witness in court. From all such factors and considerations that appear from all the evidence and circumstances shown in the case, you are to evaluate the testimony of all of the witnesses and the weight to be given to their testimony and determine the credit you believe it is entitled to receive. In this case, you have heard testimony by witnesses who are presented as experts, who by knowledge, skill, experience, training, or education had acquired scientific, technical, or specialized knowledge in the field or area about which he or she has testified. As an expert, he or she is therefore entitled to express an opinion upon matters within his or her field or specialized knowledge and to state the reasons for an opinion. Expert testimony is to be considered and evaluated as you would the testimony of any other witness. You may accept or reject it in whole or in part, or give to it or any part of it such credit and weight you come to believe it deserves. In evaluating expert testimony, you should consider the knowledge, skill, experience, training, and education of the expert and the basis and reasons given for his or her opinion in light of all other testimony and evidence in this case. The court instructs the jury that evidence of other crimes, wrongs, or of acts by the accused is not to be considered to prove her character in order to show that she acted in conformity therewith. However, the jury may consider such evidence for other purposes, such as proof of motive, opportunity, intent, preparation, plan, identity, and absence of mistake or accident as to the crimes charged. This court has taken judicial notice of court documents generated by the United States District Court, Southern District of West Virginia. That is, the court has taken as fact that the litigation in the United States District Court, Southern District of West Virginia, occurred based upon the determination of sources whose accuracy cannot reasonably be questioned. You are instructed, however, that you may or may not accept that fact as conclusive. The offense charged in the indictment in this case is murder of the first degree. You may return one of two verdicts pertaining to murder of the first degree under the indictment. They are 1, guilty, and 2, not guilty. Murder of the first degree is any felonious, willful, malicious, deliberate, premeditated killing of another person. Murder of the first degree consists of an intentional, deliberate, and premeditated killing, which means that the killing is done after a period of time for prior consideration. The duration of that period cannot be arbitrarily fixed. The time in which to form a deliberate and premeditated design varies as the minds and temperaments of people differ and according to the circumstances in which they may be placed. Any interval of time between the forming of the intent to kill and the execution of that intent, which is of sufficient duration for the defendant to be fully conscious of what she intended, is sufficient to prove a deliberate and premeditated killing and to support a conviction for first-degree murder. Before the defendant can be convicted of murder of the first degree, the state of West Virginia must prove to the satisfaction of the jury beyond a reasonable doubt that 1, the defendant Natalie Page Cochran, 2, in Raleigh County, West Virginia, 3, on or about the 11th day of February 2019 for feloniously, willfully, maliciously, deliberately, and unlawfully and premeditatedly slayed, killed, and murdered 5 Michael Cochran. After impartially considering, weighing, and comparing all of the evidence, if the jury and each member of the jury is convinced beyond a reasonable doubt of the truth of the charge as to each of these elements of murder of the first degree, you may find Natalie Page Cochran guilty of murder of the first degree as charged in the indictment. If the jury and each member of the jury has a reasonable doubt of the truth of the charge as to any one or more of the elements of murder of the first degree, you shall find the defendant, Natalie Page Cochran, not guilty. Involuntary manslaughter is committed when a person caused the unintentional death of another person. This court instructs the jury that the absence of an intention to kill or to commit any unlawful act which might reasonably produce death or great bodily harm is the main element of involuntary manslaughter. A person is guilty of involuntary manslaughter when a person commits an act in a reckless or grossly negligent manner and unintentionally causes the death of another person. Therefore, in order to find the defendant, Natalie Page Cochran, guilty of the offense of involuntary manslaughter, the state of West Virginia must overcome the presumption of innocence and prove beyond a reasonable doubt each and every one of the following elements. 1, that the defendant, Natalie Page Cochran, 2, on the 11th day of February 2019, 3, in Raleigh County, West Virginia, 4, unintentionally, 5, caused the death, 6, of Michael Cochran, and 7, against the peace and dignity of the state. If each and every juror is not convinced beyond a reasonable doubt that the state of West Virginia proved beyond a reasonable doubt each and every element of the offense of involuntary manslaughter, the jury must find the defendant, Natalie Page Cochran, not guilty. Malice is a subjective state of mind of the defendant. It may be proven by evidence of circumstances surrounding the crime, such as words or conduct of the defendant before, during, and after the event, or evidence of ill will or a source of antagonism between the defendant and the deceased. Also, malice may be inferred from a deliberate cruel act, indicating a heart disregarding social duty and fatally bent on mischief. Malice and intent also may be inferred from the defendant's intentional use of a deadly weapon under circumstances which the jury does not believe gave her legal excuse, justification, or provocation for such conduct. Malice may be expressed to include not only anger, hatred, and revenge, but other unjustifiable motives. It may be inferred by you from all of the evidence in this case if you find such inferences reasonable from the facts and circumstances in this case, which have been proven to your satisfaction beyond a reasonable doubt. Malice may be also inferred from any deliberate and cruel act done by the defendant without any reasonable provocation or excuse, however sudden. Malice is not confined to ill will toward any one particular person, but malice is every evil design in general. It is not necessary that malice must have existed for any particular length of time, and it may first exist at the time of the killing or at any previous time. As a defendant is presumed innocent of the charges brought against her, she does not have to prove herself innocent and is not required to call any witness or produce any evidence. She is also not required to take the witness stand and testify, for she has a constitutional right not to do so. The fact that the defendant did not testify is not any evidence against her, and you shall not consider that she did not testify or draw any inference from that fact as to the guilt or innocence of the charges brought against her. You must entirely disregard it and not discuss it. The court reminds the jury that throughout this trial, the state maintains the burden of proving the defendant's guilt of the crimes charged beyond a reasonable doubt. From time to time during this trial, it was necessary for me to talk with the attorneys out of the hearing of the jury, whether by having a conference at the bench when the jury is present in the courtroom or by calling a recess. Most of these conferences involve determinations as to whether evidence is admissible under the rules of evidence. It is appropriate to take these matters up outside the presence of the jury. If I concluded that a more prolonged discussion was necessary, I may have excused you from the courtroom. You've heard evidence concerning alleged conduct or other acts of the defendant, Natalie Page Cochran, which are not charged in the indictment. You are instructed that such evidence is not admitted as proof of the defendant's guilt on the present charges. This evidence is admitted for a limited purpose only, and it may be considered by you in deciding whether a given issue or element relevant to the present charge has been proven. Accordingly, this evidence may be considered by you only for the limited purpose for which it has been admitted. In this instance, the evidence of the defendant, Natalie Page Cochran, alleged criminal acts of the, quote, Ponzi scheme, unquote, may be considered only for the purpose of determining whether the state of West Virginia has established the motive to perpetuate the first-degree murder. You are instructed that upon the trial of this case, if reasonable doubt of any fact necessary to establish the guilt of Natalie Page Cochran, the defendant, as charged in the indictment, be raised by the evidence or lack of evidence, such doubt is decisive and the jury must acquit the defendant, Natalie Page Cochran. You do not have to believe that the defendant, Natalie Page Cochran, is innocent of the charges against her in order to find a verdict of not guilty. Your verdict of not guilty only means that the state of West Virginia has failed to prove to you the guilt of the defendant, Natalie Page Cochran, beyond a reasonable doubt. The jury is instructed that the mere presence of the defendant at the place of the alleged crime or crimes does not in and of itself indicate participation of the defendant in the criminal act or acts. The defendant's mere presence at the scene of a crime or mere knowledge that a crime is being committed is not sufficient to establish that the defendant committed the crime charged in the indictment unless you find that the defendant was a participant and not merely a knowing spectator. The state of West Virginia must demonstrate to the jury beyond a reasonable doubt a nexus between the defendant's presence at the scene of the crime or crimes at the time or times of the alleged crime or crimes and her participation in the criminal act or acts. In relation to any and all charges contained in the indictment in this case, if each and every member of the jury is not convinced beyond a reasonable doubt as to each and every element of the offenses charged, the jury must find the defendant not guilty. If the jury has a reasonable doubt as to the grade of the offense of which the defendant, Natalie Page Cochran, may be guilty, the jury shall resolve that doubt in favor of the defendant, Natalie Page Cochran, and find her guilty of the lower grade. If the jury has a reasonable doubt as to whether the defendant, Natalie Page Cochran, is guilty of any offense, the jury must resolve that doubt in favor of the defendant, Natalie Page Cochran, and find the defendant not guilty. Evidence relating to any statement alleged to have been made by the defendant, Natalie Page Cochran, outside the court and after a crime has been committed should be considered by the jury with caution and weighed with great care. All such statements should be disregarded entirely unless the other evidence in the case convinces the jury beyond a reasonable doubt that the statement was made knowingly and voluntarily. In determining whether any alleged statement alleged to have been made by the defendant, Natalie Page Cochran, outside of court after a crime has been committed was knowingly involuntarily made, the jury should consider the age, training, education, occupation, and physical and mental condition of the defendant, Natalie Page Cochran, and all other circumstances surrounding the making of the alleged statement. The jury may give the statement such weight as the jury finds it deserves under the circumstances. The test for the burden of proof in a criminal case is beyond a reasonable doubt. This means that after considering all of the evidence, if you have a reasonable doubt of the accused's guilt, then you must find her not guilty. You must always remember there is no burden upon an accused to prove anything. It is the state who has the burden to prove the accused's guilt. One never has to prove one's innocence. You must give an accused person the benefit of any reasonable doubt you may have from the evidence or from the lack of evidence, but remember the doubt must be a reasonable one. This means that it must be founded on reason and should be explainable, not a dreamed up or fancied one with no basis. The test is not beyond a shadow of a doubt, nor beyond all possible doubt. It is beyond reasonable doubt. After hearing and considering all of the evidence, you are satisfied that based upon the evidence you have in your heart an abiding conviction of the truth of the charge, then you are convinced beyond a reasonable doubt. It is your duty in this case to apply the law as given to you as a whole in the form of these instructions to all of the evidence in this case. In that regard, the court has instructed you on your role in determining the credibility of a witness and the weight of the evidence. The court has instructed you on the difference between direct evidence of a fact to be proven and circumstantial evidence of a fact to be proven. You must never convict a person unless the facts justify it, but you should not shirk your duty when the facts do justify a conviction. You must require that the state meet its burden of proof, but you must not make the state's burden an impossible one. The burden is always on the state to prove guilt beyond a reasonable doubt. This burden never shifts to the defendant, for the law never imposes upon a defendant in a criminal case the duty of calling any witnesses or producing any evidence. A defendant is never to be convicted upon mere suspicion or conjecture. To convict, you must be satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. So if the jury has, after a careful and impartial consideration of all of the evidence, a reasonable doubt that the defendant is guilty of the charges, it must acquit. If the jury views the evidence in the case as reasonably permitting either of two conclusions, one of innocence and the other of guilt, the jury should, of course, adopt the conclusion of innocence. In the trial of a criminal case by a jury, the law contemplates the concurrence of 12 minds and any verdict returned, whether guilty or not guilty. Each individual juror must be satisfied beyond a reasonable doubt of the defendant's guilt before he or she can consent to a verdict of guilty. If each and every individual juror has a reasonable doubt of the defendant's guilt, you must return a verdict of not guilty. The jury is no place for unreasonable pride of opinion or for stubbornness. While no juror should yield a conscientious opinion deliberately formed after a full and fair investigation of the case, nevertheless, it is the duty of every juror to consider all of the evidence of the case, the instructions of the court, the arguments of counsel, and to discuss the evidence with the other jurors with an open mind and to give careful consideration of the views of fellow jurors. And if it can be done without sacrificing conscientious conviction, agree upon a verdict. Ladies and gentlemen, that concludes the reading to you of the court's charge or the instructions of the law. We're going to take a very brief recess so that the attorneys can collect their thoughts, and you will hear shortly from them in terms of their closing remarks or closing argument. Warn you, we are not yet to the deliberation phase of this case. After the lawyers deliver their closing arguments, you'll be able to fully and fairly deliberate on this case. But at this juncture, you cannot discuss the case among yourselves or with anyone else. I contemplate perhaps a 5-minute break, and you will return to the courtroom and we will proceed with closing remarks. You may go with the bailiff now briefly to your jury room.
All right, so we do have a couple of things to discuss while they were on break. We'll just see if the attorneys have anything to discuss after they leave, which I hope not. So it is 20 to 3. An hour we each. They're going to do closings
We'll take a
in real
bathroom
life.
break for 5 minutes.
So what I think is they are definitely not going to deliberate today, because I think the judge is going to be we're going to be doing the closings now, and then we are going to go. It's going to 5 o'clock, and I don't think judge is going to. So I think they're going to do closings today, and then tomorrow morning they're going to bring out the jury to deliberate. That's my thing. I was asking a question about they have to say the name every single time, because if I was the one on the defendant, right, we would be there for the whole day in the jury instruction, because I have 6 names. Right, because Portuguese people, we have 5 given names, and then I got married to Nightbot, so I have his surname as well, so I've got 6. So the time that the judge would take to say my whole 6 names all that time throughout the jury instructions, we would be there forever. And I was just like, please, I was like, can you guys imagine if we actually, like, they had to say my whole name, my days, we would be there. Yeah, I think so too. I think we're all ready for this case to be over and done with. I hope they don't drag it out to get free food, like maybe the CNN guys once did, that they kept getting food from them. So yeah, I know. I remember you practicing my whole name there at night, but it was actually quite funny. The CNN I think they did drag it out a little bit more to get more food out. I'm not sure. I don't know. But hopefully they don't do that, because that would not be fair on the defendant or on us. Because the new trial might start tomorrow, for all I know. So I'm a little bit it's like, just let's go on with it, and that's why I think. But I still think that this is not um gonna end today. I think they are gonna go into jury deliberations tomorrow. What I was saying earlier, in terms of very excited, the good news that I was that I decided to tweet out to Kathy Russo on Twitter or Next or whatever you want to call it, to ask her about the new trial, because they said there's like following and everything, and I was like, any updates on it? And she was like, yes, they brought a new panel this afternoon for the jury selection for the case. And then I was like, oh, might as well ask how you guys look live streaming. And she was like, yes, with an exclamation point, which got me very excited, because we've been like doing research on this case, and we've been doing like the timeline and everything and talking about it, and I've been hyping so much that it would be a little bit downkill if they would not live stream, and we would be, oh, okay then. But no, they are gonna, so which is very exciting. I have to do some trial prep tomorrow morning. Oh, I know. Did you get to see Lois? I can send you by email as well. So if you guys want as well the timeline that I've created for this case, I have an email. I will put the command, the email on chat. If you like to reach out for anything about any trials or any information or anything, or if you want me to send you the timeline for this case that I created upon the information that I was able to receive, email me on that email that I'll put on a screen. then you guys can I can send you the timeline document about this case. So that's the email that is on screen. Drop me an email and I have as well tomorrow morning to do some prep on this case, because I was able to find the list of witnesses for the defense and for the prosecution. So I need to go through it, put on a document in my computer. So when a witness is on stand, I can just copy paste from the document to the pin message thing that we normally do to try so we know who is on the stand and everything. So I've got to do that tomorrow morning. I need to finish off the thumbnail for this trial and the description and just do the final touches. Oh, okay. All right. Okay. I will email you, Lois. I absolutely will do. I will write a note. See, I'm gonna write a note, and to send you the timeline. 100% sure it is written. See, it is written on paper, so I will not forget. So I'm very excited about this new case. So I'm so excited. Sorry, I get very excited about the weirdest things ever. So now I'm excited about this case. Well, it's a good thing I'm excited. I really genuinely love doing this. I've been obviously it has its downsides. I have my bad days with mental health and everything and the challenges that it brings, but the good days surpass the bad days and the hard days and the work, and it is very worth it doing it, and absolutely love it. So it's been a great honor to be able to do this and to be able to have a small part in it. I guess obviously, we're still a baby in the true crime world, but we'll get there. We'll grow, we'll develop, we'll learn, and there's gonna be new exciting things. And it's just, yeah. So I am so bad on keeping in time that. Okay, so how long it has been? 35. No, yeah, it's been more than 5 minutes and they're not back yet. Definitely not on time. Because the thing is, I need to keep time and track these things, because I did promise that if they do come back on time, we will do we'll do the 24-hour live stream. So I just need to check how long have they been on break, because obviously I did not keep a check of that, obviously, because where would I? Yeah, they've been more than 5 minutes, so sorry. It's just been funny. It's that we're gonna do that. Oh, and I need to figure it out how to do the count up, because we need to figure it out. What would you guys like to count in the new trial? I think we can figure it out like while openings are happening and everything, but I need to figure it out how to do the overlay on stream, because yeah, I need to figure that out. I need to try that tomorrow morning. Oh, what happened there? You good? Yeah. Sorry, I was just talking to my computer because it all of a sudden it went crazy. Uh, so what I was saying, I need to figure it out how to do the overlay for the count or whatever we're doing in this trial, in the next trial. I mean, because in this one we didn't do much because we're just. I can hear noise. Sorry.
All right. Are there any matters that we need to raise and discuss out of the presence of the jury at this time?
There's one that's been brought up by the defense, Your Honor, and that is the indictment says February 6th. The
indictment actually says February the 11th.
That's what I thought it said too, but I was told by the defendant and I didn't have a copy.
Well, I've got a copy because I heard the same suggestion that you did, and it says on or about the 11th day of February 2019.
Blaine Selden, he came up with that.
Just the point I brought up, and it's probably too late to address it. The murder says February 11th. The alleged act occurred on February 6th. That's when the alleged act occurred. The death of Cochran occurred on February 11th. I don't know what we can do about it or anything of that nature.
It's on or about. There's nothing to do about it.
I don't think there is anything we can, oh, we didn't have a court reporter.
Well, uh-oh.
I
You
thought
want a
you were
record of
down there,
that, go ahead.
Joanne. I'm sorry.
No, you didn't do anything wrong.
You didn't do anything wrong. All right, I think we can go forward. We can change the instructions and I can read them all over again, but everybody's moaning and groaning and nobody wants to hear that.
With a big sign that says, "This is Selden's fault."
Right.
Just for the sake of the record, I brought to the court's attention, the indictment says that the murder occurred on or about February 11th. I just brought to the attention of the court, the alleged act occurred on February 6th. The passing
I don't want to listen to the instructions again. Please, Judge, don't make us go through that again.
anything.
I don't think it impacts anything. It's on or about. No objection was raised. You all approved the jury charge, and we're going forward.
Thank you.
All right. Are you folks ready to deliver your closing remarks?
Yes, Your Honor.
Bring in the jury, please.
Yay, here we go, guys. Closing time. State would always start. So, and we're not going to have to hear the jury instructions again. Yay, because that is true. Everyone agreed to that. So, I'm bringing the jury. I need to sort that out too, the soundboard. Oh my days, I still have so much to do. Tomorrow morning. It's going to be a long morning of sorting things out. Yay. And I need to get ready for the stopwatch, guys. 1 second.
All right, ladies and gentlemen of the jury, as I have alluded to, the next stage or part of this case is the final argument of counsel. You will hear from each side, and the attorneys will argue the issues and the evidence presented, giving you their own interpretation of that evidence. As I've said over and over, their remarks would not be evidence themselves, but all of these attorneys have worked very hard in presenting this case before you, and I ask you to please give them due consideration. We will follow the same order that we have established in this case. As you know, the state does have the burden of proof, and we'll go forward first. Then the defense will present their entire argument, and the state has a brief period to rebut. All right, Ms. Acord, you may proceed. Okay.
Good afternoon, ladies and gentlemen of the jury. As you know by now, my name is Ashley Akerd. I am an assistant prosecuting attorney here in Raleigh County. I've been presenting this case to you with Tom Truman, who is our current prosecuting attorney. We're here in the matter of State of West Virginia versus Natalie Cochran. And if you all will bear with me, I will have to do some reading as we go. There's a lot of ground to cover here. So the first thing I want to do is thank you for being here. Just very briefly, I know everyone does this, but this has been a long couple of weeks, and we've had a lot of evidence come in this case. So just thank you all for sitting through it with us. Thank you for being here, and thank you for deciding this case.
Now, at this point, you all know why we're here and what we've been doing for the last few weeks. My job today is to prove to you beyond a reasonable doubt that this woman, Natalie Cochran, feloniously, willfully, maliciously, deliberately, and with premeditation killed her husband, Michael Cochran. This entire tragedy can be summarized into 3 different blocks of time. September 29th of 2017 through August 26th of 2018, September 1st of 2018 through January 30th of 2019, and January 30th of 2019 through February 6th of 2019, the week that Michael falls ill for the last time. Now, Michael Cochran was 38 years old at the time that he died. He was a father, a husband, and a son. He was a very fit and healthy man. He cared a lot about what he looked like and a lot about what people thought of him. He lived and worked here in Raleigh County. As you've heard, he worked in technology. He also worked with Workforce West Virginia. Ultimately, he was a minority partner in the business Tactical Solutions Group, in which his wife, Natalie Cochran, was the 51% majority owner. And we'll just briefly talk about TSG. We don't have to get too far into it, but I feel like we need to cover that ground again. TSG is represented through its website to be a leading supplier to the Department of Defense, national security agencies, federal civilian agencies, prime contractors, and nonprofits worldwide. And we've heard a lot about how the business ended up not being super legitimate. In fact, it wasn't at all. But it originally was set up that way. They had filed with the Secretary of State. It had a business license, and it actually was registered with the federal government to bid on government contracts and to be awarded those contracts. It was held out to be a woman-owned small business, which gave it priority in getting contracts. But a business like this required one thing: startup capital. There was 2 ways that the business obtained startup capital, and that's the money that's needed to get it off the ground and get things running in general. The first way was through investors. And what would happen was Natalie would go to her friends, her family, people in the community, ask them to invest in this company. They were promised a return on their investments when contracts were ultimately fulfilled. They'd get more money back than what they put in. And sometimes, when the money would come back, she would ask them to invest again so they could get an even higher return on their original investment. So some of these people were putting money into this company over and over and over again and seeing very little payout, if any. The other way that TSG gained startup capital was through loans. She would apply for small business quick capital loans. And what that means is these were rescue loans. These were for companies that were in trouble. They would have a very high interest rate, and you would have to pay back on them daily. And now, I'm not saying that Michael didn't know about investors and didn't know about loans. He knew people were investing. He knew there were loans. But they weren't what he thought they were. Some of the loans, he was told, were SBA grants. What's so special about a grant is that you don't have to pay the money back. That money is given to you for a specific purpose. Otherwise, he thought they were getting government bonds. Specifically, Natalie held out the loan companies to be factoring companies. And what factoring companies do is they buy all of these accounts receivable that you have, and they'll pay you for a portion of them, and then they'll collect the money later. So that's what she told him was going on. So what happens next is about August 26th of 2018, Michael really discovers the extent of family investors and investments. You heard that he got into Natalie's phone at one point and read her messages, and that's how he found out. He was completely unaware of the lucrative returns and profits that were being promised to people. He was quoted as saying she was giving away our money. On August 27th of 2018, Natalie sent a message to a few family members, which we've put in evidence and you all have seen. Hey guys, after the contracts that are out pay off, I will have to stop subcontracting. I wasn't as transparent with Michael as I should have been. After this, Michael and Natalie made rounds to family members, trying to pay some checks, try to pay some people back. But ultimately, Michael realizes that the amount of money that they owe people is a lot more than he knew. So now he wants to be more involved and understand how everything works. On August 27th of 2018, Natalie sends Michael this message, this series of messages. 3.45 million should post tonight at midnight. 300,000 should post Wednesday. 1.25 million on Thursday. 724,000 Monday of next week, and 2.56 million next Friday. You've heard that Michael was spending money. This is why. This is why he was so charitable. You heard that he donated a weight room to a middle school. He bought uniforms for youth sports. He bought a house for a youth pastor who had nowhere else to go, and later rented that house out to Chris Davis's recently widowed aunt. He was trying to give to people. And he'd been led to believe that this legitimate business was thriving and all of this money was due to them. She set a prize date, though, when she did this. All their hard work was going to start paying off at midnight. So what did this ultimately do? It created a big problem. It created a bunch of promises that Natalie couldn't fulfill. And those promises totaled, at this time, $247,499,232. So in our next time frame, Natalie starts to claim that the government is conducting an audit of TSG. And she uses this as a reason that they can't pay money to investors, a reason they can't get contracts, they can't get paid on outstanding contracts, and the reason that they're not seeing any returns. So she solicits 2 more investors. One of those was Chris Davis. He told you about that. She obtains 3 more rescue loans. On October 25th, Natalie tells Michael the audit is complete. We're going to have our money October 29th. So what happens right around that time? October 31st, Michael goes to the hospital. He's expecting $248 million on October 29th. The money isn't produced. On October 31st, he's sick. He goes to the hospital and he gets discharged, but he's not well. He's not better. And the defense would have you believe that Michael was incredibly sick all the time, that he left the hospital, went back to the hospital because he got sick all over again. No, he was sick one time. He just didn't get better. It happens. It happens all the time, all over the world. When Michael went back to the hospital on November 2nd, Natalie reported that he had had a seizure. That was never confirmed. You heard experts testify that the seizure activity in the records was reported by the defendant. Everyone else who testified said they had never seen him have a seizure. At that time, he had his friend Chris Davis take him to the hospital because he wanted to be treated. Nobody wants to feel the way that Michael felt. But other than this, he was healthy. You would think that he was sick, though, because he was stressed out of his mind, because he was waiting for $248 million that had been promised to him that he hasn't seen. But it still isn't coming. And there's a whole lot happening during this time. A phrase that we've been throwing around a lot on our team is that Natalie Cochran involved everyone and included no one. So on December 4th, BB&T is closing the Cochran's accounts. Michael goes to BB&T, and you've heard about that. He is irate. In fact, his friend Chris Davis is called to come down to the bank because Michael is causing such a scene that there is fear the police are going to be called. He's angry because he thinks these accounts closing is why he's not seeing any money. So ask yourselves, if Michael was involved in a felony level financial crime involving hundreds of thousands, at this point, hundreds of millions of dollars, why would he go cause a scene at a bank and potentially get the police called on him. He didn't know what was going on. And this is where Natalie gets lucky for the first time. On December 6th, the government's already partially shut down and is only funding certain departments. I'm sure we all remember the government shutdown because it was a really big deal and a lot of people had a really hard time because of it. On December 22nd, the entire federal government shuts down. So we've gone from an audit to a federal government shutdown, buying her more and more time. And the shutdown becomes the reason that they're not getting paid. Now, Natalie has told Michael and all the investors that the money's frozen because of an audit. Now, the government's shut down. Next, she tells people she has cancer, chronic lymphocytic leukemia, which we talked about that a little. We've never found anything that indicates that that was real either. She now has to deliver. So she tells Michael and she tells the investors, on February 1st, the federal funds will be released because the shutdown has ended. So why does the money come in on February 1st? It's January 30th of 2019, and we have entered the week of Michael's illness and ultimate death. So here's where she gets sloppy. Her motive to kill him becomes very clear because he is very quickly catching on. It becomes very obvious who's been running the company, that Michael has no idea about the Ponzi scheme. And more importantly, we're seeing that Michael's about to discover the truth of everything that's been going on. So she has two choices. She can come clean, or she can go into self-preservation, which requires that she take him out of the equation and make sure he never finds out what was happening. January 31st of 2019. Natalie says, I'm on the phone with Bank of America. Michael says, are we 1,000%? Yes, she's sending them with tracking. Money is supposed to hit tomorrow. February 1st of 2019, the fund release date told to investors and told to Michael, no funds hit any accounts. This was a Friday. So Michael knows at this point, Monday is the next day he can do anything. So on Monday, money isn't in there. More excuses. Michael is getting increasingly concerned. Later that same day, she says that she spoke with the wire department. All of this money is about to come through. 4.8 million in the morning, 23.8 tomorrow sometime. Michael says, shit, can't do anything today. Michael was just like the rest of us, as you can see. Doesn't make any sense. I certainly don't think it makes any sense, ladies and gentlemen. And that's because nothing he was told was true. So let's get into Michael's murder. February 4th of 2019, Natalie sends Michael a text message. I'm at the pharmacy. Need anything? Now, if you'll recall from Dr. Halsey's testimony yesterday, on February 4th of 2019, Natalie was picking up her prescription for Xanax, which Dr. Halsey also testified is a benzodiazepine. Michael is allergic to benzodiazepines, as you've all heard. On February 5th, 2019, Natalie goes to Access Health and sees Dr. Halsey with flu-like symptoms. She says she's vomiting, she reports a fever. She's negative for the flu and strep. She got a steroid shot and labs that day. Now you'll note that this is the doctor who, she said, put her on such a high dose of steroids. That was her words, high dose of steroids. As we'll later see her tell Jennifer Davis. But he didn't give her a prescription for insulin. And you heard his testimony yesterday that he didn't instruct her to get insulin. On this day, she also requested methylprednisolone from Stephanie Hamilton. Now, we all know that is Solumedrol. And if you'll recall, a vial of methylprednisolone was later recovered from the Cochran residence when the search warrant was executed. FBI analysis told us that that bottle had never been used. The same day, Natalie reaches out to Albatross Air, the Kearns family, and schedules a flight for her and Mike to take the following day to Lynchburg, Virginia. We've heard a lot of talk about that flight. You heard from Court Nexon, who is a former Bank of America employee. And he told you that the Cochran's account was never funded. There was never money in their Bank of America account. Mike couldn't understand why. So sure, they were going on this trip to fill out signature cards and things like that. But they were also going to find out why contract funds weren't posting to this account, why all of these wire transfers we've heard of were not coming through. And if they went on that trip, it would have changed everything. So on February 6th of 2019, the last day that anyone sees Michael Cochran conscious, 6:34 a.m., Natalie Cochran texts Chris Davis. She tells him she can't go to Lynchburg because she has a fever of 103 degrees. Now you'll recall she asked Stephanie Hamilton to bring a thermometer over because she apparently didn't have one. 6:35 a.m., Natalie texts Josh Kearns at Albatross Air, cancels the flight to Lynchburg because she has the flu. Mike tells Natalie to tell Court Nexon and his boss that they won't be there today because she's sick and they'll come tomorrow. But if they still need him to come today, Mike will go and he'll take his friend Chris Davis with him. They'll come back and get her signature card notarized. Mike very much wanted to take this trip. 6:37 a.m., Mike tells Natalie to get Court Nexon to wire them $5,000 to $10,000 from their account. The account that is still sitting empty at Bank of America. Natalie tells Mike she's already canceled the flight and he tells her to reschedule it for the next day. And this, ladies and gentlemen, is the text canceling the flight to Lynchburg, wherein Natalie says that she's been up all night with the flu, which we all know she was never diagnosed with. Later on February 6th, she sends this text message to Michael. I'm in the doctor's office getting swabbed again, getting a Prometh shot, getting you and I both meds. Now, Mike is currently out and about in town. He goes and gets some Starbucks at 8:37 in the morning. Natalie arrives at Access Health at 8:10. She says she's getting them both meds. Now, you heard Dr. Halsey testify yesterday. He didn't see Michael that day, and he did not prescribe anything for Michael that day. In fact, the only medications that Natalie was prescribed that day were promethazine tablets. Promethazine, which Michael is critically allergic to. So what did she tell him that she got him? And isn't it interesting that Natalie Cochran runs straight to the doctor at the first sign of trouble? Frequently. But let Michael Cochran lay on the couch for 6 hours, unconscious. And let's ask ourselves how Michael was feeling around this time. Well, you remember Jason Bowen telling you he, quote, felt like he was being poisoned. She later texts Jennifer Davis, we are both sick. So they put me on such high dose steroids, I have to start taking small insulin shots. Gonna have to order a vial. Again, there's no records that support any of this. There's nothing that indicates that she needed insulin for any reason at all. And if Mike was really keeping insulin in the house for his bodybuilding that everyone keeps talking about, why couldn't she use that? Why would she need to get it somewhere else? And I'll also add, the last text between Michael and Natalie Cochran is at 8:51 a.m. on February 6th. Following that was a 15-second call at 8:52 a.m. And this is the last time we know of that they spoke with each other. Later on, as we all know, Jennifer Davis offers up a vial of insulin because she's a good friend. She's worried about Natalie. She thinks her friend has cancer. She thinks that she's dying. She's doing everything she can to help. So she offers up her own son's vial of insulin. Natalie sends another text to Jennifer Davis. Mike's sick today too. He didn't get anything prescribed for him. He didn't go to the doctor. All that we've heard is that he laid on the couch for a couple hours. Chris Davis shows up a little while later, and as we all know, drops off a bag, which he testified that he never looked in. His wife, Jennifer, told us exactly what was in the bag. Some Propel, a Diet Coke that Natalie asked for, and a brand new unopened vial of Humalog insulin. Jennifer says, "You're welcome, but that's nothing. I sure wish I could do more for you." And Natalie's words are, "That was perfect." And I bet it was. Another message she sends Jennifer Davis. "Mike was so mad this AM about not being able to go today. He had to take 2 of my blood pressure pills." Now, the last documented communications from Mike's phone, 11:15 a.m., John Hamilton told you he called and didn't get Mike. He leaves a voicemail message. 1:39 p.m., which you heard testimony today, we believe Michael was unconscious at that time. A text goes from Michael's phone to Matt McCormick. "Should be good, buddy. I'm available all weekend too. Whatever works best." "12:29 on February 6th of 2019, Natalie Cochran takes this photo of her husband Michael laying in their kitchen floor. Now, ladies and gentlemen, I don't know about you, but if my husband had a serious medical event and was lying unconscious in my kitchen floor, I wouldn't be taking pictures of him. I'd be getting help. The first person she sends it to is her sister Penny, who testified that her reaction was, "Well, what does she want me to do about it?" And I think we all know the answer to that question. Next, she reaches out to John Hamilton, who you heard testify a few days ago. She tells him, "Mike is sick like last time. Last time when he asked to be taken to the hospital. Last time when he wasn't left unconscious in his kitchen floor." John heads that way, and Natalie then calls her private contractors, Jason Bowen and Jonathan Miller, to come to the residence and help. You heard Jason testify that they were at Lowe's at the time. The story he was given was that Michael threw up in the sink and then used the kitchen cabinets to lower himself to the floor. Jason and Jonathan arrive, and they move Michael to the couch, and Natalie begins reading them vital signs that they can't see. That includes his blood sugar. Why would you check the blood sugar of someone who doesn't have diabetes or any known problems with regulating his blood sugar? Ladies and gentlemen, I'll posit to you that if he were just sleeping it off like she wanted him to do, he would have felt that finger stick. I've had 100 finger sticks. I know what they feel like. You're not going to sleep through that. At that point, she reports that his blood glucose is 145, and this is at 1:06 p.m. John Hamilton shows up shortly after that, maybe 20 minutes after she contacted him the first time. He told you that Michael was already laying on the couch when he got there. He immediately asks, "How are we going to get Michael to the hospital?" Natalie's response is to let him sleep it off. She now tells him that Michael was sick and had a seizure. John noted that he had never seen Michael have a seizure. John then contacts his wife, Stephanie, who is a physician assistant, as you all heard. He asks her to come over and, quote, get her to take him to the hospital. So Stephanie arrives a little later and takes Michael's temperature. She made it a point not to startle him and even warned him that she was going to be taking his temperature. But he doesn't wake up. Stephanie also tells Natalie that Michael needs to be evaluated. Natalie again declines and says Michael wouldn't want to wake up in a hospital. Stephanie even gave her an out. She said, he can blame me. Also, at some point during the day, Natalie and Mike's kids come home from school, and Natalie's sister, Penny Lowry, arrives. Penny told you that Michael had an accident, and she held a blanket up while Natalie changed him into dry clothing that was retrieved by Natalie and Michael's daughter, Nicole. Thomas Treadway shows up later. When asked if he believed Michael needed to go to the hospital, he told you he's not a medical professional. Natalie's text messages indicate otherwise. They indicate that he believed Michael was getting worse and that he needed to be checked out. So you decide. At 4:34 p.m., Natalie reports that Michael's blood glucose is 115. She tells others that Stephanie Hamilton took that reading, but Stephanie Hamilton took the stand and told you that was not true. Lastly, Chris Davis, Michael's best friend by all accounts, arrives at the residence. He told you how he ran his thumb up the sole of Michael's foot to see if he could startle him awake. He told you that he tried a sternal rub. Nothing. His words to you were, he is going to the hospital, and I'm going to take him. At that point, he and Thomas Treadway load Michael into the back of the Cochran's car, where Natalie rides with him as Chris drives him from 4H Lake Road to Raleigh General Hospital. When Michael arrives at Raleigh General Hospital, his blood glucose was 21. That's a far cry from 145 and 115. Seemingly, it's plummeted out of nowhere. You heard from Dr. Uribe and Dr. Krieger. The only reasonable explanation is exogenous insulin administration. And ladies and gentlemen, the defense has posited to you that if Natalie Cochran injected Michael with insulin, oops, dropped the needle. Here's the good news, I brought it back up. He would have felt it. Now, this is an insulin needle.
You know, I'm going to object to this demonstration. This is bringing outside the evidence before the jury.
This is a demonstrative exhibit, Your Honor.
Overall, it is a demonstrative exhibit used in closing arguments. Members of the jury, you are the judges of the evidence. This is a demonstrative exhibit. I want you to rely upon your recollections and your memories of what the evidence has been in making your decision. There's a certain rough and tumble that we allow and some latitude in terms of closing remarks. I'm going to, as I say, overrule the objection and permit counsel to proceed.
Thank you, Your Honor. Ladies and gentlemen, I want you to see the size of an insulin needle. That needle I just showed you holds 30 units of the kind of insulin that Gavin Davis was prescribed and that was received by Natalie Cochran from Jennifer Davis. Dr. Krieger told you how small a unit of insulin is, and you can see it for yourself. Extremely small. I would also say, we made it pretty clear yesterday that the defense experts did not have the full picture. They had incorrect and incomplete information, so how could they make an informed opinion? And when Michael arrived at Raleigh General, as I said, his blood glucose was 21. He was immediately intubated. and he never woke up. February 7th through 11th of 2019. Michael was transferred to Charleston Area Medical Center, CAMC. His MRI there, as you've heard, showed diffuse hypoglycemic encephalopathy, brain swelling caused by low blood sugar. February 10th of 2019, Michael is transferred to hospice care at his wife's request. He spends 5 hours there before he dies. Now, you'll recall during Thomas Treadway's testimony that he advised Natalie needed to remember that she took his vitals that day and that she needed to make a timeline of the events leading up to Michael's death. Why? Here's some of the different stories she told. Michael was sick in the sink and fell. Michael was sick in the sink and lowered himself to the floor. I heard him hit his head, and when I went in there, he had fallen. She also said he was vomiting in the sink, had a seizure, and then hit his head. And that's just a few of the stories we heard. Now, a search warrant of the Cochran residence was executed on June 25th of 2019. And I would note that TSG has continued business up to this point, even getting additional investors after Michael's death, including the Hamiltons. During this time frame, Natalie also pled guilty to the charges that you heard about in federal court, the wire fraud and unlawful monetary transactions. During the execution of that search warrant, a lot of things were found and taken from the Cochran residence. Of note for us was the unopened methylprednisolone vial and the insulin that she kept in her refrigerator. Now, if you remember when Lieutenant Bledsoe testified, he told you that when he reviewed the property receipt from the search warrant with Natalie Cochran, she flipped through it and immediately went to the insulin. And she said, "I keep that for my neighbor's son who has diabetes." Ladies and gentlemen, as I stated previously, the elements of first-degree murder are a felonious, willful, malicious, deliberate, and premeditated killing. Felonious is simple. Murder is a felony, and it's against the laws of the state of West Virginia. Willful or deliberate would mean that someone took an overt action in furtherance of an anticipated result. She injected Michael with insulin. Dr. Krieger and Dr. Uribe testified that there was no alternative reasonable explanation for Michael's blood sugar to be 21 other than outside insulin administration. She also let him lay on the couch for 6 hours. She brought in all this help over and over just to refuse it. Malicious, showing or having a desire to cause harm. Natalie was a diabetic counselor and a pharmacist. She knew that injecting insulin into a non-diabetic would cause harm. She chose over and over, after repeated pleas from friends and loved ones, to leave Michael on the couch, laying in his own urine. She also showed a complete indifference for human life when she continued to work on contracts and make plans for bingo while her husband lay dying in the hospital. Premeditation. She obtained the murder weapon in advance from Jennifer Davis. And poor Jennifer had no idea what she was getting herself into when she did that. She had a clear motive, and you saw that leading up to this date, Michael was about to find out what she was doing to people. Do we know what he was going to do with that information? We never will, because he won't have the chance to tell us. Michael was killed because following the actions of the defendant, he was admitted to multiple hospitals and ultimately passed away at hospice. Well, there's a couple of defense theories that I just want to go ahead and debunk while we're here. The first being, Natalie was a pharmacist and could have gotten undetectable drugs to kill Michael. Those were defense counsel's words. She did, just not as a pharmacist. She hadn't worked in pharmacy for 2 years at that point. Insulin can be bought over the counter. Stephanie Hamilton debunked this one. She testified that Humalog, the kind of insulin that was used to kill Michael, cannot be bought over the counter and has to be obtained via a prescription, which neither Natalie nor Michael had. Michael was a, quote, ticking time bomb. Michael's previous illnesses can only be verified by Natalie. No one else ever saw him have a seizure. Sure, he went to the hospital, but they were never actually able to verify that seizure activity occurred, only that it was reported at home. By her own words, Mike was doing the best he had ever done in his life. You heard testimony that he forgot where he parked his car. Ladies and gentlemen, I don't know about you, but I forget where I park my car all the time. It's very common. He participated in tough man competitions and Jeep pulling competitions. It doesn't sound like a sick man to me. You also heard that Michael was on steroids. Chris Davis testified that Natalie told him that she was in charge of all of his supplements and vitamins. No steroids were recovered from the Cochran residence when the search warrant was executed. The Mexican supplement that we've heard about turned out to be a female fertility drug that came from Florida. You know who had communication with that company? Natalie Cochran. Ladies and gentlemen, in closing, Natalie Cochran had the means, knowledge, and opportunity to commit this crime. She dosed Michael Cochran with insulin that he was not prescribed and that he did not need. You may not have done the math, but I have. Next Thursday will make 6 years to the day since she injected Michael Cochran with insulin in his home. 5 days after that will be 6 years since Michael Cochran left this earth. 6 years since 2 children lost their father. 6 years since this woman, Donna Bolt, and this man, Ed Bolt, lost their son. 6 years since they were able to see him for the last time. Michael and the people that loved him deserve to have the most thorough investigation that we could conduct. And we've done that. We've done everything we could to show you what really happened to Michael. These people have waited long enough for justice. Michael has waited long enough for justice. Ladies and gentlemen, I'm asking you at this time to deliver that justice and to find his wife, Natalie Cochran, guilty of the first-degree murder of Michael Cochran. Thank you.
Mr. Victor.
May it please the court, counsel for the state, ladies and gentlemen of the jury. About 2 weeks ago, when I stood in front of you, I told you a couple of things about this case. And one was that Natalie Cochran was guilty of financial fraud, of financial shenanigans, and that she was indeed guilty without any reservation. But we're not here today to retry that case. And everything that the state is telling you about Natalie Cochran, yes, let's shed some light.
That was me, sorry.
Thank you, Judge. everything that we've heard about this financial case from Natalie's standpoint is true. She was convicted. She was a participant in the Ponzi scheme. But we're not here to judge her yet again on the financial crimes. We are here to judge her on the murder of her husband. And the state cannot prove first-degree murder against her beyond a reasonable doubt. The state cannot prove three things. The case cannot prove what, the case cannot prove how, and the state cannot prove why. First question, what was Michael Cochran killed by, or what killed him? And you've heard the evidence over the last 2 weeks that we don't know. The experts that the state brought testified to what they themselves admitted, a definite maybe. Maybe it was the insulin shot, and maybe not. The experts that the state brought testified to, we cannot determine the objective factors, the objective anatomical findings, and tangible demonstrative evidence what killed him. They don't know. The state's expert, Dr. Krieger, said, well, the hypoglycemia due to the insulin administration is a strong possibility, but it's just a possibility. Why don't we know what killed Michael Cochran? Well, because they did not perform the autopsy. And by the time all these experts got the evidence, Michael Cochran's body was so decomposed that it is impossible medically to determine what killed him. And you heard the testimony of two defense experts. And you also heard the testimony of my compatriot, Dr. Piotr Kubitschek, who is the medical examiner who performs autopsies on a daily basis and who is, I would submit to you, a little bit like Matlock. He is the medical detective trying to detect what is the crime that led to the death of that particular individual. All these experts said the same thing. The cause of Michael's death is undetermined. We don't know. The state cannot answer or prove beyond a reasonable doubt the how. How did that happen? How did this murder happen? I'm not particularly good with syringes, but, well, we'll come to that. The state wants you to believe that there was an insulin shot injected into Michael that killed him. But then the state also tells you that it could have been more than one insulin shot, because when Michael arrived at the hospital, his sugar level was 21. The experts told you that it's impossible to have that type of sugar level without being pretty much continuously shot with insulin. So how did that happen? Well, let's follow the state's theory. This cold-blooded killer is planning a murder of her husband with the insulin shot. In that regard, she is calling her friend, Miss Davis, asking for insulin on the day of the injection of that insulin. I might just as well have asked for a gun, might just as well have asked for a murder weapon. Jennifer, I'm trying to kill my husband later today. I need the insulin, and I'm trying to kill him with insulin. I need you to bring me some insulin. Is that the action of a planning cold-blooded killer? She would get that insulin ahead of time, not on the day of the murder, and involve two witnesses against her right there and then, who came here to court as predicted and testified that, they gave her the insulin. And then, how on earth did she inject that insulin into Michael? Well, let's look at these facts. Did she approach Michael from the front when he was facing her in the kitchen? And if she had the insulin injection in her hand, wouldn't he have the time to react and say, what is going on? Let's assume for a moment. Then she approaches him from the back when he's standing in the kitchen, and she jabs him either in his back or his rear end. Well, she has to have a couple of seconds to inject this insulin in him. Basic human reaction would be to turn around and face the assailant, be it his wife or be it some cold-blooded killer, a stranger. She wouldn't even have time to plunge in insulin into his body without him turning around. And he's an athlete. He's this huge guy. And here is his 5'1" or 5'2" wife who's injecting him with insulin, and he doesn't react. That's why I said it didn't happen in silence. My first reaction would be, what on earth are you doing, woman? Or whatever he calls her. What are you doing? And then somehow he drops there in a fetal position in the kitchen. Oh, that didn't happen that way. Of course it didn't. So now you heard the evidence from at least 4 or 5 witnesses that this type of insulin acts in a delayed way. 10 minutes, 15 minutes, up to half an hour. If I'm jabbed, even by my dearest wife or by somebody else with a substance, and if she is silent, that's one thing. And if she tells me, this is for you, you son of a gun, I hate your guts, whatnot, here it is, I'm killing you, I would have 10 to 15 minutes, maybe to 20 minutes, to 30 minutes, to call 911, to run to the hospital. I told you it was 7 miles from the hospital. He would have been in the, I know it's February, but he would have been in that hospital sooner than you can say hello, sooner than you can slap a tick. He would have been in that hospital asking for help, an immediate sugar reaction or sugar injection to bring that insulin level to some normalcy. He wouldn't have taken it in silence. He wouldn't have just dropped down on the floor. So how did it happen? Well, the state then gives you an alternative, because now they're changing their theory. That may have happened in bed. Ah, that's a novel idea. Inject him in bed, he would not have reacted? Of course he would have reacted. He would have gotten up and he would have done the same thing. He would have taken himself to the hospital. He would have called 911. He would have probably not been particularly happy with Natalie, but that doesn't mean anything. He could have saved himself. So then the state changes the theory again. That may have happened upstairs, or it may have happened on the couch. or he's injected on a couch. Well then, okay, so he doesn't get up. So who takes him into the kitchen and puts him in this fetal position? That didn't happen, ladies and gentlemen of the jury. And how do we know that? He fell in the kitchen because there was one witness, and he hit his head against the counter because there was one witness, and that was the sister of my client, who told you that she saw a dent, a fresh dent in the counter, in the kitchen counter. That's where he hit his head, and that's how he fell on the ground, on the kitchen floor. But not because some insulin injection, but because of some unknown condition that was caused or may have been caused by many, many, many different reasons. Now, then, continuing with the cold-blooded killer's action, she does not do anything but call all kinds of people to the house. Now, wait a minute. You have just decided to kill your husband. He's unconscious, let's assume, and you want him dead. Well, let him die then. Don't do anything. Or maybe put a pillow over his head and kill him. But do not tell me that you want to kill your husband and then you call 2 workers right there to bring Michael onto the couch. The sister and her husband, the state trooper and his wife, who is a medical assistant, and then Mr. Davis. Is that the action of a killer who wants to get away with murder? No. 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 And then, and again, I told you, that's the kicker. Then he dies, and she wants to hide all the evidence. She cremates him. And then all the evidence is gone. All these Dr. Kubitscheks and everybody else can look at all that evidence. No, they can't because he's cremated. That's how you, I guess, kill somebody the way the state believed it happened. But it didn't happen that way. And then the ultimate question, and the question is why? Throughout this case, the leitmotif, the state's main motif in this case was Michael didn't know anything about this business. Didn't know anything about Natalie's shenanigans, financial, the fraud, the deception, the lies. He didn't know anything about it. Well, I think that from the very first day, ladies and gentlemen of the jury, you've realized that this is not the case. But let's assume for a moment that Michael is indeed blind and doesn't know anything about millions of dollars, hundreds and thousands of dollars. He doesn't realize where all that sudden wealth came from. Doesn't know anything. And then he finally finds out. Let's assume that he finds out. And then the state tells you that he would do what? Well, the state cannot tell you. And the question is, what would he do? What would he do that would be so bad that would require Natalie Cochran to kill him? I mean, scenarios abound. You find out that your spouse is cheating the government, cheating the investors. What do you want to do? Well, you probably want to say, come on, let's get a lawyer. Let's get an accountant. Let's try to work it out. Let's call these investors. Let's try to pay the money back. Let's file for a bankruptcy. Let's maybe even talk to a friendly prosecutor in Raleigh County maybe you will have to do a little bit of time, but not run to the federal government and complain. What, was he gonna kill her? Is there any evidence that she launched this preemptive strike against him because he was gonna kill her, or that he was gonna do something to her, divorce her? What? What would be her motive to kill him? Why? She may have been afraid that he would be mad, but to kill him, to eliminate him from what? From doing what? From going to the federal government? From complaining that my image is so tarnished now in the community that I want to divorce you and you will be penniless and all of that? There's no evidence of that, ladies and gentlemen of the jury. What triggered this murder? The state cannot answer that question. But if you had any doubts about Michael being involved in this scheme, and if you believe that he was, then the state's entire case collapses. Because she, Natalie Cochran, would have no reason to kill him, because he, Michael Cochran, was as involved in this conspiracy as she was. And how do we know it? Well, he was working on these contracts daily, on these federal contracts daily. Even when he was hunting with his little son, he had a contract that he was working on. He was working on the contracts when they were in bed. And I'm not talking about anything sexual here. I'm talking about family. She's watching the TV. He is working on the contracts. Their little son with them, sitting between them, realizing that daddy's working on the federal contracts. He signs the checks from the company. He has access to everything, every bit of information that goes through this company, checks, contracts. He has access to all of that. And besides, is he really living on a different planet from Natalie? Ladies and gentlemen of the jury, if I suspected my wife, we are, well, unless I'm in court, we're home. We're together. We spend time together. We communicate. Wouldn't I ask my wife, honey, where is all this money coming from? All of a sudden, I'm not working. I'm this computer tech guy. You're not working. All of a sudden, we're buying 2 boats. Well, the investors, yeah, but now we have 3 houses. Now, we just got back from Paris. Ladies and gentlemen of the jury, you've heard the evidence of incredible wealth, incredible injection, maybe that's a bad word, injection of wealth that Mr. and Mrs. Cochran had in 2018, 2019, maybe even 2017. And that came from the investors. And the investors dealt with Michael individually, just like his parents. They gave him some $44,000. He knew that there were no contracts. What contracts were they? What contracts were there? He didn't have a clue about some of the business, I'm sure. But he had deep, profound knowledge of how much people invested, who was going to get paid for what, federal contracts. He had deep, profound knowledge of it. I'm sure there were some aspects of this business that he may not even know about. And I'm sure that Natalie was involved in this. But she is not here on trial for fraud. She's here on trial for murder. Well, let's look at the state's case. And mind you, the state has a very heavy burden, and the burden of proof, beyond a reasonable doubt. Well, the state brought the evidence of The pilot who says, well, the flight was canceled. Okay. The banker turned mind reader. He had an idea why the flight was canceled. But of course, he didn't. He is mad at Natalie because he had to do all that research for the company and didn't get paid for it, I'm sure. And for him, time is money. So they didn't fly to Lynchburg. Well, Natalie went to a doctor. She was sick. I think that the state attributes all these nefarious things to her, but isn't it just plain obvious from Dr. Halsey's testimony that she was sick? She was sick on Friday and she was sick on Saturday. And what did he give her? He gave her a steroid shot that increases blood sugar. So she's calling her friend, Miss Davis, to get her some insulin to maybe level off the sugar, blood sugar. What's so unusual about it? No, it's nothing unusual about it because she, Natalie Cochran, had a long-standing relationship with the Davises, who had a misfortune, tragic misfortune of having a child who was diabetic. And Mrs. Davis came here and told you, no, Natalie never had any insulin. Oh, really? But then when we confronted her with the pharmacy records, she said, oh yeah, Natalie could pick up the insulin, but she was bringing it home. Well, what if you weren't home? Yeah, she doesn't explain it. Natalie could keep it at home. That was nothing unusual about Natalie having insulin. And you know what? The state wants you to believe that this insulin, that bottle of insulin that was found, was the weapon, the murder weapon. That somehow it was punctured and she kept that bottle as some kind of sick souvenir of the murder. Is that what the state telling you? I submit to you, ladies and gentlemen of the jury, if you look all you need to look at is this humolog that we introduced in the exhibit as an exhibit. I'll submit to you that a blind fool would tell you that this bottle is full. This bottle is full. There is nothing in this bottle that has been taken. There's no bubble, no nothing. The bottle is full. I suspect I know what happened, why there's a puncture. All these FBI gentlemen got that bottle and maybe had taken a little sample of what to determine what it is. That may be the puncture. But otherwise, the bottle is full. We're not going to sit here and speculate. They find a vial of insulin that is full 4 months after the demise of Michael Cochran. And then, that's part of their evidence. Remember Mr. Bledsoe telling you at the end when we finally pressed him, is there any evidence? Is there any evidence that the bottle that you have was the murder weapon? And the answer was no. And ladies and gentlemen of the jury, the lifelong condemnation of this woman versus complete exoneration is at stake. The stigma of conviction for murder versus letting her go free is teetering in the balance, and the state has the audacity to come here with an item that is not the evidence, and they're trying to tell you to convict this woman of murder based on something that is not the evidence. Is that the case? That the state has the audacity to bring before you? Well, let's look further. Chris Davis and at least one other witness, Mr. Treadway, and Penny Lowry, knew that Michael Cochran was taking all those steroids. Whatever, steroids maybe. Maybe they were steroids. Maybe they were not steroids. Maybe they were anabolics. We don't know. Michael was taking substances by the fistfuls. And they can say that, oh, we have isolated one little vial, and that was some hormonal thing from Mexico. No, ladies and gentlemen of the jury. He had a cabinet full of medications. He had a cabinet full of that away from the family, away from the cabinet for our place where the family stored the medication. He was getting this stuff online. He had the United States Postal Service box where he would get all that stuff. And I submit to you that this was not some one deal Mexico thing. And there's nothing wrong about Mexico. This was, however, the problem. He was getting substances that were not approved by the American government, by the the Food and Drug Administration. He was getting substances that were going to increase his physique, his appearance. But my God, they could have done some serious damage and probably did some serious damage. One of them was not even for human consumption, as the children told you. There was just a sample of what Michael Cochran was taking. And what he was not taking was the medication that was prescribed to him by the physicians. And yes, he had all kinds of conditions for which he had the medications. He had Keppra, he had all kinds of serious medications which he didn't take because he believed that all the doctors were quacks. He believed that they were not the people to be trusted. Chris Davis and Mr. Treadway and Penny Lowry tell him, you have to stop this stuff. You really cannot do this. And what does he tell Penny Lowry? She testifies. He said, "Oh, retarded Penny. What do you know? I'm gonna do whatever I want to." The state makes a big deal out of Michael not being taken to the hospital. But you have witness after witness who told you that Michael not only believed that the doctors were quacks, but he hated going to the hospital. He vowed to kill somebody if he's ever awakened in a hospital. And why? Because he considered this a waste of time. Now, he had all kinds of problems that he went to the hospital with. And within the last 3 months of his life, he went to the hospital 3 times. October 31st. And then he stayed there for a day. I told him he had all kinds of problems. Then he went back to the hospital with pretty much the same conditions that he had now and stayed there for 5 days. And then he came out. You heard throughout this trial that Michael had convulsions, seizure-like activity. He probably had epilepsy. The doctors told you that. He had a brain mass that was later modified into the brain swelling, encephalopathy. Ladies and gentlemen of the jury, those are serious conditions. They are not to be laughed at. Those are very serious conditions. He retained urine. He had an enlarged heart. He had an acute respiratory failure. He couldn't even breathe because he had a chronic sinusitis. nobody is here to desecrate or dishonor his life. He died much too prematurely. He died at the age of 38 years. Not for a moment should you think that the defense is taking his death lightly. No. It's a horrible tragedy, but a tragedy, not a murder. It's a tragedy, ladies and gentlemen of the jury. But with all these conditions, Michael was still doing what Michael was doing, taking supplements, anabolics, substances that God only knows where they came from and who approved them. And he was a ticking bomb. How do we know that? Well, after his second stay in a hospital, at least 3 witnesses told us that Michael's health has deteriorated to the point where Michael was not the same guy. When he was Michael at his best, he was generous, gregarious, going to parties, participating in tough man competitions, lived life to the fullest. He was focused. After his second stay in a hospital, Michael could not find his car in a parking lot. Forget that. That happens to me quite frequently. But that was just one symptom. He could not fix a light fixture with Mr. Davis. He felt confused. The children testified he had constant headaches. He was irritable. He didn't know where he was. Mr. Treadway came here and testified, Michael hated going to Panera Bread with a passion. He hated the restaurant completely. And I know that this is not a case about Panera Bread. But if I hate a restaurant, I'm not going to set foot there. And yet Michael went there and could not even recognize the fact that Mr. Treadway was wearing the same hat that he's been wearing for years. He was confused. There was something going on in his head that made him go where he would never go, and that made him forget who his friend was, really. Now, the state brought before you those 2 FBI agents who, again, could not contribute anything scientific except for that bottle. And the state closed the case with 2 law enforcement officers who are here today. Have you ever seen a more shoddy investigation that took place in this case? They never talked to the children. And I know that the state will say, oh, this was not that important. It was important. The children's testimony was riveting in this case, and I'll come back to that in a second. They did not even check what kind of medication this man was using. And for that matter, they have no clue about Natalie Cochran's medication. And, they tried to convict her in part because she lied about her cancer. Oh, that's a low blow. First of all, we have absolutely no evidence that she did not have cancer. We have the evidence that she was going to seek help from the Cleveland Clinic, from Duke, from the doctors, wherever she could. And knowing our medical system in this country, It's not that you're going to walk into the Cleveland Clinic and you get treatment the same day. You have to have insurance. You have to have all kinds of, you have to go through all kinds of hoops to be seen by a specialist. And maybe when she told somebody, yeah, I have cancer, leave me alone, because she maybe didn't want to discuss her health with somebody, maybe in reality she was checking out whether she had cancer and went to all kinds of doctors and clinics to obtain that health. And the state believes, oh, she lied because she told you that she had cancer. The officers ignored the federal investigation completely. And in the federal investigation, in the indictment, in the forfeiture proceedings, in the federal case, it's the Cochrans who are responsible for the Ponzi scheme. But the indictment didn't come until September of 2019, and Michael was dead. I submit to you that the federal government was investigating them both. They can come here and say, well, I saw some cases where the couples were not investigated together. That's baloney. The federal government investigated them both and would have indicted Michael as quickly as they indicted Natalie for the same offenses, because Michael was involved in this Ponzi scheme up to his eyeballs. Now, let's see what evidence the defendant presented. Remember Nurse Holly, if I pronounce it correctly, Holly, yes, who said that she was at hospice. And what did she observe? Natalie Cochran was with her husband for the last 5 days and held his hand when he passed away. There's evidence that Natalie Cochran got into a car with Mr. Davis. Well, the state said, oh no, she didn't drive him to the hospital. Well, she didn't drive him, but she was a passenger in that vehicle driven by Mr. Davis. She didn't drive him because she was too distraught over his condition, but she still got into the car and held his hand. Is that the cold-blooded killer? She also testified that Natalie Cochran was a go-to woman, and I think that she may have used that phrase, or maybe I have used that phrase, when it came to the emergency situations involving Mr. and Mrs. Davis's child. So Natalie Cochran would have to have insulin. You don't treat insulin with a water pill, for God's sake. You have to have insulin to treat it. And if she was a go-to woman, she must have had insulin to treat the Davis's child. So there should be no surprise again that she had insulin in her possession. Mr. Treadway didn't want to talk to the police because he believed they were dishonest crooks. And he somehow, by the way, he got scammed financially. So he had absolutely no reason to be friendly to Natalie Cochran and testify on her behalf. Similarly to all these other witnesses, even her sister got scammed to the tune of about 50 grand. And yet she came and testified for her sister. What did Treadway tell you? Well, Michael was confused. Michael wasn't the same guy that he had been before. And then Penny Lowry, the retarded Penny, as Michael called her. She told you not only about that fresh dent in the kitchen counter, but Michael wanted to pay her back what she owed on the contract. Michael wanted to pay her back. Michael was dealing and wheeling with the money from the investors. He knew about it. She told you, again, the same story, that Michael refused to go to the hospital because he was going to kill somebody if he went back to the hospital and woke up there. And we have all these discussions between 5 or 6 people after Michael collapsed in the kitchen. And then I told you that the children testified in a riveting way. And you're gonna tell us, well, the state probably will tell you they're coached, or they were somehow not truthful. Two tragic figures, two children who were young enough to be taken care of by father and mother, and old enough to know what was going on around their house. Nikki testified here unequivocally that her father had headaches, he was confused, had a brain fog, was agitated. In a true, genuine, heartfelt way, she told you that he may not have been as loving towards her as he was towards their son. Michael had a heart-to-heart with her shortly before he died, and her impression was that her father felt it coming. And what was it? It was death, ladies and gentlemen of the jury. Michael felt it coming, and he had this heart-to-heart conversation with her, which she considered heartrending, and which we would consider his farewell to life, because he knew that there was something irreversibly wrong with him. The MAC, their son, testified too. Dad worked on the contracts all the time, even when hunting, even in bed. And he testified about their lifestyle. He testified about the supplements, the injections, the dropper, the stuff from Mexico, as he called it. Stuff that wasn't for human consumption. He remembered it all. He testified about his father's anger, his father's combativeness, his father's confusion. Now, I want to talk to you very briefly about, before I do that, there was also a brief mention of nootropics, a medicine that came from some shady, well, maybe not shady, I shouldn't say that, places that usually would not be available in your local friendly pharmacy. That was the smart drugs that Michael was receiving at his USPS, United States Postal Service box. These were the cognitive enhancers, memory enhancers, stimulants. Michael was perhaps a man's man, and he would not admit to any weakness. He was seeking desperately to look great, to be this, I don't know, alpha male, whatever you call it, to be this great, maybe bodybuilder, maybe an athlete. And yet, in all of this, he didn't follow the advice of those who should have given him the advice and who he should have listened to, and instead did his on his own. Now, I want to return for a second to the experts who testified in this case. Let's start with Dr. Kubitschek. All of these experts, by the way, had a number of autopsies that performed. But who was in the best position to tell you about the autopsies? Who was in the best position? Well, of course, it was Dr. Kubitschek. He performed the autopsy the earliest. And with all the help of the state resources, and relatively early in the game, when the body was not perhaps yet decomposed to the point that nobody could recognize the organs anymore. He told you that the cause and manner of death was undetermined. Then there was Dr. Howley, who was not necessarily an expert, but he told you a couple of nice things. One is about, of course, about Natalie being sick, but he also said something about tablets, the pills, and the state jumped on it. And now the state submitted another theory that maybe Michael was killed by Natalie with pills. For that matter, the state is bringing another theory now that maybe she killed him with the benzos. You heard about the benzos. Now the state says maybe there were 2 shots of insulin or maybe more. Now the state tells you she killed him in the kitchen. Now she killed him in the bedroom. Now she killed him with the prednisone, maybe. And then maybe any other substance. And the state will stand up at the end and tell you that whatever I tell you is a bunch of nonsense. But, ladies and gentlemen, you've listened to the evidence. If the state stuck to its theory that there was 1 insulin shot, I could buy it. But now the state quietly is telling you, well, we're not telling you that the evidence suggests that the defendant killed her husband with insulin. There may have been pills, there may have been benzos. They're intimating this because they don't have any direct evidence, to which they immediately admitted, but they don't have any circumstantial evidence that fits either. Now, you had Dr. Dragovich, who told you maybe one very important thing, and that is that the decomposition of the body caused the inability of any doctor, for that matter, to assess objective factors, objective anatomical factors, and the findings of any type of specific, concrete reasons for Michael's death. That is impossible. Dr. Uribe believed that there was an insulin shot, but this was just an assumption. It was kind of a bridge to the unknown, and I think that was his phrase. It was just an opinion. Dr. Krieger said, well, we've excluded maybe all the other options, but it's a definite maybe, as we call it. It's a definite maybe. Maybe there was an insulin shot, but we don't really have all that information upon which we can construe our theory. And then Dr. Banerjee came here, and she said, we don't know. She's our expert. Maybe you expected her to say, oh yeah, that was an insulin shot that was responsible. That was some other reason. She didn't say that. She testified like 4 other experts that we really don't know. But there are other possibilities. There was something wrong with Michael's pancreas. Remember that? He may have had pancreatic tumor. He obviously had an enlarged heart. Arrhythmia. Maybe there was something wrong. Maybe that was the reason. The tests were not done on any C-peptide insulin. No meaningful diagnosis from the sliders that were obtained or that weren't obtained. Could have OD'd on benzos. We don't know. Benzo overdose, maybe poisoning. Hypoglycemia equals death. Well, all of that. And then, of course, there are other reasons. Medication, alcohol, unexplained medications, liver disease, sepsis, surgeries, immune system, All of this could be taken into account in Michael's death, but the state stubbornly believes that Michael's death was caused by that one insulin shot, which they, by the way, changed and modified to maybe 2 or 3 on all these versions. It's impossible, ladies and gentlemen of the jury. Now, the state also brings a theory of maybe there's this voluntary manslaughter, that just because she didn't take him to the hospital. Now, I submit to you that not taking Michael to the hospital was not done over the period of days. It was a matter of hours. It was a matter of discussing Michael's preferences and will, whether he was going to go to the hospital, whether he wanted to go to the hospital, and what was necessary. We had several people in that house who could have decided. Finally, it was decided that Michael was going to the hospital because he was not waking up. Yes, it took some time, but there was always the hope that he would wake up in his own home, surrounded by family and friends, and everything would be fine. After several hours, yes, it became necessary to take him to the hospital. But that's all. Now, ladies and gentlemen of the jury, I told you at the very beginning of this case that this is a complex case. This is a case that involves medical, banking, scientific, maybe pharmaceutical, maybe business evidence and information. There are aspects of federal litigation here. And you've heard it all. But distilled to its essence, this case really involves the state's attempt to equate the federal prosecution and conviction for dishonesty and fraud with murder. The state says she is a fraud, therefore she is a murderer. She is a cold-blooded murderer because she is a cheat. That's what the state is telling you. But the state cannot prove, certainly not beyond any reasonable doubt, the what caused Michael's death, the how did that happen, and why it happened. And so at the end of this case, I will tell you that the state's attempt to equate the fraud with murder is like trying to squeeze a square peg into a round hole. And if that one peg didn't fit, then the state switched the theory, and let's see if another peg that is still square will fit into that hole. Oh no, it won't. Well, then we'll switch to another theory. Maybe benzos, maybe two shots of insulin, and it still doesn't fit. Ladies and gentlemen of the jury, the state will have the last word. In the criminal process, I will sit down and I will not address you again. My esteemed colleagues and friends will get up and tell you that whatever I told you is nonsense. They will give you the spin on the facts and tell you that's the way it is. But I heard a statement once that, and of course, when you go to the jury room, since they spoke last, you will have their words in your mind, in your memory more than mine, than my words. But I heard a statement once that It's not the one who speaks last, or trust, not the one who speaks last, but who speaks the truth. We have no reason to come here and hide anything from you, ladies and gentlemen of the jury. Ms. Cochran should not be perhaps invited home for you to have dinner with her on Sunday. I told you that. She is committed crimes of fraud, crimes of mail fraud, crimes of dishonesty, but that doesn't make her a murderer. And if you cannot answer these three questions, what, how, and first of all and foremost, why, then the state fails to prove its case beyond a reasonable doubt. And that's why we're asking you to find her not guilty.
A reply, Ms. Akron.
No, it's back to me. You are so close to listening to all the stuff. Be silent on this side, and then you will take over. On behalf of the prosecutors, excuse me, in fact, of the prosecuting attorney's office, the investigators, we thank you for your time, your effort, your attention, your sacrifice. Without you, this system cannot work. Can I touch your equipment? I should have asked. Do you need to hit this? Sure. I can make duck shadows on the wall while we get this going. Pointless maker. Okay. Yeah, I'll talk about something else. I'd like to talk with you about two numbers. And the first one is this one. 0. The defense is right. We're going to tell you that what you just heard is a lot of nonsense. And the reason why it's nonsense is the defense has no credible evidence to back up any of their theories as to why the state is wrong. Let's start out with Michael Cochran himself. They have a very schizophrenic approach to Michael Cochran. One theory of the defense is he was this macho, bodybuilding, fit guy, athlete, Jeep pulling, super stud guy. That's one theory. Now they have some evidence that he was very concerned about his fitness, very concerned about his appearance. We would agree with that. But did that lead to his death? Zero evidence to support that. On the other side, oh my gosh, the guy was a ticking time bomb. The defense words, a ticking time bomb. He was so sickly. He was essentially a guy with 1 foot in the grave and 1 foot on a banana peel. They don't really have any evidence of that either. He was just a normal 38-year-old healthy male. And a good guy by all accounts. So the hospitalizations that they've relied upon to tell you how sickly this man was, where did most of the information come from that? Medical records. Who provided histories for that? The defendant. The defendant told the doctors all of these things about Michael Cochran. It didn't come from other reliable sources. It came from a very unreliable source, her. So his suspected brain mass, his suspected convulsions, his suspected all of these problems, there was no diagnosis of any of those things. They were suspected. And they were suspected because she told them to suspect that stuff. but there was never a diagnosis. Even their own experts confirmed that. There are other witnesses. The fact that the Davises talked to a nurse to have Natalie Cochran, their emergency contact, that's not the same thing as authorizing treatment by Natalie Cochran of any child. There's zero evidence of that. There is evidence on the other side. The Davises told you they never gave the defendant insulin for the benefit of their child. Never. Both Davises told you that. As recently as yesterday, the defense was still putting that theory out there for you to consider. There's no evidence to support that. Zero. Mr. Treadway's testimony was Mr. Treadway's testimony. This is a guy that didn't want to help the police. Even though his best friend was dead, he wouldn't talk to him. And he had some newspaper article he said gave him justification for that. That's on him. Treadway's got to live with that. But he didn't bring anything of substance to this case, did he? No. The two children that testified, they are tragic figures. They have had a terrible 6 years. They lost their dad. For the time being, they've lost their mom. But they were little kids. And their testimony had a certain ring to it. They both picked up on the same word, agitated. That's an unusual word. Rolling back time 6 years, think that the oldest was 20. She was 14 at the time. And that's how she's going to describe her dad the last few weeks of his life, the word agitated. Her brother, the same word, and he was younger than her. There's something odd about that. The state believes that they sincerely believe their recollection. But does it make sense? Would kids that age really be that involved in their parents' business? Would they? Well, it's possible, but that's not very likely. The defense experts, nice people, very sincere, but they're in a little silo. If those forensic pathologists can't cut on a dead body and come up with a smoking gun reason, then their opinion was they won't give you a cause of death or a manner of death, even though Dr. Banerjee said, oh no, we don't do this in darkness. We look at all the facts. We look at all the circumstances. And the autopsy is just a part of the process of determining these things. But was it? Did she have any facts that were right at all? She had a few, but not many. And in her own report, she said, if other information is brought to my attention, I reserve the right to change my opinion. Well, she had a bunch of other information, but she still wouldn't change her opinion. Why not? That's just her mindset. Did she have any experience in insulin cases? This was her first case, her first one. Dr. Drakovich, apparently he didn't have any insulin experience either. Now, the defense told you that the state has just gone all over the lot with its theories. Is that your recollection of the evidence? Did you hear any state witnesses say there was one injection of insulin? No. Did you say multiple? Because we don't know. But there are some things that we do know. Now let's talk a little bit about how that balances out what the defense just told you. There's a lot of circumstances that need your consideration. First of all, this is a trained pharmacist, a pharmacist who knows about all sorts of medication the impact of the medication, the dosage of medication. Beyond that, this defendant held herself out as a diabetes specialist. A diabetes specialist. That's another circumstantial piece of evidence to keep in your mind. On February 6th of 2019, on the basis of a supposed counterbalance to her cancer treatment, she needs to borrow a bottle of insulin. Another circumstance that needs to be held in the back of your mind. Because on that day, they were supposed to fly to the Bank of America. And yes, there is a merger with the federal case and this case, and that's where the merger takes place. You heard Trooper Heinzman discuss all of the things that the defendant had told her investors about the money that was supposed to be coming in, the money that was going to be coming in, the money that was almost going to come in, and it never did. Who else did she tell that to? Michael Cochran. So when the defense says, oh, he was up to his eyeballs in this, was he? Does the evidence support that? They have zero evidence to support that theory. Zero evidence. He did live a lavish lifestyle. But if he thought that the money was there for good cause and that the business was just supporting that lifestyle, was there anything wrong with that? Of course not. But this was a person who ran a Ponzi scheme. And the one thing you can count on for people that run Ponzi schemes is they will do whatever they can to keep it going. Is that what she did? That's exactly what she did. She was still shucking and jiving after Michael Cochran died. Right up until they executed the search warrant, she was doing ordinary business, selling the non-existent contracts, trying to get people to invest. So there is zero evidence that Michael Cochran was up to his eyeballs in this, but this defendant was up to her eyeballs and over her head in this fraud scheme by their own admission. Second number. $21. That's a big number. And that's the number we're going to rely on to convince you beyond a reasonable doubt that this defendant killed Michael Cochran. That number was the number of his blood glucose level at Raleigh General Hospital at 8:30, the day of his collapse. Now, unlike the defense witnesses, the state witnesses were unified and very clear as to what caused that 21 number. Dr. Krieger had 13 likely causes of low blood sugar, hypoglycemia. She eliminated all but insulin. And she's got a good reason for all of them. You heard her testimony. All of those were potentially valid causes of the condition that led to the brain swelling, that led to the death of Michael Cochran. All of them. But she eliminated by logic and by her scientific skills and experience in insulin cases that it had to come from insulin. Dr. Uribe, another experienced insulin investigator. Both of those two were involved in the Clarksburg VA murder cases where a nurse was killing veterans with insulin. Those two were the government's star witnesses. They know what they're talking about when it comes to insulin. And it comes to insulin killing people. That's what they do. So that 21 was never overcome by a single shred of credible evidence by the defense. Not once. No one's told you from the state that there were single injections, multiple injections? We don't know the answer to that. We do know that Michael Cochran's death was caused by insulin and reducing his blood sugar to a fatal level, and the resulting changes in his brain killed that man. Circumstantial evidence is the basis of this case, and let's get this a nice, straightforward example of what that is. It's January in Raleigh County. You look outside your window and you see frost on your neighbor's truck, frost on the ground. Stars are out, moon may be out. You go to bed. You wake up the next morning and there's 8 inches of snow on top of the truck and on top of your grass. Did you see it snow? No. Did it snow? You absolutely know it did. That's circumstantial evidence. Ladies and gentlemen, the state of West Virginia has dumped a blizzard of circumstantial evidence on this defendant. Until today, 2 weeks in an American courtroom, and until today, you never heard the word justice. Well, do justice for Michael Cochran. Find this defendant guilty of first-degree murder, because that's exactly what she did. Thank you.
Members of the jury, you have now reached the final stage of the trial. This is the point where I would ordinarily release the alternate jurors and send the regular jurors to the jury room to deliberate upon your verdict. I see that the time is almost 15 till 5. Ordinarily, I would close out the day at this time, as you know, and send you home for a nice dinner and watching TV and then going to bed. However, you folks are in the catbird seats. You are the judges of the facts, and you can tell me at this juncture what you want to do. And if you would like to retire now to deliberate upon the verdict, that would be fine. We will stay here and we will wait until you reach a verdict. However, if you would like to start afresh tomorrow so that you've gotten a good night's sleep and you can think a little more clearly, you can come back at 9 o'clock at the regular time and commence your deliberations then. We have talked among the attorneys about engaging in a powwow among themselves, and I would urge you to engage in a powwow among yourselves and see if you can reach some unanimity on what to do. Again, you can stay this evening and deliberate, or you can come back tomorrow. Perhaps you can confer for a moment or so and decide what you all would like to do. I'm hearing tomorrow. All right. That's the decision I would make. But again, I'm not you guys. I'm not going to release the 2 alternate jurors. I'll ask you folks to come back with us because I've been at this game a long time, and I know that anything can happen with jurors in terms of sickness and accidents and that sort of thing. We've done really well, and you folks have been great. You've been here promptly. You have watched and considered everything. I've been sneaking looks at you, and I noticed that you have done very well in terms of paying attention to the evidence and the proceedings. So I will ask all of you to come back tomorrow. Even though we have reached the deliberation phase, you still can't talk about the case because you haven't started your deliberations. And I'll tell you in the morning that you all need to be together. You all need to discuss the case together and not break up out into factions or have folks wander off. You need to talk about this together and share your concerns and share the issues that you have arrived at. So that will be to start tomorrow. I'll tell you about selecting a jury foreperson in the morning, and we will get down to business. So if you could all be back in your jury room at a little bit before 9. Do not discuss the case among yourselves. You're not at the deliberation phase yet. Do not talk about it to anyone else. Don't watch TV about it. Don't do any research online or see anything online. And please don't read anything in the newspaper about this case. Have a good evening, and I'll see you folks at 9 o'clock in the morning. You may follow the bailiff.
Oh, wow, that's gonna complicate the schedule, but we'll talk about the schedule at the end of the day. But what we're gonna do tomorrow, it's gonna be a long day tomorrow, but we're gonna be here for it.
All right, are there any matters we need to discuss at this time out of the presence of the jury?
Nothing from the defense, Your Honor. Thank you.
All right, thank you very much. I appreciate your cooperation in this trial. We will return at 9 a.m. in the morning and see what develops. Court is.
All right. Yeah, I'm sorry. We'll try not to spoil it, but if after 1 p.m. your time there is a verdict, we'll try to I'll try to DM you, and yeah. So now the thing that I was thinking, right? Tomorrow is going to be a complicated day because we have this one that's going to be on deliberations. I think by what see tomorrow, case one, I'm just doing a very small like scheduled thing for tomorrow, and then I'm probably going to end up the stream as well. So what is going to happen is at 7:30 in the morning the new trial is supposed to start. So but that's not a problem. We can always catch up, so it's not an issue. So my plan is we start at 9 a.m. with this trial to see what the judge says in terms of instructions and whatever happens in this trial, and then we'll start our clock for the deliberations. Okay, while we are on verdict watch, because I'm sure we're going to be on verdict watch for a couple of hours, we will, if the new court will be up, because the jury has been selected, the jury has been seated on the new trial, and there is going to be a live stream by our friends in LNC. So we will start the closings and everything from the moment that this jury in the Natalie Cochran starts deliberating. Okay, we'll start the openings and the new trial. As soon as there's a verdict, we'll pause. I'll tell that there is a verdict just to make a split on the stream. We'll do the verdict and we'll do whatever is needed to do in this trial. And then as soon as that, I do another split, and then we go back to calling case trial. So that's how tomorrow is going to work. I've got the thumbnail ready for a split trial, so people know for the future reference that the openings of Colin and the deliberation verdict watch of Natalie is in that same stream. So that's how we're going to be working things tomorrow. I am very, very, very close. I am very, very close of being able to do a tally up on the screen. I just need to finalize to understand how this works. So I was able to extend my screen into 3. So I have the second display, which is a TV that I've connected, and now I have my iPad connected to the computer, which is also an extendable. So set your alarms early because we have an early day in the morning. I mean, in terms, I don't want to start the openings for the new case because the new case this start at 8:30 in the morning Eastern. This is all Eastern, by the way. It does start at 8:30 Eastern. But I don't want to start openings and then stop openings, go back to Natalie, and then go carry on the openings. So my idea is we'll start the stream at the normal time, 8:45, so we can have a bit of a chit chat in the morning, and just to say what happened in terms of news in true crime and whatnot, and then we'll go into Natalie first, and then we'll as soon as they start deliberating and they finish all that evidence and everything, we'll go to Colin because I'm sure he's going to be up. And then as soon as there's a verdict, we'll come back to Natalie. I feel that is a little bit more simpler if that's a word, to do that way than rather be bouncing backwards and forward like a ping pong ball. At least that's my idea. So I'm gonna set up the stream for tomorrow after I finish this one because I do need to do a couple more bets. But that is the plan for tomorrow. Hopefully everything goes correctly like I am planning, but things never go because courts have different ideas than I do. In terms of the tally, I think I'm gonna leave it until tomorrow morning, and then after we moved everything, and then I can set up things and I can try again to try to figure it out, the tally. I am almost there. I am like 99.5% done loading. I only needed the last few things to understand how I can do the tally and use it on the stream. So, but I'm almost there. It's a progress. I've been trying to rack my brain out, but I think my brain is starting to get a little bit tired. It has been a long day. It's been over 8 hours. So it has been an awesome day. I'm not gonna lie. I love today. I love every day. Every day is amazing with you guys to spend time here. But today I think it has been a little bit more special because of the support I've got from you guys and from Vamos about the 20 memberships that was given today. That was amazing. Will be forever a date that I will remember because I have a weird problem that I remember dates. That's like big things happen and whatever dates happen. But that is gonna be a date that's the channel is gonna remember for a very, very long time to come. I'm gonna end the stream here. That's the plan for tomorrow. We're gonna do both. We're gonna be okay. It is gonna be a day, and as well because yes, and Paula is back. I love having my peeps back and all my friends together, and it's just very, very, very special. I'm sending you a big hug, Paula, from all over here. And yeah, so we'll do that tomorrow, 8:45 Eastern. We'll be back live. So and everyone is in green apart from Nightbot. Nightbot will be forever blue. At least, well, he doesn't really like blue anyway, so he can stay with. um so you can stay blue, it's fine. But again guys, thank you so much. And Nightbot did a clip of my thank you from yesterday. I'm gonna repeat myself. Thank you for everything that you guys do for me and just sitting here watching trial with me. This is amazing. I appreciate every single one of you, and I could not do this without you. So thank you a million for all the support, all the like buttons, the shares, and staying here all this time. I do really appreciate it from the bottom of my heart. Thank you to Nightbot for putting up with me as well. And I'll see you all tomorrow. Have a great afternoon, morning, or evening, wherever you are. And I'll see you in the morning. 10-4, and goodbye. Bye. Good night.